ಬರಬೇಕು. ಹೌದು ಸರ್, 12 ಫೈಲು ಫಸ್ಟ್ ಸಿಗಬೇಕು ನಮಗೆ. 13 ಇದೆ, 12ವರೆಗೂ ಸಿಕ್ಕಿಲ್ಲ ನಮಗೆ. ನೋಡ್ತಾ ಇರಿ. ಇಷ್ಟು ಕೊಟ್ಟನಲ್ಲ ಅವ್ರಿಗೆ. ಕಮಲ ಲಿಸ್ಟ್ ಕೊಡಿ, ನೀವು ಬಂದಾಗ ಲಿಸ್ಟ್ ಕೊಡ್ತೀನಿ. ಇವ್ರು ಫಸ್ಟ್ ಇಸ್ ಮುಗ್ದೋಗಿದ್ರೆ ಕಿತ್ಬಿಟ್ಟು ನಿಮಗೆ ಕೊಡ್ತೀನಿ. ಎಲ್ಲಿನೂ ತಗೊಂಡಿಲ್ಲ. ಕಾನ್ಫಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಮೇಡಮ್ ಮೊನ್ನೆ ಹೇಳ್ತಿದ್ರು ಅವ್ರಿಗೆ ಅಡ್ಡ ಹೇಳೋದು. ತಿರುಗಿ ಬಂತ ಜೇಮಸ್ಸೆ ಅಲ್ಲಲ್ಲ ನಿಮ್ಗೆ ಖುಷಿಯಾಗಿದ್ದೀರಿ ನೋಡಿ. 3 ಟರ್ಮ್ಸ್ ಇರ್ಲಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ.
Yes,
My lord, in charge court matter, my lord.
yes.
So, a matter of urgency is there.
What is urgency?
Because
I'm telling all the Justice Arul's roster, unless and until it is so urgent, which can't wait till vacation, will any of the
I
matters,
am
please don't
running a
mention.
search activities there in the premises.
Huh?
Search activities. More than 500 people are visiting every day. Ordinarily, our toilet facility is without. Toilet facility. Ordinarily damaged Marital, they are putting stones. I am running an institution, Milord, that's a religious institution. Every day preaching is there. The public will come and attend.
Is it a MFA?
Eh?
What is the category of the case?
Classification in
Huh?
Classification.
CPC.
CPC will not.
The injection not granted. And now
That roster is not with us.
First rebench
This is
for
not the
us.
court also.
CPC
This
roster
is
is
not
not
the
with us. And not even before the roster bench.
MFA.
MFA
ಅದು ಇಲ್ಲಲ್ಲ ಬೇರೆ ಕೋರ್ಸ್ ಇಟ್ಸ್ ನಾಟ್
Yes.
Not in charge court. Petitioner is seeking for the stay of the interim maintenance. Interim maintenance has been passed against.
When was the order passed?
It was passed on October 2020.
No. Yes.
The evidence has been started.
There's two matters,
Please come this side. I'll be going like this. Yes.
and there's two matters disposed of matters seeking for modification. The lordship has in fact imposed a condition that petitioner cannot travel beyond 3 days. My lords, that was only for that particular matter, but when I moved an application before the trial court says since there is an order by lordships, trial court rejected my application. That being the reason, my lords, I require
When was the order passed?
The order was passed on the 20th, my lords. That being the reason.
List it on Tuesday. Yes.
But it's two matters, both the matters.
Yes.
Both are 20 matters. The stay was granted subject to deposit of 50% of the amount, and for the respondent, they have deposited the amount and then admitted to take release the amount in favor of the respondent.
Tomorrow.
In charge.
What is connect? Even that connected matter will not be taken up unless and until it is urgent. What is this matter?
This is WP, my lord, 7338.
What is it?
Connected matter is on 16439 on 26/4. So kindly have this on 26/4 because the matter is going to settle. Have it on 26/4.
Please understand, court cannot take up that court matters and what will happen to this roster matters? Everybody is mentioning only those matters. Yes.
My lord, trial court directed wife to keep the child at the time of mediation.
First, before making mention, tell the court when is the order passed by the
My
trial.
lord, last week, my lord.
When did you find the,
Thereafter, I find advance of the application to the trial court for direction to her to keep the child at least during vacation. That is not entertained. Advancement application also not entertained. My submission is at least during the vacation I can meet the child.
what were you doing till the fag and filing? No, this has become a fashion in all these family matters.
No, my lord, only
Pass,
there are
file an application 1 day, 2 days, 3 days before the vacation.
No, my lord.
So some order or the other, the
No, I had
court
filed
will
2
pass.
months ago. But the application was filed
CPC.
in-
So this is matter.
Tomorrow.
Thereafter,
My lord, one for withdrawal, my lord.
it will come from this side. Yes.
Withdrawal of the. FE.
Huh?
Action was given today's date for the present to impact. Some arrangement for the vacation, because vacations have started.
No, the other learned judge has heard all the matter. He knows what are the facts of it. No, there is no time for this court to interact with the parties.
But so if my lady kindly consider some arrangement during vacation so that the father is 25.
No, if the court wants to interact, that means without interacting, there cannot be any order. Let it come after vacation. Yes.
Some arrangement during vacation for the father to meet the children.
If it is possible, the judge would have done it without interacting. No, it means without, the court has to interact and there is no time for interaction. No, the same thing. If the matter is listed also, they'll come up with the same thing. There are some difficulties. So the court, if the court interacts with the child, then the court will understand. And again, we come to the same point that there is no time for that. And you're saying that he's an autism child. No, you can wait for a month. Yes.
Application element to be made. Date was given on the 17th of February, on Friday, on Thursday last week. Not for some reason the matter did not get listed. Every vacation month, the court is awarded 50% to the father. Therefore, the rule is and vacation starts on the 12th of May. Matter will be taken up next week, sometime on 29th.
Yes. Yes. Fresh matters will come. I already instructed. Yes.
Matter of withdrawal of the judicial deposit, my lord.
Huh?
Judicial deposit, MFA. Withdrawal of the judicial
MFA.
deposit. Respondent, insurance company has preferred an appeal.
Which year is that?
2021.
2021 for withdrawal in 2025 before vacation, urgency. Let's see. Yes.
My lord,
It's kindly.
I said that
Yes.
this is going to, how can you come in between when they're all standing? Yes.
my lord, already that respondent already get attachment from the lower court against us, my lord. We filed an appeal. So kindly for moving for the stays, my lord. So we are representing the insurance company, my lord. So kindly on tomorrow,
That
25 minutes.
fresh matter
Yes, ma'am.
tomorrow. Yes.
This pertains to Court Hall 20, my lord. This is my claimant's appeal is pending before this honorable court. Insurance company has deposited the entire amount before the claims tribunal. The parties have come from UP. Records may kindly be, they have to withdraw the amount as per the award. In my claimant's appeal, records have been received for enhancement of compensation. Claimants have filed. Records are before this court. Without record, they cannot withdraw the.
Right, insurance company appeal, writ of execution, right, therefore I'm 25 matter, press matter.
Insurance company appeal, my lord, or IA for consideration of stay, my lord, fresh matter, my lord. Tomorrow or day after tomorrow, court convene.
Insurance company appeal, sir. Kindly have it.
25 matter.
25, stay.
Hmm?
Insurance company appeal. Seeking for stay.
CP 282, my lord. It was posted yesterday and your lordship had ordered us to write the written submissions with the court master. And your lordship, one more small submission. Yesterday, IA number 1, 2 and 3 were heard. Then the orders were being reserved. The council inadvertently mentioned IA number 4 instead. It was IA 1 and 2 and
For the petitioner, my lord, my written arguments have also been given.
Is that?
I'm for the petitioner. My written arguments were also given by my learned
Yes,
opponent.
yes, yes.
Grateful,
yes.
my lord.
Amount release ಗೆ application ಹಾಕೊಂಡಿದ್ದೀವಿ my lord. For release the amount.
What is the case?
MFA my lord. Yes.
Which year is MFA?
22 my lord. 22. 22.
Will you, there is no urgency, it will wait till 20, after vacation.
Disposed matter, my lord, visitation arrangements were already made. In view of this ensuing summer vacation, I'm seeking for modification because the trial judge is not sitting, my lord, the court has become vacant. There's only one district court in the entire district.
In a disposed of matter,
I'm seeking
again,
for
the court will decide because there is no officer. No. Yes.
But I'm moving for an adjournment in the serial list number 2, serial number 32. It's a specially assigned matter. Mr. Matsudan Rao is appearing for the respondent. He has been hospitalized. I have informed the other side. It may be taken up after vacation, please. List number 2, serial number 32.
Yes, at the request.
I appear for the petition.
I have informed the other
Interim
side.
order
also.
may kindly.
For the land council, for the request is made on behalf of the land council, the respondent, submitting that he is not keeping well. This is matter after vacation.
Great.
It is
Interim
32.
order may kindly.
Interim order earlier granted is extended till then. 32 you said.
Please, ma'am.
32.
In charge court my lord. Filing a stay application.
No presiding officer in the court. That is the only difficulty.
Can any, Please understand, what is that request?
I understand, my lords, because in
In a disposed of matter, because there is no officer in charge, that the High Court will pass an order.
is seeking for modification of the existing visitation.
No, your modification is, because it's a disposed of matter as on that day, how can you seek a modification in that? Because the judicial officer is not there, that's not right. Yes.
In charge court, my lord.
What is the matter?
Fresh matter, my lord. It's a MFA.
What is urgency?
It's a stay application filed, my lord. For stay the further proceedings.
For?
Stay the further proceeding
What
for.
MFA he has for stay of all further proceedings? MFAs are all.
It's a recovery petition, my lord. Yes.
He's not having
Classification
MFA
mentioned.
CPC.
It says,
On behalf of the insurance company.
Yes, my lord.
Yes.
Well,
When was it passed?
Your Lordship, is a WPGNFC. The third additional family court has has given an order that the child be given the visitation rights to the father, but the child is autistic, Your Lordship. So we're
When was that
pressing on
order
the
passed?
state. Your Lordship,
When was that order passed?
it was passed in the month of January, Your Lordship.
Then also urgency now. No urgency. Yes, next.
Malad, firstly, serial number 33, I appear for respondent. Firstly, serial number 33, I appear for respondent. Lord, petitioner counsel is here. Lord, this is the writ petition challenging the appointment of psychiatrist, my lord. Consultation of psychiatrist. The proceeding is going on. My lord, I need to file some certain objections to the petition. Kindly. There is no urgency in this, my lord.
This court will not hear any matter in this list unless and until it is urgent. All the matters will be adjourned.
Please, my lord.
As it is.
Date may be given, my lord, after
We'll
vacation.
see when the matter comes.
Please, my lord.
Call.
Kind permission.
Number 1.
Kind permission. Seal number 31, list number 2 million. Radha Jain appear for the petitioner. She is not well, kindly.
This number?
2. Seal number 31.
Other JNT.
Radha Jain. Kindly call after vacation.
Have you informed the other side?
Important.
It is submitted to the land council. The appellant is not keeping well. This is matter after vacation.
How much?
Yes.
List number 1 for orders matter, serial number 1, D. Vijay Kumar.
I am for the respond number 1, 2, 3 and 5, my lord.
My lord, I am for the appellant, my lord.
Both the appeals are pertaining to single bench only, my lord. Office has mistakenly raised the objection. The connected matter, my lord. It is also pertaining to single bench matter only.
Why is it listed today?
My lord, I am filing a memo to treat the respondents number 1, 2, 3 and 5 as LRs of the deceased respond number 4, my lord.
Where is
R4
that?
is dead, my
In
lord.
both the appeals, In my appeal also that memo is there.
R4 is the Shardama, is the mother of the deceased, my lord.
The memo is fine, stating that the respondent number 4 died on 21/6/2024. And the fourth respondent is a mother of the deceased, wife of the first respondent, and mother-in-law of the first respondent, and grandmother of the second and third respondent. It is stated that all the legal heirs of the deceased are on record. Hence, respondents 1, 2, 3 and 5 will be treated as the LRs of the deceased. Accordingly, the memo is taken on record. The appellant shall, the necessary amendments shall be carried out to the.
My lord, in the connected matter also, appellant number 4 is dead.
Appellant number?
4 is dead. Appellant number 1, 2, 3 and 5 are the LRs of the same, my lord.
Yes, next.
Serial number 2. Serial number 2. I'm appealing for the appellant, my lord. Mahesh Ramayan.
My lord, we have filed this appeal before this honorable court, being aggrieved by the judgment passed by the Motor Accident Claim Tribunal, wherein the honorable tribunal, without even providing me a fair opportunity to file my written statement and.
No, it is coming up for objections. Office objection.
My lord.
What is the office objection? Come to that.
My lord, the office objection is regarding the impute judgment, which your lordship may find at page 16, my lord. My lord, the office objection is that the date of
Order
disposal.
is dated 3rd July 2022.
My lord, that's a typographical error, my lord. It should be 3rd July 2023, my lord. It is mentioned as 3rd July 2023 in the operative portion of the judgment, my lord. It is 3rd July 2023, my lord. Due to some typographical error, it has been mentioned as 2022. If your lordship may kindly come to page number 33 and 32. It is mentioned as 3rd. My lord, the MVC petition itself is 1244 of 2023, my lord.
In how many months this appeal, this MVC is disposed of? Within 1 month?
Yes, my lord. I was not even given my chance to file my written statement and contest the matter, my lord. My lord,
Office has taken an objection. The date of disposal is shown as 3rd July 2022, whereas MVC is of MVC number 1244 of 20 is of 2023. When the MVC is of the year 2023, then the date mentioned as 3rd July 2022 appears to be a typographical mistake. Accordingly, the office are overruled. Yes.
My lord, one humble submission, my lord. The respondents have initiated execution proceedings on this impugned judgment before the honorable trial court. I'm producing a memo before your lordship. The matter is coming up on 26th of April 2025, my lord, within 3 days. Your lordship may kindly grant a stay on the proceedings of this operation of the judgment, my
Who
lord.
are you?
I am for the appellant.
I understand. Appellant is who?
I am the petitioner. I am the
Is it a motor accident claim? You are the owner of the vehicle or the insurance company?
Owner of the vehicle, my lord. My lord, what has happened is the entire petition transpires from a motor accident, incident, my lord. What has happened in the matter is the respondent number one's husband who was driving a motorcycle belonging to his friend, had colluded with the motorcycle which was driven by the appellant herein. And that is how the accident occurred, and he sustained injuries and he passed away eventually. But due to the accident, even the appellant had suffered a severe head injury, due to which he was not in a position to give instructions to his legal counsel and file his written statement. We had filed 151 application also before, along with our written statement before the honorable tribunal. But the tribunal, without considering that crucial aspect and the genuine conditions of the appellant and the respondent therein, had passed this judgment, my lord, within almost 1 month.
What is the compensation that is awarded?
14 lakh, my lord. Specifically, it is 14 lakh 46,200. My lord?
Deposit 50% of the amount.
My lord, some time may be given to me. I'll take instructions and.
That's a blanket order will not be given. This is matter on 25th.
Obliged, my lord.
Yes. Next.
Cell number 3. BC Shivanya Gowda for appellant. Prasanna DP.
For the respondent, we are trying to settle the matter. It may be a refer to Lokadal. ICC.
Yes. Refer to the Lokadal. Yes, next.
Cell number 4.
Post after service of notice.
Appearing for
What about the non-competence of office object?
Our respondent number 5 is rider of the motorcycle. Kindly, there is a dispensation.
Memo is filed. Seeking dispensation of notice to R.
Respondent number 5.
R5. Memo is taken on record.
One more submission, my lord.
And notice is dispensed with. Yes.
Cause list number 2, serial number 23. I couldn't ask before.
Huh?
I couldn't ask before. Cause list number 2 and serial number 23. 1 week
No,
time.
you can't make a mention on that. When it comes, then we can see.
Okay.
Yes, next.
Cell number 5.
Appear for appellant, my lord. Date of accident is 28/2019, my lord, correct date of accident. That was submission is made. Submission may be accepted, my lord. To date is mentioned in the judgment. Correct date is 28/2019, my lord.
Why should that be taken?
Pardon?
Court will look at the judgment, will understand. You can't say that there are two dates, one is the correct date. If that is the case, you should see clarification from the court that it's a typographical mistake. How can you make a note before this court? Is it not? If
Correct,
some
ma'am.
typographical mistake is there in the order,
Yes, ma'am.
you seek clarification from the very same court. And you will not say that what is mentioned by the court is wrong. Please take this as the date of accident. The typographical mistake with regard to the date, the petitioners should seek clarification from the trial court and the office objections or sustain. Yes, next.
Serial number 6. Take away your B.
Accident is mentioned in cast title 44/20, my lord. Every top judgment is 44/21, my lord. Discrepancy in 44/21 is correct, my lord.
Internally, it is mentioned as 44/21 only.
Yes, my lord.
The office has taken an objection as in the first page, it is mentioned as MEC number 44 of 2021. And according to the claimant is MEC 44 of 2021. This court has perused the order, and in that the number in the internal pages, it is mentioned as MEC number
44/20.
44 of 2021. Appears to be a typographical mistake. And the office objections are overruled. Next.
Serial number 7. MP Chandrachud.
Yes.
I'm filing fresh application for paper publication.
What happened to the earlier one?
That paper was closed, Your Honors.
Huh?
That Tumkur edition, Tumkur Times has been closed.
It is submitted that earlier they have sought for the paper publication in Tumkur.
Tumkur Times has been closed.
Tumkur Times, and it has been closed, and has come up with the present application. Accordingly, petition is permitted to take out notice in Karnataka Tumkur edition on yes, 3rd June and 17th June.
Much obliged.
Yes, next.
Serial number 8.
Petitioner. Lord, mother's,
Non-complaints of office objections.
Lord, there are three objections. Lord, one is I have filed the petition under Articles 226 and 227. The registry says it has to be only under 227, not 226. I cannot use. Lord, the source of power may not to issue writs is only under 226.
The papers are notified rectification of the following.
Copy has been served.
Provision of law
Yes.
to be corrected at cause title. Page 101 to 108 to be stitched in order. Copy to be served on the caveator and acknowledgement.
Copy has been served, my lord. Caveat is present. Copy has been served. I filed a memo already.
Your ladyship, I am on behalf of the respondent, the caveator in the matter.
You ready?
You're ready.
Yes.
Lord, challenge is to an order of visitation passed by the family court, granting Lord the father visitation rights from 10 a.m. to 6
Please
p.m.
come to that order.
Yes, yes. That's at page number 20.
The petition is at liberty to have custody of their both children on every second and fourth Saturday
Yes.
from 10 a.m. to 6 p.m. What is the age of the children?
15 years. My daughter is 15 years old. Son is 12 years old.
Son is?
12 years old. November 2022 was the separation. My lord, in principle, I may not have any objection to the order granting visitation except for some modifications with regard to duration, because the father claims son is not his at all.
Son is?
So he's not his son. He's an illegitimate child born through somebody else. That's the allegation made in his petition for custody. So I may not have any serious objection with regard to the visitation. No, the only objection I have is the father gives an undertaking not in 2024 to the court that he will pay the children's educational expenses and also reimburse whatever expenses, educational expenses the mother has borne through her parents. To date, my lord, does not comply with the order despite undertaking given to the court, recorded by the court, my lord. That was my only objection. Page number 24.
How can, if that's the case,
Yes.
it's not that's a different issue.
No, a father who comes before the court, my lord, seeking visitation rights must also discharge his primary obligation, my lord, like the Honorable Supreme Court has mentioned in Rajneesh versus Neha's case, the primary responsibility to pay the educational expenses rests with the father. Undertaking,
There is no urgency for this. We can see after
no,
vacation.
my only school fee is not paid. Again, school fee is due now. Page number 85, I will only take your lordship through pages, my lord.
You come before the court.
Yes.
On an IA.
Yes.
Where that is not at all the issue.
But my grievance is that the father gives an undertaking, signs the order sheet before the family court in 2024, page number 85.
Your ladyship, may I just submit that there is no.
No, when is that order passed? Or
No.
when is that undertaking before?
3rd of January 2024.
3rd January
Yes.
2024. According to you, that order is not complied with.
Yes.
What did you do from?
I filed an application, my lord, before the family court to initiate contempt proceedings against him and also to stay all further proceedings since he is not complying with his own undertaking.
What happened to that?
But that application was rejected before this order was passed.
Was it questioned?
Yeah, I'm filing a writ petition.
So when you question it,
Yes.
court will deal with that,
No,
but not in an application.
Undertaking given to the court, that, my lord, is,
So for everything we can't.
but there's a
already-
corresponding obligation.
Already you have availed the remedies that are available to you.
But there's a corresponding obligation, my lord, a person who comes before the
Understand
court.
that, but you have already filed an application for that. Court has dismissed it. When it comes before the court will decide on that. But the court cannot, no, as far as this order is concerned, there is nothing to be interfered with.
Well, kindly see page 24, my lord. I will not trouble your lordships anymore over this. Page number 24. The last 5 lines, my lord, from the bottom of the page. The respondent side submitted that the petitioner earlier has undertaken to pay the school fees of both their children, but he has not paid any fees. Respondent submitted the visitation rights of the petitioner may be considered subject to payment of school fees of their children as undertaken by him. But therefore, I'm not saying.
We'll consider this in your writ petition that is likely to be filed.
17 lakhs, my lord, is due as of today.
But still we can't interfere in this.
But my request,
Your ladyship,
beyond the scope of the writ petition.
Lord,
Number one.
Challenge-
An order where the visitation is granted, and I can understand you have not questioned that order where you have asked them to initiate the contempt proceedings.
Contempt.
That you already filed, that is dismissed, and that order, when was it dismissed according to you?
My lord,
16/11/2024.
I have filed a contempt petition before this honorable court. Contempt petition is pending.
Let that be decided independent.
Your ladyship, may I just submit that the order dated 1/3/2025, the visitation order, the impugned order, is yet not complied by the petitioner. 3 opportunities, 3 visitation dates have lapsed. 2 second Saturdays and 1 fourth Saturday. Every
So avail the remedy available to you, not in this petition. Please come.
grateful.
Lord, may I request at least 50% let them deposit, my lord.
We shouldn't.
The mother is without employment. Her parents are paying the school fee.
Why? What was she doing?
No,
When
we are-
that order comes before the court, then the court would, where is that, you have initiated contempt proceedings.
Before this honorable court, my lord, before the division bench, it's pending. I've mentioned at para 9 also. Lord, contempt would be only for punishment, my lord. For compliance, Lord,
Why you are not
It
paying-
was filed on 6/6.
Why you are not paying the maintenance?
Your ladyship, there is no undertaking. Only my willingness was recorded. I am still willing to pay.
When will you
However,
pay?
there is no order as to maintenance that has been paid. The matter is listed for deciding interim maintenance on 28th April in the family court.
You will even, where is that?
but page 85 and 87.
85?
Page 85, the penultimate paragraph. Petitioner present before the court, this is submission he makes. Page 85, my lord. The petitioner is ready to bear the expenses of his children and also reimburse the school fees paid by the mother. But page number 87, my lord.
That's it. There is no undertaking.
Page number 87.
You cannot, when something is recorded in an order, you can't afford to say that I didn't say. If you say that, you should seek clarification of this order.
Your ladyship, I bow down. However, there is no figure that has been adjudicated. That is pending adjudication in the lower court, while my interim maintenance, interim visitation has only been decided by order dated 1/3/2025. For the last 2.5 years, I have not met my children. Every delay tactic has been used by the petitioner to ensure that I do not.
Unfortunately, that is the problem. Every delay tactics will be used by both the parties.
Your ladyship, I am in due compliance in section 24 maintenance application. I am in due
much you are
compliance.
paying?
It has not been decided. There is no effective order yet. When there is an effective order, I have filed my income affidavit in the DV court, and the same will be filed in the before the learned family court as well. It is listed next week
Section 24 proceedings were initiated when?
in 2023.
So 2025 also, it is not, no order is passed in that.
No effective order has been passed. She has filed her income affidavit on the last date. In fact, it was
Right from 22 till 25, there is no contribution from the father whatsoever nature for the children.
I have paid 2.5 lakhs in the interim. However, I am completely cut off from my children. There is not even one source of contact or communication. There is no proper order that has been passed, effective order that has been passed by the learned family court. I am in due compliance. I have filed my assets and liabilities in DV court. The same will be filed before the learned family court as well. The assets and liabilities by the petitioner was filed on 1st March. It is in due process. This is an attempt, this writ petition and so on in the family court also by various applications as mentioned, is an attempt to make my visitation contingent on the maintenance.
Page 87.
They have not even placed the entire order sheet in this writ petition. The order dated 16/11/2024, vide which all these applications were dismissed, are not annexed herein.
I want to hear anything on the technical. Now I'm asking you, why your client is not paying anything to the children? You are not aware of your responsibilities, but you are very much aware of your.
Your ladyship, that is not the case, that I am not aware of the responsibilities. There has been no effective order that has been passed.
So if there is no effective, please listen to the court, then you can answer. If there is no effective order, so that means the children do not require any amount. And they are with you from 2022. You know what are the requirements. For that, you need a court's order.
I have paid 2.5 lakhs in the interim.
What is their, in which schools they are studying? What is your contribution before 2022? Will tell the court with the 2.5 lakhs which you are paying, right from 22 to 25 from the last 3 years, will the children be able to sustain, or the mother will be able to take care of them?
Your ladyship, the mother was working. The minor son, he is on full scholarship at Adventure Academy. He's skilled at football. That is why he has a full-time scholarship in the school. I have expressed my willingness to pay. However, the amount has to be adjudicated by the learned family court.
What is adjudication? When you say that I'm ready to pay the school fees, it is fine. The seat is sufficient. You don't have to be. There need not be any adjudication on that.
Your ladyship, despite the minor son being on scholarship, there is an amount of 6.5 lakhs that is being asked. Grossly exaggerated and inflated figures are being asked that requires proper adjudication by the learned family court. It is, she has asked for 6 lakhs per month as maintenance, including that of the children. In fact, the learned family court also, by the impugned order, has recorded the same thing, same aspect, that the proceedings under section 24 of the Hindu Marriage Act are pending. This application was disposed of 1/3/2025. Now on 28/4/2025, the application under section 24 is listed.
The school fees that is paid to the.
I sent the receipts. Can you see page number 87? Undertaking given by the lawyer, my lord, to the court subsequently. Page number 87. 2 undertakings given. Page number 87. Advocate for the petitioner, my lord, my learned friend, submits he will insist his party to pay the school fees. The next date, my lord, advocate for the petitioner submits his client will pay the school fees and also arrears within 2 weeks.
Your ladyship, there is no transparency with respect to the figure.
Then why did you say so? Who asked you to submit before the court all this?
This was by the erstwhile counsel. I didn't want to say that.
That's your client's. Client has engaged the advocate. Whatever he says, you say.
Great.
That is what is your client's expression.
Your ladyship, I'll be in due compliance of the law. However, my visitation is not contingent on it, and it is not in the scope of the present writ petition.
That we will decide.
Great.
What about your submission with regard to the money? What is he going to do? How many is he going to pay? How much is going to pay? Or something he should pay?
I'll seek instructions.
Ask him to immediately comply with the order, and I'll keep this pending till 26.
I'll seek
Let him
instructions.
Let him pay something and let them comply with the order immediately.
Your ladyship, may I only request that the visitation may not be made contingent like in this manner to the payment that I make.
Ask him.
Until separation, my lord, every single expense the father has borne. All we're requesting now is for school fees to be paid. Maintenance, my lord, let the family.
Your
court decide.
ladyship, until separation, I was seeing my children every day.
Look, international schools, my lord, I think.
Vacation started with the children?
Vacations, I have no communication to the children. It may start in May.
I don't have access.
I do not have access to any information, school information, circular, WhatsApp groups, nothing.
Whether the holidays have started or not.
I'll find out. Both of them.
We'll ask the father to pay the money, and if the vacation started, the visitation, first of you have not, according to them from 2022, the father has no access.
Nothing.
In respect of whatever is the order, from tomorrow till Monday, that is 28th, he will have the access with the children in the same timings, that is 10 a.m. to 6 p.m. if the vacation starts.
I will verify and make my
Otherwise, that's what
submission.
I'm saying. Otherwise, from if there are no exams, then evening from after the school hours for 4 hours, he'll have till 28th. The matter will come up on 29th and provided with all based on his instructions. Pass over, get instructions.
Very good.
Great.
Yes, next.
Stay number 9.
I'm the petitioner in this case, my lord. I'm appealing for the
With
respondent
complaints.
in this matter. My lords, what has happened is an order was passed on 17/3/2020.
You have not filed your wakalat so far.
My lords, the document was served to us only last week.
I received the copy
On
only
16th?
around 8:15 in the night, my lord, and that particular time only around 9:15 I have given I've
And-
served the copy of summons and the copy
File
of.
your wakalat still.
My lords, I'm filing my wakalat as well as
File-
I'll
file
file it in the
it.
counter. My lords,
I
one
pray for a
submission I
week's
want to
time, my
make.
lord, because there is a complaint and I'm waiting for the order copy from the court. So I'm just waiting for the copy, original
What
copy.
is this writ
My lords,
petition? What is
This is for the
included? Let us
visitation rights, my lord. They are seeking for the overnight stay in one of his friend's place. The child is.
So for the mother.
I'm for the mother, my lord. And the child is just 4.5 years, and the father wants to take the child to one of his friend's place where he wants to spend the third Saturday whole night till next day 6 p.m. So which is not right, my lord.
Then
So
what
mother
happened
is
when
not.
order is passed by this court?
There is a stay, my lord. On 17/4, the stay was granted against that order, which was passed by the trial court. So we are seeking for some time to comply it, my lord.
May I make a submission, my lords? My lords, serial number
No,
36.
what is seeking time to comply with the order? I am not able to understand.
Okay, my lord, the thing is, on
There's a
17th,
stay
yeah, there is a
by
stay,
this
my
court.
lord.
What is the time for complaints?
There are documents which I have to produce before the court, my lord. For that, I need some time. That's
You can have stay, but you need time to produce the documents.
only the annexure B, my lord, which is very important. That is incomplete document is there. That's why, my lord.
Then
Stay
how-
I
then-
asked
then
because,
how
my
are you
lord,
entitled for a stay?
I'm sorry to interrupt you, my lord. On third Saturday, there was a visitation, right?
We will hear her on
Yes.
these documents. On these documents, you got the stay.
Yes, my lord.
Yes.
My lords,
Please
serial
come to the
number
order. Wait for a minute.
I'll
Please come to the order.
My lords, they are connected cases. Serial number 36, I have challenged the same order, and serial number 9, they have challenged the same order.
Let's look at the order.
My lords, in this petition filed by my learned friend, if your lords may kindly have page
Come to
13.
page 37, the operative portion of the order.
Kindly, my lords. My lords, here, the petitioner.
What is the age of the boy?
Girl,
The
my
child,
lord.
It's a girl,
Girl
child, my
child.
lords. The child is 4 years, 7 months, my lords. And the father, petitioner father.
First, if you read the order, it will be
Yes. If your lords
convenient
may
for the
kindly-
court.
Operative portion is at page 37, my lords. It starts at the bottom. IA 5 and 7 are allowed in part. IA 5 is in respect of weekend visitation overnight, and IA 7 is in respect of summer vacation. Petitioner is granted visitation right of 25% of the summer and winter vacation of the minor child Prisha. And the petitioner is permitted to take the minor child Prisha to any neutral meeting place for exercising the parenting time from 2 p.m. to 6 p.m.
Petitioner is also granted interim custody of the minor child with overnight stay on the third Saturday and connecting Sunday of alternative month commencing from April 2025.
Which order you're agreed by which
My
portion
lord,
of the order?
I'm challenging order, IA number 7,
Look
my
at
lord.
that. Look at the order.
Yes, my
Come
lord.
to the order portion. Which part of the order you're agreed?
On page number 38, my lord, second paragraph.
Yes.
The petitioner is also granted interim custody of the minor child with overnight stay on third Saturday and connecting Sunday of alternative month commencing from April 2025, and the petitioner shall take the child with him to his boarding place at Bangalore, that is to house where the petitioner stays or to the house of the petitioner's friend Siddharth Shah at Bangalore, by giving full particulars of place of board from 10:30 a.m. and third Saturday till
So
5
what is
p.m.
wrong with that?
She doesn't know who is he, my lord. Mother of the child, she doesn't know who is he. And overnight staying at the
leaving the
child.
child with
And
the
one more
father.
thing, I just want to point it out. The child has never stayed with anyone else apart from the mother. From by birth, she is only attached to the mother, and she has not having the habit of sleeping with anyone. Though there are grandparents at home, the child is not sleeping with them as well. And besides, he's an unknown person, so she's not comfortable sending child anywhere. We have already given the rights to visitation, where we in IA number 2, my lord, the father is already visiting the
From
child.
how long the parents were separated?
It's almost 7 years, my lord.
The age of the
It's,
girl
the
is?
child was 1.5 months old. That time the father has kicked the mother out of the house, and she's staying separate from that time, my lord.
1.5 years.
Yes.
When the visitation is granted?
It's just last year, my lord, in the month of March.
In the month of?
Yes.
What was the visitation in the month of March that was granted?
It's only on third Saturday and Sunday, 11 to 5. He can take the child to the Phoenix Mall and he can spend the time over there.
So
So,
how
we have no issues with
How
that, my
it
lord.
went on? It's been
The thing
happening
is,
from the last 1
yes,
month.
my lord. The
1
thing
year.
is, yes, yes.
So how are there any complaints on such visitation?
Yes, my lord. He's been feeding all the junk foods to the child.
All
every
that from the
Okay.
girl's side. Is she having any problem spending time with the father?
Yes, my lord. Whenever we try to send her, she cries. I have a videos of all those things. I can produce before the court.
Was it ever brought to the notice of the court?
Yes, my lord. In the trial court, I have given the information about all these things. I have given the video also. And yesterday also on the third Saturday, this month of third Saturday, which was on 19th, on that day also the child started crying. She didn't want it to go, and the mother forced the child to go with the father. So when she comes back to the mother, she's literally hugging the mother and she's not leaving the mother. She's not at all comfortable because it's a Phoenix Mall and she's seeing all the toys over there. She's
Granted
going
for
over
the
there.
entire order or for the only this paragraph number 2?
Only for the IA number 7, my lord, because she's not comfortable to send the child to any other's place.
That's what I'm asking
Yes.
you. For the overnight custody, the stay is
Yes, yes,
granted.
yes, ma'am.
Yes.
In respect of this order.
Why he has no independent place to
A
stay?
resident of Delhi, the matrimonial home was in Bombay and Delhi. After the child was born in September, on 1st of December, as a matter of procedure, they moved to their parental home, and the respondent wife, in this case the petitioner wife, refuses to come back after that. All that she wanted is that he has to shift to Meerut because he was working from home, and in the petitioner's wife, my lords, they are having siblings of 2 females, and their parents are dependent on petitioner's income. They do not have any income. So the petitioner moved to Meerut, and after that, petitioner wanted the husband also to move to Meerut and stay in Meerut because it was work from home.
Which is connected 30?
My lords,
Which is connected 32?
36, my lords. If your lords may kindly have my petition, my lords. It is 36.
Let it come after vacation.
My lords, 36, I have asked for my summer rights, my lords. An order
Will
is
not
passed-
decide now.
My lords, my lords, kindly. An order is passed in respect of 25% of visitation. That too, 2 to 5. When, my lords, I am staying in Delhi. It is impossible for me to only have visitation of 2 to 4. And I want to take my child to Delhi. My child is used to me, and they are making baseless allegations. I have thousands of videos to show that the child is extremely comfortable.
In matters of these kind, the court cannot pass any orders without interacting with the child. And court has now there is no time for the court to interact. And this court cannot pass any order now. Both this matter and the other matter shall come after vacation.
There is an interim order in this case, my lord.
I've been granted some orders, my lords. My lords, right now the order is very one passed without application of mine, knowing the fact that the client every month travels from Delhi to Bangalore to spend quality time with the child.
Yes.
And, my lords, if your lords may
Interim
help me
order is
with
there,
the
ma'am.
Order of that aspect. My lords, the time that says is 2 p.m. to 6 p.m. It is impossible to, that is an impractical order that is being passed. I am a resident of Delhi. I live with my father and mother, and I have filed an application to take my child to Delhi to spend summer and winter and other vacations. When that being the case, I have to spend an order being passed where I have to spend only in Bangalore. That too from 2 to 6 is absolutely illogical, my lords. And it is absolutely impractical.
Overnight custody, this court will not grant without interacting with the child. I made it very clear, whatever submissions you make, that's not going to change. If you want the duration in the daytime, we'll grant.
Let's let the summer vacation, at least, if not increasing it to 50%, at least for time being from 25, in this 25%, let it be from morning 10 a.m. to 5 p.m.
Yes.
The entire 25%.
My lord, one
Both the
submission
mo-
I want to make.
Both the mother and the father or before this court, questioning the order dated so and so, passed by the family court. Give that file.
My lord, I just want to make one submission. Mother is out of station from 26th to 15th, my lord. After that, any date will be fine.
They have already enjoyed 45% of the way.
Case, anything is fine. Order dated 17th March 2025, whereby the father is granted visitation rights for 25% of the summer and winter vacation, and is permitted to take the minor child to any neutral meeting place for exercising the parenting from 2 p.m. to 6 p.m. And also, he has granted interim custody of the minor child with overnight stay on that third Saturday and connecting Sunday of alternative months commencing from April 2025. And the father shall take the child with him to his boarding place at Bangalore, that is to the house where the father stays, or to the house of the friend, by giving full particulars of place of board from 10:30 a.m. to the third Saturday till 5 p.m. on the next day. In the first matter, I'm on the patient order sheet. A coordinate bench of this court on 9/4/2025. When is the order?
17/4, my lord. 17/4/20.
9/4/2025 is my petition, my lords.
On 17/4/2025. Had stayed as far as the overnight custody is concerned. Then counsel appearing for the father submits that the father wants to take the child to Delhi. And the order that is passed, that is granting time for the exercise of the 25% registration from 2 p.m. to 6 p.m. when the father is residing in Delhi and exercising in Bangalore, is the order. The order is not a well-considered one. When counsel appearing for the mother submits that the girl is not comfortable staying overnight, even when the grandparents are there, she's staying with the. She always wants the company of the mother. From when are you out of?
Till May 15th, I am out, my lord.
When the school starts?
School starts on 27th of May.
I will not even be having.
Please understand. What is 25%? How many days will come?
Already it's been set, my lords, on the third week of
Please,
March.
I'm asking you a question. 25% of the summer vacation or how many days?
So, my lords, first of all, I do not have access to the child's education. In this order, there is child access to the education where I need to be included. I am not aware, but I do know I have called to the school and the school is open on the third.
How many days of the vacation?
Usually, my lord, it will
Not
start.
usually, there should be a specific time. Get instructions.
Yes, my lord.
Right now, next matter will be called. Ask her from when to when, or the vacation. What
She
is
was on a
25?
vacation, I mean, she was on a summer camp till last 31st
Not
of this
concerned.
month.
Then if it is summer camp, don't go anywhere. Give the father his 25%. Whatever remains in that you go. So you can't have everything you want.
I understand.
Tell her 25% should be given to the father, and it will be between 10 to 6
In Bangalore itself.
in Bangalore. Yeah. Next matter will be called. Please get instructions.
Yes.
Yes. Yes, next.
Sale number 10. Satika DJ.
Notice.
Sale number 11. Sale number 11. Raju S.
Notice.
Sale number 12.
See, notice.
Sale number 13.
Notice.
Sale number 14.
Notice.
Sale number 15.
Notice.
Sale number 16.
Case 16.
Sale number 16.
Petitioner, Father, my lord, if I could just in brief explain as to what the case is posted for today. The petitioner father has filed a petition for divorce and permanent custody of his 11-year-old son. In that petition, I had filed an application for visitation rights, which was allowed only in part because at the time of the order being.
The order passed.
My lord, 21/12.
Petition of 2022.
Yes, my lord.
What is the urgency to hear now?
My lord, because the vacations are going on.
Why are you moving the court just? So
No,
that
no,
I can-
my lord, the matter has been listed continuously since September of last year. In fact, we have been pushing for a final disposal. Learned senior counsel representing us has also addressed his final arguments. What had happened in the interim, my lord?
And it's already ordered. Let it be heard after vacation.
My lord, in fact, this honorable court and my lord also has passed an order where I have
Not like, every time before every vacation. This can't be the arrangement.
my lord, I absolutely
And
agree
court
with
can't
you.
spend time like this.
Yes, my lord, but I have not moved the matter now. The matter has been going on since September of last year. They have been taking adjournments. In fact, they also had filed, please let me complete. They had also filed an application before this honorable court in my petition.
Why petition is pending? Why should it be pending from 2022?
In fact, I have.
In respect of a visitation, it's an interlocutory order.
And my lord, I
Maybe
have.
an order be passed, and all of you, whatever the rights and remedies you have, you pursue it.
My lord, in fact,
My lord,
I have
an application was filed.
Sir, what is the earlier order?
My lord, an application was filed for relocation of the minor child along with the respondent, my lord. And we were directed to file the same application before the family court.
Come to the impugn order.
Yes, my lord, it's at page number 36. In fact, I have produced a memo of documents for the convenience court, which has the relevant page.
Get the order first. Petition is permitted to exercise visitation rights of the ward on alternative Sunday between 11 a.m. to 4 p.m. till the disposal of the main petition.
Yes, my lord.
Video call on alternative days.
It was because of the threat of Omicron.
They mentioned about so and so. Then what was the order? Give that.
My lord, this court has already passed 7 orders permitting me to take the child during summer vacation, my lord.
Now, what we do is, we will dispose this off.
Please, my lord.
We'll dispose this off.
Please, my lord.
My lord, if I may make one submission, an application was filed before the family court seeking relocation of the minor child to the United Kingdom, my lord. That application has been allowed. We have just received a certified copy of the order. We've been permitted to take the child to the UK, my lord. I may be permitted to file a certified copy of the order. My lord, senior counsel is engaged in the matter. It may kindly be taken up tomorrow for argument.
Your court had permitted you to take the child to UK.
Please, my lord, we have been permitted to take.
You're the mother? Or
I am the mother, my lord. I prefer the mother. I have been permitted to take my minor child to the UK, my lord.
The summer vacation.
No, my lord, to relocate to the United Kingdom, my lord.
This is matter after vacation.
My lord, I lose out on the vacation rights, my lord.
Now, when there is an order,
Please.
can there be an order of that nature?
Yes, my
When
lord.
the court had permitted them to take the child, you have to question it. In this, will not pass any order.
But my
Please,
lord,
my lord.
if I may be able to please, just 2 minutes, my lord. They have not specified as to when they are going to go to UK, my lord.
Are you not aware of the order?
I'm aware of the order, my lord, but the order is
Question it.
silent.
Question it, we will
My lord,
see.
but the
Please,
order
ma'am.
is silent. My lord, just 2 minutes, my lord. My submission is that they have not mentioned as to when they are going to UK. In fact, during the course of arguments, they had orally said that
Completely when there is an order of relocation, you have contested the matter, it is for you to question that order.
My lord,
In
but
this
the-
order, we will not pass any orders. This writ petition is filed.
My lord, please, if I may be permitted to make a submission now, presuming I fail in my appeal when I challenge this order and they are permitted to go to UK, they had indicated that they're going only in August. The child's vacation is ongoing now. At least the father may be permitted to enjoy the vacation now that is going on. The child has vacation till 2nd June. The father is.
Are you leaving to the UK?
My lord, we're in the process of obtaining the visa, my
On
lord.
the last date,
As
they
soon
took
as
an
we
adjournment.
receive the visa, we will be leaving, my lord. We are not sure about the timeline of when we
My
will
lord,
receive
on the
it.
last date, they took an adjournment indicating that they would inform today.
Where is the father?
The father is a resident of Bombay, and there have been 7 orders passed by this honorable court where the father has
So
been.
you're taking him to the UK.
Please.
Let me spend time.
Let the father have the custody. What is the difficulty?
Till the end of May,
You're
I may
going
be
to- you're going to
permitted, my
take the
lord.
child out of country.
Please, my lord.
Let the father have the company of the child for some time.
My lord, may be taken up tomorrow, my lord.
Fine,
Thank you.
My lord, every time an adjournment is taken and the matter is pushed.
My lord, senior counsel is engaged in the matter. He's held up in arguments in Court Hall 1, my lord.
Pass over, let him come next.
Obliged, my
Cell
lord.
number 17.
But whoever comes, the order is going to be that custody will be given during the vacation. And please tell the court what is the vacation. If this order is not going to change, for your satisfaction, the matter is passed over. Tell the senior counsel that. Yes?
Cell number 17, Gita Devi MP for petitioner.
Yes.
Pajay.
But in this matter, we're not challenging the order of the family court.
What is urgency now for the 23 matter?
My lords, in that I am moved the memo because they have obtained a stay and I filed a vacating of interim order application also. They have lied before the court through their memo.
No, when they have the stay. When was the stay obtained?
My lords, stay was what obtained in 2022. But I have
We'll
been,
see.
my lords, there has been continuous lies before this honorable court and
That lies will continue for another 2 months and will decide after vacation. Please understand the difficulty of the court.
Your lordship can kindly review the order sheet. 7 straight adjournments they have taken. It is not because of my negligence.
Please
the matter was
understand.
not heard.
Please understand, this is not the roster of the court. Unless and until there is an urgency in the matter, court will not take up. Yes, after vacation.
Cell number preliminary hearing, cell number 18. 18. Sadesha KN for petitioner.
Yes. No representation after vacation. Yes.
Cell number 19. Arun Goenraj.
Yes.
May I please.
But the urgency was school fee was not paid, and therefore his lordship passed an order on Thursday last week that parents must come to some understanding with regard to payment of school fee. Subsequently, my lord, the father has deposited 4 lakhs, though the actual fee to be paid is 5,68,000 rupees. With that payment, my lord, we'll request the school to grant some time for payment of the additional fee.
May I just submit matters? Last step. Ashikan. There are 2 writ petitions. One is with regard to the maintenance order by the trial court, and another is with regard to visitation. From September till this day, your lordships intervened in between, and then there was an order for Saturday and Sunday. Now, I request your lordship to kindly take up this maintenance matter itself, which is urgent for them. Your lordship may kindly say, I'll just take 5 to 6 minutes of your time, that's all. Your lordship may kindly see the memo of calculation.
Matter. Where is the order granting visitation?
My lords, WP 21834 of 2024 is connected with WP 21426.
Which pertains to visitation?
Visitation is for 21834.
Give that.
And 21426 is their maintenance. Because they have urgency on maintenance also, I will address that I have completely honored the court's order. This memo of calculation may kindly be seen, my lords. Last time I gave it to.
Now, as far as the visitation is concerned, there is no difficulty.
Allah, difficulty is there because, my lords, what was the order passed? In between, your lordship had passed for 2 days, Saturday and Sunday. There afterwards, there was disconnection. It went, and that order was for a limited period. Then the original order was to have visitation only in the mediation center between 10 to 1 p.m.
What is the age of the children?
Children age is, what is the age of the children? 7 plus. They are in, I'm sorry, my lords, 1 second. 8 and 10, my lords. 8 and 10. What's happening is mediation, 12 and 8 years, I stand corrected. The problem is that, my lords, now they are particular about the maintenance order to be honored. As far as this memo of calculation is concerned that I have placed before your lordship, there was an order to pay 60,000 rupees towards school fees and 40,000 rupees towards maintenance of wife and children.
Every month.
Every month. Then when it came up before your lordship said, because we said school fees has already been paid by us regularly, then your lordship said that 40,000 can be converted into 20,000 rupees per month till further orders. We have been doing it. Even if we take it at 60 and 40 also, I have placed the memo of calculations. We were falling short of 3,71,000 rupees. Now they are shifting the child to another school where the school's fees is going 12 lakh rupees per annum, which is beyond my capability. My take home salary is 177, and then.
Can you pay the same thing what you're paying?
Pardon, Millers?
You pay the same thing what you're paying, the mother will pay.
That's, and even now, Millers, on the last occasion when it came up before the coordinate bench, the bench said, irrespective of whatever the permutations and combinations we do, and after finally hearing the matter, beyond 25% I am not supposed to pay as per the Supreme Court. Even if we go to 1/3 also, Millers, my take home salary is 177 plus 6 lakh.
There is no urgency for this. We'll hear it after the case.
This maintenance, as far as this visitation is concerned, Millers, your lordship had passed weekends. Then I have been requesting, there was a mediation, lengthy mediation. At the last end, it did not materialize. Then we requested, my lords, father to have children and access to children. They are not allowing me, my lords. That's
Never had the visitation all through.
We had, my lords. In between, they said earlier there were orders, my lords. I have placed all those things on. Your lordship may kindly see the.
Take that. Yes.
ಮೊದಲಿಂದ ಆರ್ಡರ್ ಕೊಡಿ different number statistics ತರ ಕೊಟ್ಟಿದ್ದಾರೆ. My lords, these were the dates when we were not allowed to visit. My lords, it is in the family court. My problem is this, my lords. This may also be kindly seen. A detailed order was passed at different times, my lords. My lords, we had filed applications, my lords, IA3 and IA11 for different orders, my lords. Now the order that is passed on IA3 and IA11 are on the next page, which your lordships will see, my lords. The petitioner, first column, my lords, the petitioner is entitled to the.
Oh, Mr. Arun Gondraj, what about the visitation?
Now, my lords, temporarily some arrangement may kindly be done for this holidays, my lords.
This is the case where the father was granted visitation every weekend from 10 to 5. Every weekend. Family court allowed suo moto reduce that to 2 weekends 10 to 5 after interacting with the father and the children. Thereafter, further reduced supervised visitation in the visitation room because of the father's conduct. In fact, your lordships have recorded on 23rd of September that any further visitation will be subject to how the children feel with their father. No.
But there was, it was also recorded by the court that the visitation went on very well.
But thereafter, my lord, so far as further visitation is concerned, the father writes an email to the mother, can you bring the children to the visitation room? The mother goes with the children to the visitation room, the father does not turn up. Thereafter, she writes him an email and informs him that further visitation, whenever you want, you please write an email and I will be there with the children. He does not respond. I have the email with me.
Lords, every court, every date, my lords, we have recorded there also. And then, my lords, one more submission.
What has happened? What is going to happen from now to the till the vacation?
But not in mediation room, my lords, not in mediation room. That may kindly be excused. Saturdays, my lords, the children have Hindi, some tuitions. And one child comes and sits with the mobile and the other child sits and takes the tuition. And between 10 and 1 in the court hall, in the mediation room is very difficult, my lords. May I request your lordship, 10 to 5, 10 to 5, this is holidays are also going on, Saturday and Sunday. Any 2 weekends may be given to us, my lords. And I have been honoring the order now, my lords, as of that, even though we have challenged the trial court's order as far as maintenance is concerned, as on today, it is completely valid.
Are you suggesting from
10 to 5, 10 to 5 for 2 days, my lords. Weekends were given earlier. So what I'm requesting is,
to say 10 to 5 in a month?
Two weekends, my lords, 10 to 5.
Saturday
and Sunday, two weekends, my lords, 2 weekends, one overnight. In that one overnight.
Overnight has not happened till now.
It had happened earlier, my lords. With your lordship's intervention also it had happened. And then your lordship also recorded. Their case is that, my lords, once the child was not, we admonished the child, the father spoke harshly with the child is what they said. That's different.
What happens is, now the vacation is going to start. Whatever that happens, there is no occasion for any of you to bring it to the notice of the court. Instead of going for the overnight visitation, this weekend, 2 weekends.
10 to 5, 10 to 5.
10 to 5, that we will confine.
Please, Maras.
Then after this court reopens, we can think about
Please,
the
Maras.
next term.
Please, Maras.
One request. The father's writ petition, my lord, challenging the order of maintenance. Only one paragraph from the writ petition. It is submitted that with regard to the educational expenses of 60,000 rupees directly to be paid per month by the petitioner, the court below has failed to consider that the petitioner father has been paying and continues to pay the school fees for both minor children at Head Start Montessori in Whitefield. Their annual fee of rupees 8,08,600 is paid. Therefore, when the petitioner father has been paying and will continue to pay the school fee directly to the school, question of paying the school fee of rupees 60,000 per month to the respondent wife does not arise at all.
That one, we are still agreeing.
I may be allowed to make my submissions. It is the father's affidavit before this court that I will continue to pay the school fee.
Correct.
That is not being done. Therefore, the matter came up before his lordship, and on the last occasion, his lordship has passed an order. I hope that the father will not allow the children to be removed from the school for non-payment of school fee.
I abide by the statement made. It is a statement on oath. Now they are shifting the child to another school.
So then we'll do as per that statement.
Old fees structure.
No, you are ready to pay an amount of rupees 8 lakh.
That time it was 8 lakh rupees.
8,600 per annum.
That we have paid.
No, 8 lakh 8,600. So is he paying that?
And we have paid.
The 4 lakhs that is paid. The school fee is not paid at all.
No. May I just correct it?
This amount. That was school fees.
Yes, Malas.
24-25 school fee he has paid.
We have paid.
25-26, the first term school fee is 5,68,000.
No. Then she's saying that you've shifted the boy to some other school.
No, same school. The campus where they are has classes only till 6th standard. The older son moves to 7th standard. He has to move to the main campus. From Whitefield, the same school has the main campus in Sarjapur. He's not shifting schools.
May I just
the campus is shifting.
May I just intervene, Maras? The elder son, they want to shift to the major because there is only 6.
But they want to shift.
Well,
as per the school,
please,
if you have till 6th standard one campus.
That is my pursuit permit, Malas. 12 lakh rupees per month. That's where I'm requesting them, Malas.
Same school.
No. The fee structure is double. Now their policy is that school's policy is that.
Please tell the court that in the very same school they have the 7th standard classes available, or they're continuing with the 7th standard, but still they're sending it to some other.
Their school may just take 2 minutes time. There are 2 children. One is younger child which has to complete till 7th standard in one school and then go to the next school. The elder son goes to the other school of the same branch, but where the fee structure is double the earlier fee structure. We had agreed to pay for this school. Now, the younger child also, according to their policy, if one child is one school branch, the other child will not be allowed to study in another branch. So both children will have to go to the newer branch, larger branch.
According to the father, what should be done?
We suggested that let them go to some other school, Bethany school, some other Christian institutions are their best schools. I will give up to 1 lakh rupees per month is what has been ordered by the trial court, 60,000 rupees plus 40,000 rupees. I said, my lords, now this month onwards, even my EMIs will also come down. My take home salary, even with bonus, now I have been given 6.5 lakh rupees per month per year as bonus. So 177 plus 50 will be 222. Even if you take it at 3 lakh rupees also, beyond 1 lakh rupees, I can't be giving.
And one thing also, children who are studying in the very same school with all the peer group and all, suddenly in seventh
Well,
standard.
this is
you
impossible
ask
for
them
me.
to
Whereas
shift
the
school.
wives earning, I have placed on record.
Homemakers throughout, may I make one request? The rich senior counsel on the last occasion has filed a memo showing the father's income as 2,40,000 rupees per
Correct.
month take home after all expense, after all
Correct.
deductions.
Correct.
2,40,000 rupees. The school fee and the children's maintenance awarded by the family court, the school fees be taken as actuals. It comes to about 90,000 rupees per month for the father to pay, 40,000 rupees towards their maintenance, 1,30,000 rupees. By their own account, they still have 1,10,000 rupees left. There is no EMI to be paid. All EMIs are concluded as of March 2025.
Now,
1,10,000 rupees the father is left with.
May I just intervene, Nurse? I was paying EMI. Then during negotiations, they said that I have to vacate the house.
Govinda, what we do is, whatever that 8 lakhs and all they were paying, let him pay. Let him, this year also let him pay.
Subject to the final
decision.
Fine.
And the visitation is first Saturday, Sunday, and fourth Saturday, Sunday, 10 to 6.
Grateful, Nurse.
I will have absolutely no objection about that. But right now, children are in food mode. We'll compensate. If they're not able to come on a particular day, we'll compensate.
Any of the Saturday, Sunday,
Yes.
on advance notice to the
We'll compensate.
father. It should be
That-
like
that
in
undertaking.
a week, the 2 days, in a month.
This memo of payment may kindly be taken on record, Nurse.
The three writ petitions or filed. What was like?
They have now challenged the writ petition on one more.
19 is filed by the mother, that I understand. 19.1 by the mother. 19.2.
We had filed two. One is with
I
regard.
find different advocates' name. That's why I'm asking.
The 19.1 and 2
Filed by the
Suhas and
filed by the
Somnath.
father.
Father.
The two writ petitions are filed by the father and one writ petition is filed by the
Mother.
mother. The senior counsel on behalf of the father and Mr. Arun Govindraj submitted their arguments. Considering due to paucity of time, this court is not inclined to go into the matter elaborately. Considering the requirement of the children towards the school fees and the visitation, this court is passing the following order. As the father shall pay an amount of rupees 8,08,600 as agreed by him towards the school fees
Per annum, Millers.
per annum as per the earlier as per the statement, as per his own averment in the
6,000
affidavit in this writ petition, which is subject to the further orders to be passed by the court. Coming to the visitation, the father can exercise the visitation on the first Saturday, Sunday, and on the fourth Saturday, Sunday of the week of the month from 10 o'clock to 6 o'clock. If it is not for any reason, if the mother is not able to, has any inconvenience in advance, 2 days in advance, it shall be communicated to the father and shall be compensated in the very same month on some other weekend.
This shall continue
This is
till the
not-
next. This order shall continue till next date of hearing, Millers.
Until
Arrangement.
until this arrangement shall continue till the next date of hearing, plus the certification.
1,68,000 still to be paid for this term.
No, if it is 8,08,600, if he has already,
Paid 4 lakhs now. 1,60,000.
that's what he has to pay. And as per the, no, in the fees, this thing, you're right.
Millers, may I just submit, Millers? Earlier, whatever was the trial court's order, we have complied with it. There is no due at all.
What I'm saying here,
Now, Millers.
8 lakh.
That we had a time, Millers. I had a time to pay in 2 installments earlier. Now I have already paid 4 lakh rupees, my lords.
But if the requirement is there, you have to pay. You can't, the father can't be so impractical.
My
If
lords,
the court is insisting, if the school is insisting the court fee to pay, you can't say that I'll pay in my convenient time. If the, as per the schedule fixed by the school, the fees shall be paid
By the father.
by the father.
Cell number 20, Anil R.
it may be subject to adjustment, my lords, subsequently subject to result of writ
I
petition.
said that, so everything is
Grateful.
subject to the result of the writ.
Cell number
Yes,
20, Anil R.
Yes.
Appearing for petitioners, my lord. Aggrieved by the delay caused by the
What is
petitioner.
the urgency to hear this matter now?
Because, my lord, this is 3 years matter, my lord. This is not the normal dispute
This
between
court
husband
is
and
not the roster court. Any matter that is urgent will only be heard by this court after vacation.
Number
Yes, next.
21, 21 A.N. Krishnaswamy.
I'm appearing for the appellant, my lord.
Yes.
This is a negligence case, injury matter.
Hmm.
The liability fixed against us is 40%, my lord. That is Bajaj Alliance Insurance Company, and 60% is ICICI Company. Are requesting for stay, my lord.
On what ground you are before the court?
Negligence, my lord.
According to you, a vehicle is not involved in that.
Is involved, charge sheet filed against both the vehicles.
Hmm.
But is our
Here on the
contention-
apportionment.
Yes. Yes,
So
ma'am.
whatever amount
The 40% liability fixed
then
against us.
50% of it you deposit, they will withdraw. The
No, my lord, it's
I
a
heard that.
matter of negligence, so that after the contention, they can-
Subject to that is subject to the result. The insurance companies before this court questioning the order where the liability is on the 40%.
Yes, my lord.
On the insurance company. Considering the submission, there shall be stay of all further proceedings on the, as far as which is the insurance company?
Bajaj Insurance Company.
As far as Bajaj Insurance Company is
Bajaj
concerned.
Alliance General Insurance.
Bajaj Alliance so and so, appellant insurance company is concerned on the condition that they shall deposit 60% of the amount, and the respondents are at liberty to withdraw 25% of the said, the half of the said deposited amount, which is subject to the result of the writ petition.
In this court, before the honorable court.
That's the deposited before this, within a period of 6 weeks from the date of order. Next.
Much obliged.
Who appears for the respondents? Which is the insurance company? Look at it.
Aqua General Insurance.
Huh?
Aqua General Insurance. B. Pradeep.
Pradeep take. So Mr. P. Pradeep is directed to take notice on behalf of the insurance company. Memo?
For dispensation notice.
Huh?
Dispensation notice.
To whom?
22. Notice to R1.
Memo is for seeking dispensation of notice to R1. Dispense with at the risk of appellant. Yes. Admit post of final hearing. Call for the DCR. Yes, next 23.
Cell number 23.
Claimant appeal for enhancement.
Claimant's appeal for enhancement.
Yes,
Which is
ma'am.
insurance company?
New India Insurance
Company. Mr. Ashok and Patel is
Yes.
directed to take notice on behalf of the insurance company, and the land counsel for the appellant shall serve the copy of the appeal memo on the counsel.
R2 dispensation.
Memo is for seeking dispensation of notice to R2. Dispensed, same is taken on record and dispensed with. Admit post of final hearing, call for the DCR. Next.
Cell number 24.
My lord, I am for the appellant, my lord. Appeal by the insurance company challenging the negligence and liability. I am
Yes.
ready to deposit 50% of the award amount before High Court.
You are on what ground?
Negligence and quantum of compensation.
50% and 25% they will withdraw. In that they will withdraw half of it.
Please, my lord.
Insurance company is before this court, questioning the quantum of compensation as well as the negligence. Considering the submission, they should be stay of all further proceedings on the condition that the 50% of the awarded amount shall be deposited within 6 weeks from
Before High Court. Before High Court.
6 weeks from the date of order, and on such deposit, the claimant is entitled to withdraw half of the amount which is subject to the result of the petition. Yes, next.
Much obliged.
No admit, notice.
Please, my lord. I am ready to deposit 50% of the award amount. Appeal by the insurance company challenging again negligence and quantum.
Same order. Next.
Same order.
26.
Much
26.
Yes, 26.
Serial number 26.
What is the urgency?
Ganapati, wait for the
Yeah.
respondent.
Today, it is fixed for filing, my lord, the compromise petition. They have to provide us that he has, my lord, the respondent is a husband, and he has got married during the pendency of existence of marriage with the appellant. And there he has not paid any compensation for her leading life. She has no shelter, and she has no other.
Asking.
My lord.
Have it day after tomorrow, my lord.
No, my
Day
lord.
after tomorrow, after vacation we'll have.
My lord, one submission. We are ready with the joint memo. Previous order according to the honorable court previous that we are ready for that. We are ready to give a two houses
have not
also.
provided because
Everything
this
is,
have
no, my
it
lord,
tomorrow,
this
my
is,
lord, I'll see.
my
Let
lord,
her-
please.
Let them
Please
furnish.
read. My lord,
Let them
I
furnish copy of
I
that.
read.
And it is duty of the advocate.
My lord, what copy we have produced, they are accepted last week.
After vacation, 27.
Serial number 27. Maheshwari, DM for petitioner.
My lord, husband's appeal, my lord, challenging the judgment.
How much is
of-
granted?
My lord, 7,500 per month, 7,500
What is your
per month,
income?
10,000 litigation expenses, my lord. My lord, his income is very meager, my lord. His income is only about 20,000. In that
If you ask what
16,000
the query of the court is, then it will be easy.
Yes, my lord.
7,500 is a amount granted.
Monthly
To the
maintenance.
wife or the child is also there.
There is no child out of the
What is your
wedlock, my lord.
income?
My lord, my income is about 20,000, my lord, and 16,000 I pay for the rent, my lord. I have my parents' dependents, my lord.
So for earning 16,000, you pay 20,000, you live in a house of 16,000, then what he will eat and what he'll feed to the other
My
family
lord,
members?
my lord, the petitioner has a brother who is also earning meager amount, my lord. He is contributing for the household expenditure, my lord. My lord,
Pay
before the trial
5,000 on
court,
that, the stay will be granted, or else I'll hear this matter later.
my lord,
You want stay, 5,000,
but,
not less than that.
please.
The present petition is filed, the present RPFC is filed, agreed with the order passed by the tribunal where an amount of rupees 7,500 is granted as maintenance. Land council submits that the income of the petitioner is very less and he has to take care of his old aged parents and he cannot pay the amount of 7,500. Considering the submission, there shall be stay of all further proceedings on the condition that the husband shall continue to pay an amount of rupees 5,000 per month and arrears, if any, till today, within a period of 8 weeks, within a period of 8 weeks from today, and continue to pay this 5,000 by 5th of every succeeding month. Either 5,000 is not paid or the arrears were not paid within 8 weeks, the stay granted by this court stands vacated. Notice to the respondents.
My lord, I'm challenging the final judgment. My lord, I'll deposit the amount before this honorable court.
On such
The arrears.
deposit, the wife is entitled to withdraw.
Obliged.
For 28. Then there will be group.
Yes.
Rangaswamy.
I appeal for respondent.
After vacation, next 29.
Serial number 29.
Huh?
Date may be fixed.
They'll mention the date, looking at, yes, 29.
Serial number 29.
Lord, this is with respect to
My lords, I'm
custody of
filing,
the child, my lord. We have sought custody of the child from Friday evening to Saturday, Sunday evening.
I'm filing the objections, my lord.
What objections here?
My lord,
From 4
in a
months,
joint,
they are taking time for this reason.
my lords,
Several times.
in a joint order pronounced by the learned family court, there was a visitation rights order and an order for paying the monthly maintenance of rupees 5,000, which was ordered in on 8/6/2023, my lords. Until June 2024, they have paid the maintenance, my lord. However, it's been almost a year. They have failed to honor the order of the learned family court, my lords.
Yes, are you paying the maintenance?
My lords, a mere 5,000 rupees also the
My
petitioner
instruct-
husband is not being able
No,
to pay.
I need to get
Get
instructions.
instructions. This is
That-
matter tomorrow.
Let their submission may kindly be recorded if it may be right or wrong.
Their submission may kindly be recorded.
He submitted that from 2024, which month?
June
June,
2024.
the father is not paying the maintenance of 5,000, which is ordered by the court. And land counsel for the petitioner submits that. He'll get instructions. List tomorrow, next 31,
Till number 30,
30 years.
30, Ipaje.
Appeal for the petitioner husband in the matter, my lords. There are two matters connected with
The
each
report
other.
settlement.
My lord, this matter, my lord, the
There is
lordship had
no
already
settlement.
interacted with the child and the parent also.
Their
And
lordships.
they were supposed to declare the judgment, my lord, because of the time, this thing, my lord, it's get urgent, that's all. Otherwise, his lordship has already interacted with both the parents and the child to grant custody of overnight. Overnight custody was granted by the family court. This court has stayed that. And morning, on Saturday, Sunday, mornings to evening, it was given.
What is happening now?
It's happening, it's going on.
Let it go on after vacation.
Yes, ma'am.
This matter after vacation. Yes, 31.
31,
No representation after vacation. 32.
32.
I'm appealing for the petitioner in this matter, my lords.
No, this can also be happen after
My lords,
vacation.
I have urgency in this matter because my application has been not allowed and is allowed in part without an application of mine. If your lords may kindly have the order sheet, the operative portion of the order, my lords.
They have filed an application for
I'll make my
vacation
submission,
visits
my lords.
in the family court, which is listed, I believe, on Friday.
That also they are restraining. They have not filed their objections even though it's been a month since I have served the copies. They are dragging the matter here also and I am not getting visitation of my child. My lords, here is a case where the husband and wife lived together for 10 years and then the petitioner, my lords, the respondent wife steps out of the house unilaterally. On the very same day when she steps out the house,
Please come to the impugned order.
my lords, if your lords may kindly have the.
So this petition is filed on 25/2/2024.
Yes, my lord, since then what happened, because she holds the custody, the interim order was not granted at that point of time. And then since that time, there have been partial hearings. In fact, they were supposed to get the child today.
You have to understand the difficulty of the court also.
I understand, my
When you are not
lords.
pressing on a matter from February 2024, how it has become so urgent now?
My lords, unfortunately, sufficient time was sought by them and they played a game of, once again, my lords. My lords, they moved the matter and get this matter referred to mediation. While mediation was pending, they filed FIRs against the petitioner. My lords, at least my interim order may kindly be considered, my lords.
You're doing from 24 to 20.
My lords, this matter has been listed every time. It's just that they've been seeking time or it's.
You should have insisted before when the
My lords,
matter is.
actually, last date of hearing, my lords, at least my interim order may kindly be, I'll at least make a submission about my interim order, please, my lords.
Next matter.
My lords, here is a case where the father hasn't been able to spend time with the child, my
I
lords.
asked you, what are you doing from February 24?
My lords, this matter is being listed. It is being dragged because they.
Now, please understand, this is not a roster court.
My lords,
And except the urgent matters, already I've spent enough time. I have the other matters to look into.
My lords,
You should have done your efforts before the court, which was having the roster from the last 1 year.
my lords, the efforts were made. In fact, it was for the child visit.
Then this
It
court
was for
can't
the
help it.
child's.
In fact, when matters of this are listed, generally all of them are adjourned. But still this court is giving time considering the urgency.
My lords,
When
may I
something is not urgent from the last 1 year, is not urgent even today. Yes.
Grateful, my
I can actually make one submission. Right now, the visitations are happening in the family court, which is away for both father and mother. And it is only happening on the first and the third Saturday, my lords. At least whole day may kindly be granted.
No,
to
I'm
me, my
sorry.
lords.
This is not some,
Yes.
grateful.
But
Till number 33. Go to petitioner.
Respondent, my lord. After for some time, my lord.
yes, what is this matter about? Adjourn after vacation.
Yes, my lord.
Yes,
Till number
34.
34.
The lordship was appearing for the petitioner.
Please use the mic. Yes.
Your lordship, there was already an order passed by the family court on IA number 2 on 28/3/2024, allowing the father to visit the child on every Sunday from 10 to 3 in any public place. Your lordship, that is in page number 38. The urgency of the matter is that because now he is not getting, since long he is not getting the visitation properly. And we had
It's an order, the respondent mother shall facilitate the petitioner further to exercise the registration from 10 a.m. to 3 p.m. on every Saturday at park at so and so.
Yes, 1 to 3 p.m. And that was a modification, that was passed on a modification application filed by the respondent.
This
As
order is passed on 25/3/2025, let it come after vacation.
Your lordship, one humble submission.
Yes.
Because this matter was enough heard in the last few occasions.
Yes.
And there is an interim stay also. There is an interim order also asking the mother to comply with the first order on IA number 2. In spite of that, the mother is not showing the child and creating a lot of problems in the public place.
My lord, it's
And
a
our-
false submission.
and
He's
our-
exercising his visitation
our-
right every
our
Sunday
only
10 to
prayer,
3, my
Your
lord.
lordship, my only one humble submission is,
Serial number 35.
your lordship, my humble submission is his only request is to give.
Orders will not be now one order, complaints another order, no. If somebody is not complying, you have a remedy, please have that.
Your lordship, then kindly the interim stay may be extended and the interim order also may be extended.
Whatever interim order is granted, it will be.
Interim stay and
it will
interim
be-
order is may be extended.
Into the
Because
interim
it's only
order-
the- it's
Interim arrangement earlier made is extended until further orders.
Your lordship, it is actually a few hours, whatever hours allotted by the family court. We want those to be given in his custody without supervision. That is all our prayer.
Now you have an order in the month of March. In the month of April, again, the court has to pass some other order. No. Yes, next.
Serial number 36. 35.
Here for the petitioner.
Respondents, my lord.
Lord, there are two directions in two writ petitions, one by your lordship and one by the coordinate bench, directing the family court not to dispose of the matter by the end of April, this April. The wife files an application after cross-examining the husband, saying, I want to further cross-examine him. The family court recalls the witness for further cross-examination on the ground that permanent alimony has been claimed. There is no such claim for permanent alimony. The family court has passed an order, my lord, assuming there's a claim for permanent alimony.
Where is that order?
My lord, the order is at page number 171. Only on that ground.
My lord, I'm filing my statement of objections, my lord.
But before that, may I take your lordship's note to the two orders passed by your lordship and court. Respondent side have filed IA 17 and 18, both under section 151 of CPC, seeking recall of PW1 and permitting them to further cross-examine him. In this case, the respondent side have filed these IAs seeking further cross-examination of PW1 on the contention that after.
Further cross on 28/3/2020. What has happened thereafter?
Not.
No, they haven't appeared in court, my lord.
Huh?
They haven't appeared
They
in
have
court.
challenged the order before your lordship.
But there's no state, there's nothing, my lord. They haven't appeared in court.
On the last occasion, my lord, my learned friend was directed by the court.
Why you should come back to this court when the matter is posted on that particular day on 28/3? The matter will be heard and disposed of.
No, the learned judge has posted for further cross-examination now. Though cross-examination is complete, my lord, your lordship may kindly see two orders passed by your lordship and the court, page number 132.
Understand?
Yes.
Just because the court passes an order to expeditiously hear the matter, that
Yes.
doesn't mean that without looking into the matter, the requirement,
No.
court will blindly, just like the dispose of.
Well, second order, page number 142, my lord.
When it is
In another
supposed to-
petition,
When it should be disposed of.
by 19th of April
Ma'am,
2025.
my lord,
No,
there's-
your lordship,
There's no date, my lord.
Please wait, Mr. Counsel.
your lordship's order,
19th April 2025.
yes, it is
You have come before this court by
Yes.
28/3/2025 itself.
correct. No, I've come not for a direction for early disposal.
No,
I have come.
you have come questioning that the court is not adhering to the timeline fixed
No,
by
my
the
lord,
court.
that is not my grievance. My grievance is this honorable, not page number 142. I'm sorry, only one paragraph. I understand, my lord, time constraint. Page number 142.
Yesterday, the court has to till 7 o'clock.
I'm sorry. Page number
I
1.
can understand if any genuine which
Yes, ma'am.
requires urgency, court is there to hear, but not every
No,
matter to be.
despite specific directions of this honorable court, my lord, this is passed by a coordinate bench in January of this year.
Yes.
Page number 141, paragraph 2. No, the bottom of the page. The family court shall proceed further in the matter and permit the petitioner wife to cross-examine the respondent husband, limiting only to MC 1890 of 2024, and the cross-examination shall be completed within 2 weeks from the date of receipt of the copy of this order. Parties are allowed.
How many orders will be passed by the court?
Yes.
In all the cases, it is not.
Lord, I'm not seeking that family court should dispose of the petition within the particular time. Cross-examination as directed by this honorable court was concluded. Thereafter, wife filed an application to reopen the stage of cross-examination on the only ground Husband has filed his affidavit of assets and liabilities. I want to cross-examine him on the affidavit of assets and liabilities. My lord, if in any case, my lord, if that precedent were to be set, no maintenance order will be, my lord, final, because in every affidavit, my lord, there will be evidence and cross-examination to be conducted. And the family court allows.
So when the matter is coming up with when it is at the back end, there is a question of cross-examination of the assets and liabilities.
My lord, the reason is, my lord, because if you look at the order of 142 itself, my lord, in page number 142, there is already a pending application for maintenance, my lord. The same was to be decided at the end of the MC case, my lord. Further,
So what were you doing till now?
my lord, they haven't filed the assets and liabilities, my
They
lord.
have filed assets and
My lord, they
liabilities.
have only filed their assets and liabilities after completion of their cross. They have
It be Mr. Arnold
But it's 24 application. But cross-examination and maintenance, my lord, is unheard of. Even the Honorable Supreme Court Rajesh Naya does not speak of cross-examination on the interim maintenance application. Application under section 24. No, I can understand if there's an application for permanent alimony. The wife is seeking restitution of conjugal rights. So question of cross-examination on a 24 application, my lord, is unknown to law. The family court proceeds. There's an application for permanent alimony and allows cross-examination. That is the error in the order. Kindly see, my lord, the order page number 142 says, IA filed under section 24 of the Hindu Marriage Act.
The family court has not passed orders on IA filed under section 24.
24. 24 is for interim maintenance. No, there's no question of evidence and cross-examination on interim maintenance application. The family court at page number 172 says, wife has claimed permanent alimony under section 25. On that, I must permit cross-examination. That is the law laid under the Honorable Supreme.
That where do you get that?
Page 172, man. The order I've.
Order is 142.
This Honorable Court's order on section 24, that the application must be considered along with the main matter.
Where is the other order?
Page 172, the order of the family court. Since about 4 lines from the bottom of the page, since here in this case permanent alimony has been claimed, it is necessary to subject the cross-examination of PW1 on the affidavit of disclosure of assets and liabilities.
My lord, I have only one submission towards that, my lord. My lord, there seems to be an error in the reasoning, my lord, but the issue is, my lord, in the conduct and the way the trial has been carried out, my lord, till now. Because assets.
What do you say on submission in regard to?
My lord, I have the right to file an application for permanent, because there's the restitution of conjugal rights and the divorce have been clubbed, my lord.
You didn't even hear what is the query of.
Yes, my apologies, my lord.
What I said is, what do you say about his submission? Your application is seeking for interim maintenance.
Yes, my lord.
On an interim maintenance, what about this cross-examination, further cross-examination?
My lord,
Such a procedure or such a remedy, this thing is available to you.
my lord, in section 19(1), my lord, the affidavits are liable to be cross-examined, especially of the CPC, my lord, especially when the circumstances are at issue, because the section 24 application was filed initially, my lord, but pending due to the order of this honorable court.
Apart, when section 24 application is filed long back,
it is
seeking interim maintenance, why the court was not passed?
But she has not pressed the application. The family court passes an order that she has not even.
No, my lord, that's
I'm sorry, sir. Allow me to make my submission. Page 165.
Please state the facts on
page 165. Kindly allow me to make arguments on record. Page 165. The family court records. May I read, my lord? Both IA 14 and 15 filed under 151 CPC 47. The respondent side, the wife has pressed their IAs under section 24 of HM Act seeking maintenance pending to light. The said IA has been filed on 12/7/2023, but thereafter they did not press their IA.
That is a submission of the petitioner, my lord.
I'm sorry, that's the order of the court.
The respondent said. It's not that
The
we have.
respondent wife has pressed their IA today, but they filed the application in 2023 and thereafter did not press the IA for more than 2 years.
My lord, without them filing in assets and liabilities, the same could not be decided, my lord. That is the very reason why now, even in the affidavit of assets and liabilities, they've missed out majority of the portion. It's incomplete, my lord, the whole affidavit of assets and liabilities. Without the same, it cannot be considered.
Agreed with the orders passed by the court, dated 28/3/2025 in MC number 3787 of 2018. The husband is before this court. The husband, who filed the MC?
The husband, my lord, in
Husband
20,
has filed for restitution.
divorce, my lord, 2018.
Wife filed for restitution.
Wife filed for restitution 6 years
Husband has
later.
filed the MC seeking.
My lord, if my
restitution.
objections may be
The
taken on
wife had
record, I'll,
filed.
sir. It may be taken on record, my objections.
No, why objections? I don't understand. This is an order under 227. When everything is there on record,
Yes, ma'am.
we are looking at that.
Yes, ma'am, I'll leave it to your lordship.
First of all, this process of filing this objection should be ruled
Yes, ma'am.
out before this court. What did you write? Ask her to come here. Wife has filed an MC seeking restitution of conjugal rights. Earlier, 2 orders were passed by this court where there was a direction to expeditiously to dispose of the matter by April 19th.
Initially October
No, my lord.
2024, thereafter April 19th.
No, my lord, that's false. There is no date given, my lord. It just says 2 months post cross-examination of the
Cross
petition.
examination is calculated on 19th of February.
To complete the to dispose of the matter as expeditiously as possible. It is submitted that earlier on
24th April, your lordship's order, my lord.
on 9/1/2025, there was an order wherein the court has observed that the respondent side, the wife has pressed their IA under section 24 of the HM Act seeking maintenance penalty life. The said IA has been filed on 12/7/2023, but thereafter they did not press their IAs. Here in this case, there is direction from the Honorable High Court for early disposal of the case. Now the case is at the fag end. The parties are directed to proceed with the case on merit. And thereafter, again, the present order is passed saying that in this case, permanent alimony has been claimed. It is necessary subjecting PWN to further cross-examination on the affidavit of disclosure of assets and liabilities. Hence, IA number 17 and 18 are allowed. This order is on 17 and 18.
Yes, ma'am.
IA number reviewed by the order passed on IA number 17 and 18 are allowed, and the respondent is directed to cross-examine PW1 without fail on the next date of hearing. And for further cross of PW1, the matter was directed to be listed on 28/3/2025. Next parallel, counsel appearing for the petitioner submits that on one pretext or the other, the wife is dragging on the matter. It is further submitted that the one pretext or the other, the matter, the cases, they were dragging on the matter, and further, there is no application for permanent alimony. In fact, there's an application under section 24 of the Hindu Marriage Act seeking the interim maintenance. The court in the earlier order has observed that the court is not going to proceed with the main case as per the directions of the court had to dispose of the matter. He further submits that cross-examination of a witness for the assets and liabilities and for an interim maintenance is no procedure is contemplated. It's for land counsel appearing for the wife submits that in fact the husband, when the matter is posted on 28/3/2025, they have not appeared before the court for further cross-examination. It is submitted that when they have filed the statement of assets and liabilities at the fag end, the wife had no other opportunity but to file this application seeking further cross-examination on the said assets and liabilities. And the trial court had rightly passed the order and there are no grounds to interfere. It's fair. Having heard the counsel signing the said there is a material on record. This is an MC of 2018. There are repeated orders by this court for further for disposing of the matter as expeditiously as possible. This court is not able to understand how an order was passed by the court on when an order is passed on 9/1/2025 saying that they are pressing on the section 424 application, and now when it comes to the present order, it says that there is an application for permanent alimony, which is not correct and which is factually incorrect, and there is no such application for permanent alimony. this court, as rightly submitted by the learned counsel appearing for the petitioner husband, at this stage, further cross-examination of the husband on the IAR under 24 for the interim maintenance, maintenance is not permissible. And the court, having observed earlier in the other order, ought not to have permitted the wife application for further cross-examination. In that of the matter, the order dated 21/3/2025 is set aside and 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 as for the time as for the timeline fixed by the court, the expedition, the trial court shall expeditiously dispose of. Yes, next.
Obliged.
All these final hearing matters after vacation.
Finally, yes.
My lord,
First of all from 37 to 40 after vacation.
my lord, interim order may be extended.
In
Number
those matters, the interim order is there, extend.
My lord.
Yes, next.
Serial number 40,
Serial number
40, even though an order has been passed, serial number 40, even though the trial court has directed the father to pay the school fees, he's refusing to pay the school fees, he's directing the school to give a TC to the child. It's a little urgent, my lord. An email also has been sent by the school to the father, and he's refusing to pay the fees. So my humble...
For complaints of the order passed by the family court, the High Court is the executive court for that.
No, my lord. No, my lord.
Then-
No, that's
Is it not?
It's not.
An order that is passed by the family court, if it is not complied with, there is a procedure. High Court is not an executing court for that.
Yes, my lord.
Yes, after vacation. Yes, next. Passover matter in this list.
Serial number pass over matters in list.
My lord, the
number one.
vacation has started from April 13th.
April
13th, and school will start on May 26th, my lord.
May 26th.
Yes,
So how
the
many
total
days?
43 days. If we
25% would be?
11 days, my lord.
Yes. So when this 11 days you're going to give them?
From 16th, my lord, 16th to 26th.
16th to?
26.
They've not shown any document to show that April 13th, the school, it's a child.
I'll
Well, it's a
record
preschool.
that. Yeah, I'll record that. 16th to 26th.
Yes,
It's only
ma'am.
10 days then.
27th school will start, my lord.
So then give it from 15.
15th night they are coming, my lord. They are going to Meerut, so they'll come back only on 15th night. My lord.
Are they going?
On 25th they are going, my lord.
My lord, so if it is in Meerut, my client stays in Delhi. He will go and meet the child in Meerut itself from May 1st to May 15th, my lords.
My
That is
lord,
more
they
convenient
have
for
booked
him.
They're going on a vacation.
Vacation, they are going to some
Meerut is
Chardham, my
their
lord. The
hometown.
tickets
They're
are
going
already
to their
booked.
hometown.
Anyhow, one more thing.
Yes.
It is near to him.
Yes,
Why
my
not
lords.
he meet
My
the
lord,
child
she's a
in-
working lady. She's coming back on 15th night because she has to work. So,
You didn't answer the question.
I'm sorry, my lord.
That Meerut is close to
Yes,
the
my lord.
place where he's
Faridabad.
staying.
I agree.
So why not he had the vacation there?
My lord, from 25th to May 15th, they are going out of station. She'll go to Meerut, but from there they have planned for going somewhere out. It's a
Not
Chardham
produced anything.
yatra,
They're just
something like that. They're
speaking
going, my
in
lord.
the air, my lords. All these submissions.
I will
In
provide
fact,
all
my
the
client
tickets,
is
my lord,
also
and
working.
the vacation
Works in
it
Delhi.
has been booked, and I'll give all the records.
If both the councils want to argue, court is not interested.
I'm sorry, my lord.
My lords, we'll
Apologies.
meet the child and Meerut that 11 days, my lords. Whichever 11 days that it's suitable for them. Even though 11 days is actually less, I do not want to sit and dispute on that. But they have not produced any document to say that from April 13th it is there.
Give them an opportunity to go file the documents.
Yes, my lords. They can
File the
produce.
documents after vacation.
My lords, in terms of 11 days,
You have to
at least
understand. You have to understand the mind of the court and what's happening. Accordingly, you should make the submissions.
my lords, I'm okay Meerut to spend the child time with child in Meerut
What
for
will
11
happen?
days.
They're going on a vacation. You will spend within that vacation from morning to evening as per the court's order, 10 to 6, you will spend with the child. Where is the vacation for him? Is it not?
My lords, this is the kind of inconvenience they've been causing. First of all, they do not inform well. Anyway, my lords, I'll leave it to the court.
My lord, one more submission I want to make. The child will get up really late, so it may be like provided between 11 to 5 will be convenient for
My
the
lord,
child, my lord.
child goes to school,
Because
my lord.
7 hours, it is too much for a small kid to spend outside
It
time.
is not. Already the child is
And
pending.
all these kind of bargain, the court never understands.
Sorry, madam.
Considering the arguments of both the counsel, considering the ensuing vacation, this court is passing the following order. The father, it is submitted that the vacation is between April 30th, from April 13th to May 26th, and the father is granted 25% of the vacation. That 25% of the vacation comes to 11 days, and in view of the same, the father is permitted, the father can exercise the visitation between 16th and if you want any day in between for that 11 days. Or else
That's what, my lords. In Meerut, at least 4 days because grandparents live in Delhi.
to 26th.
My lord,
At
they are
least
not
for
in
4 days may be
Meerut for
granted
that
in
period
Meerut,
of
my
time, my
lords.
lord. They are going out of station between 25th to 15th.
16th to 26th, the father can pick up the child from the mother's place.
Mother will drop the child in the Phoenix Mall, my lord, and from there only she will
drop
pick
the
it up.
child in Phoenix Mall at 11 o'clock.
My lords, 10, my lords. 11, my lords.
Child will not get up, my lord, and she will be a cranky, and again it will not be possible for us to
This
send the
is
child.
very unreasonable, the kind of request both of you are making. We are not negotiating on some commercial terms where this kind of bargain should happen. From 11 o'clock to 6 o'clock. Yes. Yes.
Cell number 8, Arun Govindaj.
Petitioner.
Yes.
No, the daughter has schools going on, the son has vacations. So, my lord, as the lordship suggested, my lord, in the evening we have no objection. From tomorrow he can pick up the children at 6 o'clock and drop them back by 9 o'clock.
6 to 9.
Your ladyship
6 to 9 till
9.
28. On 29, the matter will come up again.
Your ladyship, let the matter come post vacations. We'll file our objections, detailed objections as well till then.
Seeking an interim order. I'm seeking stay of the order passed by the family court with regards to visitation.
Then counsel appearing for the appellant, the petitioner submits the father.
Your ladyship may not stay the proceedings, may not stay the visitation order.
You can't have, I've already heard you. I have indicated my mind.
Your ladyship.
Please understand, this is the arrangement I said. If it is okay, fine, or else I'll pass the order.
Your ladyship will.
If you're agreed with such order, you have a remedy for that. So no more arguments on that. There are only two ways. One, the court has only ordered for, where is that order? Page number?
26.
The court has ordered every second and fourth Saturday from 10 to 6. I said from tomorrow till 28th, and after that also the order will be extended. He can exercise the registration from morning to evening, and the corresponding duty should follow. If it is okay with your client, order will be passed, or else I will stay this order.
I bow down, your ladyship. We are ready to pay 20,000 per month for the children. The son is on a 100% scholarship with the academy due to his football skills. So we are ready.
Son's responsibility is not there. What about the daughter's responsibility?
I'm ready to pay 20,000 per month. In the interim, this visitation arrangement may continue. Your ladyship may keep the matter post vacations. We will file the objections till then. In the interregnum, this arrangement may continue. I paid 20,000.
No. Why I am asking it to come to be listed on 29th is whatever your obligation that you have to complete it. Then it will continue. Just like that, it won't continue.
Your ladyship, that is, your ladyship, if wants to keep the matter on 29th for compliance, that is okay. But for hearing,
complaints, even it's your grievance that the mother is not complying.
Yes.
So you will have the visitation.
Yes.
You have a responsibility that you will comply. Whether both of you are complying or not, for that it will come on
29th. And for hearing, not for hearing.
20,000, from when you are not paid? From when the parties are separated?
November 22. And from then I have paid 2.5 lakhs. 2.5 lakhs.
Sorry, we don't have that information. That information is not furnished anywhere before any court.
I have furnished it with my affidavit of assets and liabilities. In fact, she has stated blatant lies that I have not paid a single penny after separation.
Even assuming it.
Yes.
Even assuming it that you have paid.
I am stating it on bar that I have paid.
So whatever the amount you are saying, it would come to it would be like per annum.
I don't understand.
Per
your-
annum, if it is 20,000 per month, per year, how much it would be?
It would come to 2 lakhs.
2,40,000.
2,40,000.
That's what I'm saying.
Hmm.
It would come to 2,40,000.
Yes.
So you're from November 22,
Hmm.
you're separated.
Yes.
That has to be calculated that you're ready for 20,000. Till November 23, that's the amount.
Your leadership, the adjudication of the arrears cannot happen without the adjudication of the maintenance application, your leadership. I am ready
No,
and
we are
willing
not
for
saying it.
20,000 for the interim arrangement.
I'll not record that it is arrears.
Yes.
Record it as an amount that is paid.
Your leadership,
Which
this
will-
concession will be used before the family court by my learned friend against me. I am only agreeing for the interim arrangement, that for the interim arrangement, till the time this writ petition is decided, I am ready to pay so and so amount. She complies with the visitation order. Then your ladyship decides the writ petition for finally, and the maintenance aspect and the arrears
What about
aspect
the
can.
statement made by you before the trial court with regard to the school expenses which you are going to pay?
Your ladyship, for that, she filed 3 IAs before the family court, 3 separate IAs, IA 6, IA 9 and
I
IA 10.
understand the line of argument, please come.
And all those IAs were dismissed and those orders remain unchallenged till date.
The order, agreed with order passed in.
And your ladyship, if may see, the children said that they are ready and willing, they are ready to meet with the father and spend quality time with them. The mother has actively acted against the wishes of the children.
Agreed with orders on I number 3 in JNWC number 18 of 2023, dated
1/3/2020, 1st March, 1st of March 25.
1/3/2025. The mother is before this court. That on the IA number 3 filed by the father under section 12 of the Guardians and Wards Act, the court had granted the custody of both the children on every second and fourth Saturday from 10 a.m. to 6 p.m. Next paragraph. Land counsel appearing for the appellant mother, the petitioner mother, submits that.
Page
in
85.
fact- Huh?
85 and 87.
In fact, on
3rd of January 2024.
as per the order dated 3/1/2024, the trial court has observed that the husband is ready to bear the expenses of his children and also reimburse the school fees paid by the wife. And in the order dated.
Your ladyship may
1/3
also, I'm sorry, your ladyship may also see the para above that.
1/3/2024.
29/1 and 1/3, my lord. 29/1, the previous order, page 87.
Uh,
29/1, the order dated 29/1.
No, it appears 3/1.
Sorry, my lord,
Petition is
3/1.
ready.
The next page, 87, the first paragraph, the advocate said he will insist his client to pay the fee. 87.
That's what I'm recording.
Yes, sorry,
that.
sorry.
That by order dated 1/3/2024, it is observed that advocate for the petitioner submits that his client will pay the school fees and also arrears within 2 weeks. Now when the mother has assigned this order stating that when the father who has failed to comply with has to fulfill his own has failed to comply with what has been stated, undertaken, that is before the court, and they have separated in the year they are staying separately from November 22 until now. He has not taken the responsibility of the children. When the father is not interested to take the responsibility of the children, he is not entitled. He can't, when he is not aware of his rights, he cannot press for the about the duties. He can't. He cannot only ask for his rights. He submits that in fact he has also moved a contempt. When that contempt petition is dismissed, he has filed a petition before the deferment of this court, and the same is pending consideration. it is submitted that the order passed by the family court has to be state, maybe state. Next parallel, counsel appearing for the respondent submits that the application for interim maintenance and the the maintenance under the Domestic Violence Act. All those petitions are pending consideration before the court. When the court had granted maintenance, a court had granted visitation, the mother cannot question the same before this court. And already the other orders which are passed by the court or were not questioned by the mother, and this court may not interfere with the order passed by the family court where the court had granted visitation. It is also submitted that the children are very much interested to meet the father. Further, the mother is not allowing the father to have the access, and hence the petition is liable to be dismissed.
Your ladyship may also record that the writ jurisdiction of this court cannot be used as execution proceedings.
Court cannot be used for seeking a for what it
Execution.
should not be used.
For execution of an undertaking.
Execution of an agreement between the parties. Next paragraph. Having heard the counsels on either side, peruse the material on record. During the course of argument, this court has suggested to both the parties that the court had granted interim custody on every second and fourth Saturday from 10 a.m. to 6 p.m. And it is the case of the father that mother is not giving access. Then it is suggested by the court that the father from today, that is from 22nd, from 23rd to 28th, the father can exercise a visitation from 10 to 7, and he shall all the court has specifically asked both the party, and the father shall take care of at least the educational expenses.
Your ladyship,
as
may
stated
I
by-
interrupt? I'm really apologetic about it. I've just sought further instructions. He's saying that he'll pay the arrears as well. He's ready to pay
What?
for 20 at the rate of 20,000 per month for per annum basis.
The educational expenses, I have filed a memo on page number 91. For 23-24 was 6 lakhs for both the children.
No. If he's ready to pay 2,40,000 now, other things you can take care before.
Let him deposit 5 lakh, 2,40,000 for 2.5 years, my lord. Let him deposit 5 lakhs at least.
Still not. Some amount from his side, that is only the court is concerned. If he's ready to pay, I'll post this on 29 when this visitation go on.
No, 6 to 9 because daughter has school going on. 6 to 9 we have no objection.
Yes. Take that or strike it off.
Your ladyship may also consider the summer vacations aspect on 29th.
That is not challenged by my learned friend.
1 minute.
Sorry.
That is subject to further order.
Further compliance by both the sides and
Let
further.
him, that order also will be passed by the court. You come up with what is your client is ready.
Yes.
It is like both the interest of the father, mother,
Yes.
and the child have to be balanced.
Yes. your
Nobody can have the advantage from the courts. That is very clear. It is submitted, stock of everything. This is the order dated 1/3/2024 is the sale before this court, stating that the father, without paying the maintenance and taking care of the children, he wants the visitation, and the court, without considering the same, has granted visitation. When the matter came up before the court, this court had directed both the counsels to have instructions from the client, wherein the father will have the visitation of the children, and as well, father has to pay the amounts for the maintenance or the educational expenses of the children. Next paragraph. On instructions, learned counsel for the father submits that Father is subject to the further orders to be passed by the court, by the trial court, and on the pending applications. The father is ready to pay an amount of rupees 2.5 lakhs. By what date?
How much time do you need?
2
installments. 2 weeks.
Not 2 weeks. The matter is coming up 29th. What is that he's going to pay? That's what is important.
We'll pay half of it by 29th, Your Ladyship. It's
He's
a
ready to
2.
pay. He's ready to pay 2.5 lakhs, and he will pay 1.75 by 28th. 28th. Next, the trial court had granted the visitation on every second and fourth Saturday from 10 a.m. to 6 p.m. Considering the submission made on behalf of the father that the father has no access to the children, under the circumstances, this court deems it appropriate to pass the following order. 1. On 23rd, 24th, 26th, 25th, 26th, and 27th, between 6 o'clock, I think till 23rd, 4th, 5th, between 6 to 9, and on 26th, 27th, and on 20 until 27th, it is from 4 to 7, and again on 28th.
Can it be from 3 to 7, at least 4 hours, Your Ladyship?
But we have no objection. The son has football classes, so we will have to coordinate the time because the mother gets to know only on Friday.
We'll just see. On 28th, again on from 6 to 9. The father can exercise the visitation where he can pick up the children.
Pick up the children from the respondents outside the service line of the petitioner's residence.
The father can pick up the children from the mother's place and drop them back. And next, by the date of earlier I said 28th or something date for the payment of that amount. In clause number 2, so this amount shall be paid by that day. And third, point number 3, basing on what transpires in the visitation, and basing on the and subject to the payment as agreed before this court, further orders will be passed for the summer vacation. Summer vacation in the sense some more amount from the father.
Yes.
Then some more summer vacation.
Yes, Your Ladyship. Your Ladyship, we'll file our objections in the meantime. We'll file our objections in the meantime.
Not required your objections. Yes.
Your Ladyship, the councils will coordinate since there is a restraining order against the respondent in the DV proceedings.
With regard to the timings, the council.
Just send me emails. My colleague's number, I will give my lord.
The petitioners, the council, Mr. Arun Govindra submits that they can inform the same to his colleague, and accordingly arrangement can be made. Yes, next.
Deeply obliged, Your Ladyship.
16 Kaveri Timaya for petitioner. Parvati Nayak.
Which matter?
Memo of documents or something.
For the response counsel,
Yes.
my lord may kindly be pleased to permit me to produce a copy of the order passed by.
There earlier also this court has passed orders for
the
visitation.
now with my lord's kind leave, the situation that was prevalent on the earlier occasions for having given the custody of the child during summer vacations is completely different now. My lord may kindly permit me to make 2 submissions with this regard. First is, the writ petition does not survive anymore, it has become infructuous. Secondly, the order that's passed by the family court is in terms of the direction given by this honorable court. My lord may kindly permit me to read from the order of this honorable court. It's order sheet is there.
No, you say that you are referring to the trial court's order.
Trial court, please, brother.
We have an extra copy.
Yes.
I'll not trouble your lordship to read all the reasons and other things. We are on page 41 of the trial court's order. Internal page.
Final order on the MC.
No, my
Because
lord, it's an
put in-
interim order, my lord. We are yet to
No,
challenge it.
I'll make submissions on that, my lord. I'll make a
It's an
submission.
interim order in response to my lord's
Thereby
question.
directed to deliver the original passport of his minor son.
Yes, my lord. Yes,
to the
my lord.
respondent
My
to
lord,
give consent for the renewal of passport and permit the respondent to unilaterally apply and execute the documents
yes, my lord.
to give his consent for obtaining the United Kingdom visa before the UK consulate in Bangalore for the minor in order to enable the respondent to take the child along with her to the United Kingdom or permit her to unilaterally apply for his visa and to give consent for any other requirement from the passport and visa authorities for issuing the passport visa of the son or permit the respondent to unilaterally apply for his passport. To take the to video or audio calls for about 15 minutes every day at about 11 p.m. Indian Standard Time. Child to Bangalore once a year during his school summer vacation and hand over the interim custody. So everything is decided.
Everything is decided.
Submission is, if I may be permitted to make a submission, since September of last year, we have been pushing for a final disposal. In fact, learned senior counsel engaged by us has also completed addressing final arguments. In the interim, what happened is they have filed this application, this current application, they filed it before the Honorable High Court in November. For that, on that, a detailed order was passed by this Honorable Court on hierarchy of courts saying that this Honorable Court doesn't have the jurisdiction. This application had to be filed before the trial court. Now, this application, I don't want to address on merits of the application, but the only submission that I'd like to make is.
No.
No,
What
yes.
submission? No. If this is the case that only court had decided with regard to the application, leaving the country, taking the child to UK, it's a different aspect.
Yes, my lord.
In that, court has decided the further course of action. What are the visitations you are entitled to?
Yes, my lord, but my only submission is, my lord, now.
Can you make a submission without assailing this?
My lord, I have gone through it, my lord. My submission is that 2 points. One is that they have not indicated as to when they are going to UK.
No.
My
What
submission.
is decided? What is to be done?
Yes, my lord, but my submission is that if I'm going to challenge this order. Now, presuming I succeed in my writ petition challenging this order, then my writ petition here is
it becomes it has become infructuous.
No,
already.
my lord, but my submission is that it has not become infructuous because this order has not gained finality, my lord. I'm in
the light of this court will say, in the light of the order passed on IA number so and so, this petition has become infructuous and the petitioner can assign the order which is passed with the.
But my lord, my submission is that my writ petition is not infructuous because this order has not gained finality. If I can give a probability, my lord, they have also not specified.
Takes the time.
My lord, they have
You
not
have
even.
the remedy. You have the.
But my lord, let's presume, my lord, that I succeed in my writ petition challenging this order. Then what about this writ petition, my lord?
This has to go.
No, my lord, if I
Has to go.
no, my lord, if I succeed in that writ petition, the child continues to stay in India. What about my visitation rights then, my lord?
When the court is passing an order in your favor, that also will be considered. In the light of this order, this petition has become
But my
infructuous.
lord, their prayer was never regarding this suo moto. The court has passed an order even on the.
What to do?
But my lord, now that they have not specified as to when they are, my lord, if I could,
please don't. No, I'll not consider that.
my lord, the writ petition cannot be rendered infructuous, my lord, because
That
this order-
I'll record the reasons why it can be rendered infructuous.
But my lord, if it could be kept pending, and if I could be at
It
least
can't
be
be
permitted.
pending ever like this. Where is that impugned order page number?
My lord, the impugned order that I've challenged in this writ petition, my lord, page number 36.
20?
36. My lord, page number 31. My lord, but my current writ petition depends on the outcome of my writ petition when I challenge this order. I have received the certified copy only yesterday, my lord. If I were to file a writ
The
petition.
council, the IA number 3 under section 20, the present order is, the present writ petition is for a file. Questioning the orders passed on IA number 3 dated 21/12/2022. The IA number 3 is filed under section 26 of the Hindu Marriage Act, that is section 10 of the Family Courts Act for grant of visitation of the boy on every alternative Friday, 5 p.m. till 5 p.m. on following Sunday, first half of the summer vacation, Dasra vacation, Christmas vacation, and midterm vacation, Ganesh Chaturthi, Deepavali, on the date of rituals, pujas, functions programmed by the family and on birthday of the child on 29th December and on birthday of the boy, the father dated 11th September. The court had passed an order whereby the father is permitted to exercise the custody visitation rights on alternative Sundays between 11 a.m. to 4 p.m. This is the disposal of the main petition. And he is also permitted to make video call on alternative day about an hour. And the mother is directed to hand over the child to the father on specific time mentioned, and he is directed to consider, and the father is directed to consider the likes and dislikes of the child while exercising the visitation rights. Further, the father is directed not to give ill advice about the mother to the child while exercising the visitation rights, and if necessary, the mother may also join the father and child in the interest of child, and both the parties are directed to maintain peace, a peaceful atmosphere with the child while exercising the visitation. When the father has approached this court in the year 2022,
If I may be
the
permitted,
matter underwent, yes.
if I may be permitted to interrupt, my lord, my only submission is that they have not mentioned when she is going to the UK.
That I
Presuming
record.
she is going in December, my lord, am I not to exercise my visitation rights until December, my lord?
That I will record all that. Then an order way back on 24/20/22 is passed, whereby this court had directed has permitted the father to exercise the visitation between 9 a.m. to 6 p.m. on every Saturday and on every Sunday between 11 a.m. to 5 p.m. And further directed the father not to take the child out of the jurisdiction of the Bangalore metropolitan area. Further, after that, then on 21/9/2022, the court of an order is passed to give the custody to the father at 8:30 a.m. on 24/9/2022, and the father shall send the give the custody of the boy on 29/9/2022 forenoon, and the father has given an undertaking to pay the arrears of school fees.
4/5/2023 is the next order.
Then the matter again came up on 21/11/2022.
Visitation. The next order for visitation was on 4/5, my lord.
Then on 25/4/2024, again, another order was passed by this court permitting the father to take the child to Mumbai from 1/5/2024 to 30/5/2024. Now, again in 2025, for the
19.
Again on 13/12/2024, another order is passed that the child be taken custody of the child to the father by 14/12/2024 morning 10 o'clock, and both the father and mother shall take the child to the hospital and provide proper treatment. Another order was passed on 19/12/2024. On 24/2/2025, the court had dismissed I number 2 of 24 as not maintainable, and respondent is at liberty to file the application before the family court, and the family court shall decide the same expeditiously. Now on this, the orders are passed.
Please, Madam.
Thereafter, the wife had moved the family court by filing an application
IA number 11.
number 11 or 9.
11, my lord.
IA number 9.
And I'm sorry, Madam.
IA number 9.
Yeah,
To
I number 11, my lord.
9 and 11. I think there are two
Nine-
applications.
My lord, 9 was my application seeking an order of injunction restraining the mother from
IA
taking.
number 11 is filed by the mother. IA number 9 is filed by the father. The mother wants to take the child to UK and she wants the father to fulfill the formalities with regard to obtaining the visa and other things. And the court had passed an order dated 16/4/2025, whereby the father had directed the court had directed the father to fulfill all the formalities, whereby facilitating the wife to get the visa and other formalities, and further had directed the mother to facilitate the child to talk to the father through video or audio calls for about 15 minutes every day at about 11 p.m. of Indian Standard Time. And the mother shall bring the child to Bangalore once a year during his summer vacations and hand over the interim custody of the child to the father for 10 days during such summer vacations. So what we do is this 10 days whatever is the court said about the summer vacation. This year, before you leave, give the 10 days.
Before I leave, certainly, Milord. Now, what, Milord, because Monday, the visa interview is fixed.
No,
I have to
before
take
you
the child.
leave, in advance notice to the
I'll
father,
inform the.
give him 10 days vacation.
That elaborate by Milord.
My
That
lord,
elaborate.
my lord, the vacation is till 3rd June. Could I please request for
But
at least?
court said only 10 days and hand over the interim custody of the child to the father for 10 days during such summer vacations. The mother shall not relocate the child to any other foreign country without the permission of the court, and she shall furnish the contact details of the child in UK to the petitioner. Then counsel appearing for the father has submitted that as like it was granted right from 2022. The father is entitled for the summer vacation, which the court has failed to grant to this impugned order, and an order be passed granting visitation to the father. At that point of time, when a senior counsel appearing for the respondent mother had brought to the notice of this court the order passed on IA number 11, which is discussed in the preceding paragraph, and it is submitted now that with regard to the custody, with regard to the visitation and other things, a final order is passed by the court, and nothing survives for consideration in this writ petition, and the present writ petition has become infructuous. Next part. Having heard the counsels on either side, produce the material on record. Questioning an interlocutory order passed by the court, seeking granting visitation. The father is before this court, and right from the year 2022 till now, various orders were passed by this court. And before every summer vacation or on some other vacation, the matters are moved, and the court is passing the orders one after the other. The pendency of this petition before this court for this from 2022 till 2025 is most unwarranted, as the court is not deciding any of the rights of the parties finally, but only court is deciding with regard to the interim arrangement, and it can never forever, court cannot keep this matter pending, and before every vacation court cannot pass any order. IA number 11, when it is filed before the trial court, that is contested by the respondent, by the father, and the court had also not only permitting the mother to take the child, but also had fixed the visitation, summer visitation, and about the audio calls for about 15 minutes and other things. In view of the subsequent order that is passed by the court, in the considered opinion of this court, no further orders needs to be passed in the writ petition of 2022, and virtually it has become infructuous. Then coming to the submission that the petitioner is entitled for, the father is entitled for the summer vacation, which has been granted by the court. It is for the father to assign the said order. However, this court, exercising the parent patriarch jurisdiction, is conscious of the welfare of the child as well as the rights and duties of the parents towards the minor. Considering the same, as in IN number 11, court had already granted the visitation of 10 days during the summer vacation to the father. This court deems it appropriate in the facts and circumstances to direct the mother to hand over the custody of the child for 10 days before leaving the country.
Could I please request for a date to be specified, my lord?
And that's what I'm saying, 10 days. And after the wife, the mother shall indicate the date when she's going to give the custody for 10 days within 5 days from the date of receipt of the copy of the order. Accordingly, the petition is disposed of.
Published.
Yes, next. List number 2.
List number 2. Share number 1, part-time matters.
Kindly be passed over, my lord.
Pass over.
Share number 2.
The orders to be dictated. Liability is not the issue.
No issue. Regarding negligence aspect is concerned, 40%.
What about 2 lakhs? About
2 lakhs. 2 lakhs.
This is MVC number?
MVC number 2489 of 15.
2489
of 2015. Para 83 million.
There are only 2485, 2494.
2489.
There is no 89.
89 only, 2489. Para 83 million.
No, come to page 8 of the order. This is MFA 5560.
Yes,
correct?
madam. 5560.
Come to page 8, 2485, 2494. Only those are 2 MVCs. Why is that confusion?
No, my lord. 2.
Share number 2, my lord.
24852, 2494.
2494. So this is MVC number?
2489 of 15.
2489 of 15. Where is the table?
Table, my lord.
Para 83, there is a discussion, my lord.
Agreed with order.
Table 130, my lord. Page number.
Agreed with order passed in MVC 2489 of 2015, dated 31st March 2016. The claimant is before this court seeking enhancement of the compensation. The tribunal has held that the respondent insurance companies are liable to pay the compensation at
40% and 60%. 40% against Sriram.
on the
Sriram General Insurance
which
Company.
respondent.
A second respondent.
40% on the second respondent insurance company
Allah.
and 60% on the
Please go. First and third, my lord, here in the appeal, my lord, the first respondent Reliance 60%.
first respondent 60%.
Third respondent
and
Sriram General Insurance Company.
third respondent 40%. 40% compensation. Then council submits that. So this 2 lakhs where we can include, because we just, if you say globally, then no interest.
No interest.
So we have to
Actually-
adjust somewhere. Pay, how many injuries? How many, I mean, what are the injuries?
My lord, page number 107, my lord.
How many?
8 injuries, sir, my lord.
8 injuries.
8 injuries and
So we'll grant 1 lakh for pain and suffering. So that is 60,000.
yes, please.
Then loss of income, nothing. Medical bills is granted. Loss of amenities. There is no loss of future earning because he has got the.
As a future, 4 lakhs has awarded. As per Master Mallikarjun,
Uh-huh.
4 lakh has been granted. As per Master Mallikarjun, 4 lakh has awarded. Item
I'm
number 4,
looking,
Millard.
I think,
Item number 4.
no, the table is where?
Internal page 130, Millard. 130.
130, madam.
I'm looking somewhere else. That's why 130.
Zero. Judgment page 130.
So pain and suffering 60. What is the disability?
Disability, Millard, 90%, 95% to the limb, Millard. 35% MSCT has considered. Internal page 125, Millard. The whole body disability of the petitioner to the extent of 35%.
Table is at 137, 7,56,508.
Please, Millard, correct.
So pain and suffering 60,000 is less. If it is for Master Mallikarjun, it is.
No, Millard, in the Master Mallikarjun case, wherever the 30 to 60%, 4 lakh has to be granted. That 4 lakh has already granted item number 4.
That is loss of future earnings.
Future earnings.
There is
That includes pain and suffering, discomfort, terminates and all. Here, Millard, it's bifurcated and granted the compensation. Because
Then what? Then
she
if
has sustained.
both of you are ready to file a joint memo. I think the other day he was saying Lakshmi Narayana is also ready.
He is also ready. He has informed to Shivanagowda.
Because no, when Master Mallikarjun's case is applied, either we have to take that monthly income, that notional income, or we have to apply the Mallikarjun's case.
Please,
We can't. Where is the scope for enhancement of 2 lakhs? What I'll say is like both the insurance companies submits that over and above the amount that is granted, another 2 lakhs compensation maybe, and they are ready to pay. Joint memo, ask them to come. We will see.
Evening, Lordship.
Evening, at 5:30. Tell Ms. Lakshmi Narayana also. Yes. Over and above 2 lakhs.
Over and above.
With interest.
With
interest.
With interest.
Number 30. Number 13, then dictation. Yesterday matter dictation, Millard. This is a come to admission, Millard. Number 30, it may be also dictation.
No, that which we will call it in the that we will dictate when it comes, when it is called. Yes, 3.
Till number 3. Till number 3, Harish Bandareti.
This is a quantum, Your Lordship, challenged by the corporation.
E. Rupesh.
Do that.
The injuries are, Your Lordship.
Quantum is questioned by the corporation.
Yes, Your Lordship.
So, how many or what are the injuries?
Injuries, Your Lordship, get at page issues on 11 to 11. The injuries, Your Lordship.
Is it a case of
irregular lacerated wound on over frontal region of scalp and left side
head
injury.
Age
45.
Pain and agony 10,000. Pain and agony 10,000. There itself
40.
Because looking at the injuries, another 50,000 will be enhanced.
Then Millard, 4,000 rupees is taken. Only 8,000 has to be taken. Income.
Your Lordship, para 13 one said.
No. According to you, which is on the higher side? If it is not, we'll not waste time on this.
My Lordship.
We'll discuss.
Interest 9% has been given.
That we will reduce. Remaining remains to be the same. Yes, the appeal is filed by the corporation questioning the award passed in MBC number 824 of 2013 dated 7 September 2016, whereby the tribunal had granted an amount of rupees 2,29,600. Land counsel appearing for the corporation submits that the compensation that is awarded by the tribunal is on the higher side. It is submitted that the interest is granted at 9%.
Yes.
Is not granted at 9%, which is on the higher side. He has drawn the attention of the court to the heads wherein the amounts are granted by the tribunal, and he submits that it is on the higher side. Next parallel, and counsel appearing for the respondent submits that the court had rightly considered and granted the compensation. In fact, the claimant is entitled for more compensation where the accident has taken place in the year
2000 my lord.
2013, your lordship.
13,
2013 and the court had taken the income at 4,000 instead of
8,500.
instead of 8,000 as per the table. And if it is calculated on all the counts, there is every scope for enhancement. However, it does not dispute the fact that no appeal is preferred by the claimant. Next para, having other counsels on either side peruse the material. This court has perused the injuries that are sustained and the compensation that is granted by the tribunal as rightly submitted by the land counsel for the respondent claimant. The court had not granted any excessive compensation as submitted by the land counsel for the corporation. However, the interest that is granted by the tribunal is on the higher side. Accordingly, the appeal of the corporation is partly allowed by reducing the compensation from the interest from 9% to 6%, and the amount and deposit shall be forthwith transferred to the tribunal. Yes, next.
Yes, grateful, lordship.
Yes, next.
Cell number 4. Cell number 4.
Pass out. After lunch, we'll see.
Yes.
Yes, 5.
Cell number 5.
Appeal for respondent number 1. Claimant's appeal for enhancement, my lords. The tribunal, my lords, has granted 10,25,000.
It's a case of death or injury.
Injury, my lords, grievous
Will
injury.
please come to the table straight away. Where is it?
The injury, my lords, it's mentioned at page number 10, my lords.
What are the injuries?
Is my lords injury to the open reduction and reduction of fractured right acetabulum.
How many fractures?
One fracture.
One fracture,
One
40,000.
open reduction and internal fixation of left humerus.
Medical expenses, no dispute.
Medical expenses, no dispute, my lords. With regards to future medical expenses, my lords,
What did the doctor say?
1 lakh has been granted, my lords. Whereas the disability certificate clearly mentions, my lords, for hip replacement, 1
What's
lakh.
his MBC number?
887, my lords. I am challenging 887, my lords.
Pain and suffering, reasonable amount is granted, 75,000.
Pain and suffering, yes, my lords. Whereas
Then
for
medical expenses is 7 lakh.
50,000.
That is also, then food conveyance. How many days you were in hospital?
for around 1 month, my lords.
Court had rightly granted that also.
Yes, my lord.
Then loss of income during the laid up period. What is your income according to you?
15,000 is mentioned, my lords.
No evidence.
Evidence is provided. Salary certificate is given and also evidence is
Court has considered how much?
10,000. Exhibit P22 is
Which year is
the.
accident?
My lords?
Which year is accident?
2012.
What do you say on that? On the evidence with regard to the salary? Why
Yes.
not 15,000 be taken and why only 10,000?
My lords, they have produced the salary certificate, but they
Have you examined anybody in support of that?
employer has stated
Why
15,000.
the,
my
then why
lords.
the court has not considered?
My lords, actually they have considered an extra month in this file. She was granted a 1 month paid leave, my lords. Only 4 months were not lost for her. Only 4 months were lost, my lords. Here they are considered for 5 months.
So now we are on the point 15 or 10. Why not 15?
15 may be given.
So if you take
But a month may be reduced in the 4 months.
15,000 into 4. That is how much?
60,000.
60,000.
Yes. Court had granted how much?
50,000. For
Another
5 months.
10,000 difference is there.
10,000.
That's the only difference.
Yes, my lord.
10,000.
And my lords, future medical.
Then what is the disability?
My lords,
Disability is-
disability concerned, whole body disability is not given, my lords. And after
What
that,
is the limb disability?
my lords,
Limb disability is how much?
13%
and
and 14%. 13 to the left leg, 14 to the
my
right.
lords, here it's,
That is 13 plus 14.
my lords, humble submission, my lords. Soon after the 5 months, she has joined to the same work. She has been going to the same job. So that may be discarded. There is no disability in that.
Around 7%. But you resumed your work, it is not having any impact.
It
No
is, the
impact,
only
my
thing
lords.
is, my lords, that she was working as a public
That's why
relations
what we do
officer.
is, loss of amenities will increase some more amount. Will not grant under the head of loss of future income. So, loss of amenities, court had granted 25,000, will grant 40,000.
Yes, ma'am.
So 40 plus here 10 na, 60,000, 50,000 is the difference now.
Yes, my lords. And loss of future for future medical expense, my lords, 1 lakh is granted. Whereas in disability certificate, it's clearly mentioned, my lords, that 1,60,000 is required for hip replacement surgery and 25,000 for further
Accident
treatment.
happened in 2012. It's 25, my lords.
Yes.
Back, that has been.
Your client is very fortunate to get this kind of compensation. So now it is 10,25,000 plus 10,000 for legal expenses. So 10,25,000 plus 60,000. That is 10,85,000 would be the amount. Please come. Agreed with award passed on MIS number 887/2012 and dated
7th August
7th August 2015, the claimant is before this court seeking enhancement of the compensation. It is submitted that the tribunal had not granted a just and reasonable compensation. It is submitted that the court, when the evidence shows that he's earning 15,000, court had taken 10,000, and further towards loss of amenities and future medical expenses, court has not granted reasonable compensation. Next, when counsel appearing for the respondent claimant, respondent insurance company,
Yes, my lords.
submits that the court had reasonably granted the compensation and no enhancement is called for. Next para, having heard the counsels on either side. So and so. Considering the injuries sustained by the claimant under the head of pain and suffering, court had granted a reasonable amount and no interference is called for. Coming to the medical expenses, also no interference is called. Now, medical expenses, food and nourishment, the incidental expenses are rightly granted by the court. No interference is called for. Coming to the income of loss of income during the later period, it is a submission of the learned counsel for the respondent that already 1 month. You said 1 month.
1 month.
1 month paid leave was given, my lord.
1 month paid leave was granted, so he's only entitled for 4 months.
Yes,
Then evidence on record to show that the claimant is earning 15,000, court had taken 10,000, hence this court is inclined to take an amount of 15,000 as salary and it comes to 60,000. Then coming to loss of amenities, considering the disability and the evidence of the doctor, this court is granting an amount of rupees 40,000. Then I think it's a long calculation I made. 10,000 in that loss of earning you're getting, and other is like court had granted 25, and this court granted 40,000. That is only 15,000.
15,000.
15,000. And 10,000 towards legal expenses. So it would be 35,000. Not 35,000. That is, I have calculated 60.
That's
Yes,
35,000.
that is with regards to the income, my lords.
Income is 10,000 only. It has
10,000
come. No?
difference, yes.
So it's only 35,000. Then in that case, it would be 10,55,000.
Yes.
What did you write? 40,000 for the loss of amenities. And under the other heads, the court had granted reasonable amounts and no interference is called for. In the light of the law laid down in Mekala, 10,000. Altogether, the claimant is entitled for an amount of rupees 10 lakh.
60,000. 60,000.
60,000. 10,60,000.
Yes.
Accordingly, the appeal is partly allowed. The enhanced amount shall carry 6% interest. Yes, next, please.
For respondent number 1, my lords, my presence may be noted.
Respondent number 1, learned counsel appearing for the respondent number 1 has submitted his arguments in support of the award. Last one. If somebody is there, we'll decide. Otherwise,
Grateful.
Cell number 6. Venkatai Gowda K. For appellant.
yes,
PB Raj.
after lunch.
Serial number 17, Lordship. Short accommodation.
Serial number
17 is also present.
CP, why you
One
want
submission,
time?
failed submission, but my file was mistaken.
Yes,
That-
17 after vacation. If look at it, interim order is there, extend. Yes.
Much obliged.
It's okay, let it go on. Don't touch. Why should he touch? No, what he can do? No. Now what we do is, mother is not around. No, she has gone. Now you take any of us, take them to some other, like, let father not take. Let our people take them to the park or something, whatever is there, no? And let our person be there, and let our father and others say what happens. We'll see. Hmm. That's what I'm saying. No. What you do is, why the mother is here? She's there in the court. She's there in the court. She's the one. No. This said she's there. Why is she there? And why is she here? Child is having the phone. No phone. What you do is with our people, don't ask the phone.
And they're not looking for you.
Some lady officer expect to take to the park or somewhere. The father accompany her and let them do in this. It's all tutored, no? It's all tutored. Fully tutored. No, the best is, I think she should be sent to the counselor. She requires counseling. But the difficulty is, these 2 sessions we cannot do anything because there is an order of discipline. Why? That's the whole difficulty. They don't use their brain at all. What you do is now, no, why don't we do one thing? For the from the Bangalore Mediation Center, or otherwise outside also. If any child counselor is there, why don't we call them? Why don't we call them and make them interact with the child? They know the technique, what to speak. Better try now to the Bangalore Mediation Center. Call them and tell that do it and let me know what's happening. Call.
Serial number 9, this is an interim order.
Serial number 9.
This number 1, serial number 9. There is an interim.
Look at it. If it is there, send this order to the sheet. And you do this. You send the.
Madam, serial number.
Court officer? Court officer? Court officer?
ಸರ್ ಹೇಳಿ
ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 9
ಇನ್ನು ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ ವೇಟ್ ಮಾಡಿ ಸರ್
ಅಲ್ಲ ಅದರಲ್ಲಿ ಶರ ಏನ್ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್ R5 ಗೆ
ನಮ್ಗೆ ಟೈಮ್ ಕೊಡಿ ನನಗೆ ಬೇರೆ ಕೆಲಸ ಇದೆ 10 ನಿಮಿಷ ಆಮೇಲೆ ನಾ ಹೇಳ್ತೀನಿ
ಓಕೆ Court officer?
ಹೇಳಿ ಸರ್.
List number 2, serial number 9 ಅಲ್ಲಿ R5 ಗೆ ಪೋಸ್ಟಲ್ ಶರ ಏನಿದೆ ನೋಡಿ ನೀವು. MFA 4528 of 2017.
ಕೊಟ್ಟುವಲ್ಲ ಅವರ ಲಿಸ್ಟ್ ಕೊಟ್ಟೆ ಯಾರು ಲಿಸ್ಟ್ ಕೊಟ್ರೆ ಲಿಸ್ಟ್ ನನ್ನ ಕಡೆ.
R5 ಏನಾಗಿದೆ ಮೇಡಮ್? ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 9.
ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಹಾ.
237 ಅಂತ ಹಾಕೋರು ಯಾರು?
R5 absent ಅಂತ ಆಗಿದೆ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ.
ಅಲ್ಲ R5 ನೋಡಿ ಮೇಡಮ್.
R5 absent ಅಂತಿದೆ ಸರ್. ಪೋಸ್ಟಲ್ ಶರ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ absent ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ ಸರಿ.
ಆಮೇಲೆ ಮತ್ತೆ ಪ್ರಾಸೆಸ್ ಹಾಕಿದ್ದಾರೆ, ಅವಾಗ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ತಿರುಗಿ ಇನ್ನೊಂದ್ಸತಿ ಪ್ರಾಸೆಸ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ನೀನು 36 ಅಲ್ಲಿ ಕೊಟ್ಟಿತ್ತು ಅದೇನಾಯ್ತು ಅಂತ. ಆಬ್ಸೆಂಟ್ ಅಂತ ಇದೆ ಮೇಡಮ್.
ಒಂದ್ ನಿಮಿಷ ಇದೆ. 36 ಆದ್ಮೇಲೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್
R5 ಅಂತ
3624 ಅಲ್ಲ
4528 of 2017 ಅಲ್ಲಿ
ಪ್ರಾಸೆಸ್ ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಿ ಹೇಳಿ?
ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿದ್ದು 3623 ನಲ್ಲಿ.
ಅಯ್ಯೋ ಅದು 2012-24 ಅಲ್ಲಿ ಆಬ್ಸೆಂಟ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಹಾ. R5 ಗಂಗಾಧರ ಅಂತ ಮೇಡಮ್.
ಏನಕ್ಕೆ ಅದು ಹಾಕೋದು ಹಂಗೆ? ಅಟೆಂಡ್ ಮಾಡಿದ್ಯಾ ಒಂದು ಮಾಡಿದ್ರೆ
ಏನು ಕೊಡಲ್ಲ
ಅಲ್ಲ ನನ್ ತೋರಿಸಿಲ್ಲ, ನಾನು ಹೋಗ್ಬೋದು ಅಟ್ಲೀಸ್ಟ್
ಹೋಗೋದಾದ್ರೆ ಹೋಗಿ. ಮೇಡಮ್ ಕೇಳಿದ್ರೆ ನಾನ್ ಜವಾಬ್ದಾರ ಅಲ್ಲ.
ಅಲ್ಲಲ್ಲ ನಾನು ಹೇಳೋದು ಇಬ್ರು ಯಾಕೆ ಹಾಕಿದ್ರು? ವೈ
ಎಲ್ರು ಒಬ್ಬೊಬ್ಬನೇ ಹಾಕಿದಾರಪ್ಪ, ಅದೇನೋ ಗೊತ್ತಿಲ್ಲ ಫಾರ್ಮುಲಾ
ಎಲ್ಲ ಕೊಡು.
ಎಲ್ರು ಒಬ್ಬೊಬ್ಬ
ಓಂ ಅಲ್ಲಿ ನೋಡು ಓ ಮಹೇಶ್ ಸರ್
ಹಾ
ದೇವಸ್ಥಾನ ಇದೆಯಾ ಪಕ್ಕ
ಹಾ ಹೇಳಿ ಮೇಡಮ್.
ಗಂಟೆ ಹೊಡಿಯೋ ಸೌಂಡ್ ಕೇಳಿಸ್ತಿದೆ ದೇವಸ್ಥಾನ ಇದೆಯಾ ಪಕ್ಕ
ಹಾ
ಪಕ್ಕ ದೇವಸ್ಥಾನ ಇದೆಯಾ ಮನೆ ಹತ್ರ
ಎಲ್ಲಿ
ನಿಮ್ ಮನೆ ಹತ್ರ
ಮನೆ ಹತ್ರ ದೇವಸ್ಥಾನ ಇಲ್ಲಲ್ಲ.
ಮತ್ತೆ ಗಂಟೆ ಹೊಡಿಯೋದು ಸೌಂಡ್ ಎಲ್ಲಿಂದ ಬರ್ತಿದೆ ಈಗ ನೀವ್ ಒಬ್ರೇ ಕನೆಕ್ಟ್ ಆಗಿರೋದು ಆಯ್ತಾ
ಹೌದು
ಮ್ಯೂಟೆಡ್ ನೀವು ಒಂದೇ ಅನ್ಮ್ಯೂಟೆಡ್ ಅಲ್ಲಿ ಇರೋರು
ಹೌದು.
ಸೌಂಡ್
ಎಲ್ಲೂ ಇಲ್ಲಲ್ಲ ಮೇಡಮ್.
ಹೌದಾ ಇವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ಮ್ಯೂಟ್ ಮಾಡ್ಲಾ ಆಮೇಲೆ ನಾನೇ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲಲ್ಲ ನಾನು ಇವಾಗ ನೀವು ಒಂದು R5 ಏನೋ ಹೇಳ್ತೀನಿ ಅಂದಲ್ಲ ಅದಕ್ಕೆ ಇದು ಮಾಡಿದ್ದೆ.
ಸರಿ ಸರಿ ಆಯ್ತು ಓಕೆ ಅದಾದ್ಮೇಲೆ ಮ್ಯೂಟ್ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು.
ಓಕೆ
Continue the list. Continue the list.
Serial number 6. Venkatagowda ke. List number 2, serial number 6. Venkatagowda ke. P. Raju for respondent.
I'm representing.
Ready?
No, claim petition dismissed, my lord. In this case.
We'll pass orders when they're not interested to come. What to do? The present appeal is filed. Agreed with orders passed in ECA number 13 of 2016 dated 3rd December 2016, whereby the claim petition is filed by the claimant is dismissed on the ground that the employer-employee relationship is not established. This matter came up on 8/4/2025. As there is no representation on behalf of both the parties, the matter was directed to be listed today under the caption dismissal today, either in the morning or in the morning as well as in the forenoon as well as afternoon. There is no representation on behalf of the appellant, and this court is passing the order on the merits of it. The tribunal, for giving such a finding, while giving the finding, has observed that as per the as per the investigating report exhibit R2, submitted by the insurance company, the claimant is not at all working in the estate of the first respondent in the year 2001. but he met with an accident in the month of May 2022. Therefore, absolutely there is no material except the oral say of the claimant that he was working under the first respondent. And on 9/2/2001, he met with the accident. According to the petition case, after the alleged accident, the claimant has been either treated in the government hospital at Bonibidu or Mudikere for the injuries sustained by him. In the evidence, the claimant stated that after the incident, he has taken treatment at Mudikere and thereafter he went to Tamil Nadu, wherein he has taken treatment from the local doctor. Even to substantiate the said fact, nothing has been placed before the court. But the tribunal has also observed that the claimant has not examined any co-worker to show that he was working under the first respondent on 9/2/2021. The claimant has also not made any attempts to examine the doctor who had treated him at Tamil Nadu. In the absence of any documentary evidence, it cannot be accepted that there is employee relationship between the claimant and the first respondent. Further, the court has also observed that the owner has given a statement before the investigating agency that the claimant is not working with him in the year 2001. And looking at all these facts, the court had come to the conclusion that the claimant has failed to substantiate his case that he was working with the first respondent, and during the course of employment, such accident has happened, and accordingly dismissed the petition. Land counsel appearing for the insurance company submits that the court had rightly considered the evidence, rightly passed the order. Next, for having heard the counsel for the insurance company, this court has perused the material on record. The court had rightly observed that there is no material to show that there is employee relationship between the claimant and the first respondent, and court had rightly dismissed the petition. This court finds no reasons to interfere. Accordingly, dismissed. Next one. Next one.
For order serial number 7, Ashok Mehta.
Appearing for a petitioner.
I appear for respondent in this case, madam.
Yes.
I filed power yesterday and copy is not served on me, and I request the council to.
It is submitted that by the council, by the respondent that he has filed wakalat recently, and
Yesterday.
Yesterday, and he'll come up with objections. This is matter after vacation.
And submission. madam.
Order earlier granted.
The matter may be referred to mediation, madam. There are possibilities of.
No, my lord, she has to come from Batkal, which is 500 kilometers.
Any mediation is there?
So not like that, my lord. If she is not really willing to join the petitioner or the respondent hearing,
Mediation
we can.
Compel them for the mediation. When she's staying somewhere there, if you are interested, you should go there for the mediation there.
The thing is that, my lord, I have been many times to that place, my lord. She is not coming forward to talk to me. At least.
That's what I'm saying. You tell about the mediation center which is available near to her place of residence. There you can go. We'll refer.
No, my lord. My submission is that, my lord, at the initial stage itself, if she is not willing for to join with the husband, let her.
That you can decide before the
Let at least let her to be present before this court, my lord. At least, at least for next date of hearing, my lord.
Next.
Serial number 8, Hari Prasad.
Intermodal order granted is
For the
Eight.
petitioner, fresh memo has been filed yesterday, madam. With regard to, fresh memo has been filed with regard.
Oh, sir.
It is served on advocate
Submitted that as per the order
Rakshitar.
passed by this court. They have served the counsel, Mr. Shri Rakshit R. And a memo is filed to that effect. Memo is taken on record. Registry is directed to print the name of Mr. Rakshit R. This is matter after vacation. Intermodal is there. Intermodal earlier granted is extended till the next.
Great.
Number 9,
Appear for the appellant, my lord. R5, the owner, Shara is not forthcoming in the cognizance. Notice was issued.
Non-furnishing of so and so.
Earlier, notice was issued, my lord, by RPID. Shara is not forthcoming, my lord. Postal Shara.
Absent.
R5, owner.
Yes. The petitioner shall pay the process within a period of, the appellant shall pay the process within a period of 1 week, or else the appeal against Starface stands.
My lord, my lord, permitted to take substituted service, my lord?
Or take substituted service.
Please, please.
Permitted to take out notice by way of substituted service.
Please.
And he submits that he'll file an appropriate application. Yes, 10.
10.
Appellant file a dispensation memo for respondent number 1, my lord.
The memo is filed, same. The notice to R1 is dispensed with. Admit post for final hearing. Yes, next 11.
Cell number 11. Cell number 11.
No representation after vacation.
Cell number 12.
Filed application for.
Yes, IA number 1025 is filed seeking substitute service of notice. Yes, on or before.
On or before 3/6/17/6.
Yes, next.
Please.
Cell number 13. Cell number 13. Admission
petition
or
is case
Shashidhar.
You have an interim order? You have an interim order?
Yes, madam.
Post this matter after the vacation. Interim order earlier granted is extended. Next 14.
Cell number 14. P. Nataraju.
Yesterday's matter.
After vacation.
Interim order may kindly be.
Interim order earlier granted is extended after vacation. Yes, next 15.
Cell number 15.
Your Honor, already the respondent has entered upon this case, Your Honor.
Today you have this.
Yes, Your Honor.
Admit post for final hearing. Not final hearing, let it be in the same caption, post after vacation.
Certainly.
All these matters. Interim order earlier granted is extended.
Cell
Yes,
number
16.
16.
This also look at it. If interim order is there, extend. 18.
17 urgent. 18.
18 also same order.
But interim order not granted, that's why.
Granted.
First time, last time I have served a notice, not as directed by this court, blood. Hence, it is also served, blood. Now, blood, the interim order, blood, court other day.
You don't know if I hear the matter whether interim order or final hearing, now it is.
But at least that will be interim order, it can be called after vacation. Interim, then.
Interim order has to be on the merits of the matter. If you want me to decide on the merits of the matter.
But what happened the other day, the summons was
That's
issued,
why
I served.
suppose you can take a chance after vacation, 19.
Interim order till then may be granted, not because.
I was not convinced, I remember this. 19.
Cell number 19.
Yes, after vacation, look at it. If interim order is there, extend. 20 also
Cell number
same.
20.
Interim order is not there, Malice, in 20,
It is coming a fresh matter.
Fresh matter, my lords.
Give 20.
Please, my lords. Respondent has filed petition, my lords, before third additional senior civil judge, Bangalore Rural District, my lords, for restitution of conjugal rights, my lords, in MC number 746 of 24. I am seeking transfer from Bangalore to Kundapura, my lords, senior civil judge.
To?
Kundapura, my lords. Distance, my lords, 480 kilometers, my lords.
No,
And
submitted
I have, the wife has
presentation
already
is by
filed divorce petition before.
Transfers from Bangalore to Kundapura. It is submitted that the distance between both the places is
450 kilometers.
450 kilometers, same. So and so, they shall be stay of all further proceedings. Hand summons by 4th. Memo shall be filed. If it is filed, list on 5th, or else the stay granted by this court stands vacated. Next 21.
Please, grateful.
22.
This is 21. 21.
21.
No representation after vacation.
Cell number 22.
My lordship, my lordship, I appear for the petitioner, my lordship, a small submission. The petitioner here, she's the wife, lordship. An MC petition is filed at Bangalore, and she has filed a criminal maintenance petition, criminal miss at Sakleshpura, my lordship. She is with custody of the minor child, which is just 2 years old.
So she's seeking transfer from where to where?
From Bangalore, seeking transfer from Bangalore to Sakleshpura.
To the Sakleshpura. Distance?
It's more than 250 kilometers.
Yes, same order. Bangalore to Sakleshpura. Distance is?
More than 250 kilometers.
250 kilometers, sir. Even with regard to the hand summons also, like in the other case. Yes, next.
Cell number 23.
My lordship, the stay may be granted.
Stay granted hand summons like in the earlier case. Yes,
23,
MFA.
This company subpoena, my lord, in respect of injury case, quantum alone is in challenge.
We'll have it, all these matters after vacation because other matters are there. After vacation, 24.
24.
All the matters after vacation of this list, all this list after vacation.
Yes.
Madam, serial number 30, my lord, dictation.
Serial number?
30, yesterday matter, dictation. Today.
30, take this bundle out, 30. Yes.
My lords, my make good submission.
Serial number 26, my lords, in list 2.
Huh?
It's a case of death, my lords. Kindly date may be fixed, my lords.
It is a 2024 matter. 2024 matter.
It's a case of death, my lords. Nobody is there to take care
Where is Mr. Umesh? Are you ready?
Cross objections, they have not served the copy. Delay, there is 2000 days delays.
That to be Lenio do it. If it's a case of death, please cooperate with the, for this matter 26.
The minute may be called after vacation, immediately after vacation, date may be fixed. I will also, I have not filed wakalat in the connected matter.
I will give you permission to find the wakalat for next.
I leave it.
Yes.
If it
Take
is
out that 26.
immediately after vacation, it could be some date immediately after vacation.
I'll hear this matter now. Yes. 26 and 30 take the bundles and remaining cases after vacation. Entire list. Entire list. Call list number 3. This also keep it, sir. I'll pass orders later. Yes.
List number 3. Serial number
No,
1.
do one thing. Call that the 24. What she's saying about the death case.
26.
Already it is no. This is not the one. Next case.
Serial number 26, my lord.
This also keep here. I'll dictate the order. Then we'll do one thing. I'll dictate it later. This matter accordingly. The appeal of the claimant is allowed, enhancing the compensation from 6,79,346 to 7,50,346. The enhanced amount shall carry 6% interest. Yes. Next matter.
5 lakhs, 27,552, 7 lakh 50,000. 5 lakh.
Look at it. Yes. What about this? 20? 26. That there is a delay of 2,197 days. For the reason stated, delay is condoned on the condition that they are not entitled for interest for the set period. Yes. On what ground the insurance company is before this court?
I will not be able to. 26, your lordship said that day.
26.
Please.
Yes, next. Call list number 3.
List number 3.
Not that
Serial
2 lakhs case is concerned, my lord. He wants interest, my lord. The company is not agreeing for interest.
serial number 1.
So, but and even on their concession only the 2 lakhs I have passed. Because if it is Mallikarjun's case as to be applied, in fact your compensation would come down.
2 lakhs, then 2 lakhs.
That's without interest. Then evening you can come to the Lokadal. Yes. Yes.
Okay.
List number 1.
Yes.
Serial number 1.
List number 3.
List number 3, serial number 1. Vijay Kumar.
Yes, Pradeep, what is this?
Please, my lord.
For enhancement?
Two connected matters, my lord.
Hmm.
Enhancement only. 7745 of 16, arising out of MEC, 6766 of 2013. Para number 17, my lord.
6766.
6766 of 13. Global compensation of rupees 40,000. Para 17, my lord, 17. Internal page 23.
Yes.
Madam, the injuries are, my lord, tenderness present over the left hip joint, tenderness present over the left lower back, suture wounds present over the left parietal region. The compensation, my lord, total 40,000 has been awarded, my lord.
No.
Global compensation, no doctor evidence.
Number 6765.
6766, my lord.
That is next page.
MFA 7745 of 16.
MBC 6766.
6766.
Para number 17.
17.
Tenderness present over the left hip joint, tenderness present over the lower back.
Suture wound present over
the left parietal region. Doctor, the injuries are simple in nature.
Please, ma'am, the petitioner has not examined the doctor. Therefore, the tribunal has awarded 40,000 global compensation.
It could be.
Another 20,000 will be granted. Not easy. Parallelist first matter.
60,000. It is submitted that the insurance company is ready to pay an amount of rupees 20,000 over and above the amount of 40,000 that is granted by the tribunal. What we'll do is, today we are having, we'll again fix it for day after tomorrow. Lok Adalat, day after tomorrow, date is 24th. 24th, I think. 24th. Yes.
Connected matter 7746.
How much is granted?
7746 of 2016, my lord.
How much is granted?
Para 19, my lordship. Injuries, fractures are there. I will, table is concerned. my lord.
Para number?
Para number 19, my lord. 6768 of 2013.
6768.
Table is on that, my lord. Para, internal page 35, my lord.
How much? 5,45,000.
5,45,000,
What are the
521.
injuries?
Injuries is concerned para 19, my lord, internal page 27. Forearm fracture, my lord, and head injury. CT scan shows normal steady. Abrasion over the upper eyelid and left eye. Conjunction of the left eye, my lord.
So how many?
Only one fracture, my lord. Other are injuries.
We grant 60,000. Next, loss of income. How much is considered?
Income considered 7,000, my lord.
Which
3
year is
months.
accident?
3 months as awarded, my lord.
Which year is
The
that?
date of accident is 17/10/2013. 8,000 rupees.
8,000.
8,000.
And how many days he was in hospital?
Hospitalized, my lord. 18/10/2013 to 25/10/2013. 7 days, my lord.
So 8,000 into 3.
Please.
24,000. Medical bills as it is. 3,38,641. Then what is the disability?
Disability, my lord, 12%, my lord. 52 years.
Evidence of the doctor is?
12%, my lord. PW5. Doctor.
For doctor, quoted.
12%, 68% to the left upper limb, 23% to the whole body, the doctor has assessed. The tribunal coming to the conclusion that, my lord, PW5 is the medical records, the injury sustained by the petitioner during the treatment, it just necessary to consider the 12% of the whole body instead of 23%.
Why?
Not given any reasons. Not giving any reasons, my lord.
We'll take 20%.
Please.
Future in loss of future income.
Disability assessed, my lord, in the year of 2015. That's what the MSCT has considered 12%. Para internal page 32 may kindly be seen.
Internal page?
32. Second, according to him, the petitioner has sustained permanent physical disability to an extent of 68% left upper limb and 23% of the whole body disability. But in his cross-examination, he has admitted while assessing the disability on 6/3/2015, he has discussed with the treated doctor by name Dr. Venugopal, but he has not given concurrent in rating and with regard to the assessment
On the
arrived.
basis to come at 8%, we'll take 20%. 8,000 into 12 into what is the?
Multiplier 11, my lord, 52 years.
Into 2500. It comes to 2,11,200. Then loss of amenities, how much is granted?
Loss of amenities, my lord, 20,000, my lord, including conveyance, nourishment.
No, that
Item
is
number
on the
5.
lower side. So what we'll do is loss of amenities 30,000 will grant, and incidental expenses. How many days you said?
7 days. 7 days, my lord.
We'll grant 10,000.
Please.
Future medical expenses in
15,000 awarded.
surgery.
Please, my lord, surgery.
Another 5,000. That is 20,000.
20,000.
comes to 6,93,841. How much is awarded?
5,45,521.
5 lakh?
45,521.
It is submitted that the insurance company is ready to pay an amount of rupees 6,93,841 against 5,45,521 awarded by the tribunal, and they'll come up with a joint memo. Same, this also all the matters today, whatever joint memo, day after tomorrow. That's on 24th. Yes, next.
My lord, in this case, my lord, our liability is 20%.
In which case?
This case, these two cases.
Who are the others?
Other company is there, my lord.
Who is the counsel? Inform them also.
Reliance General Insurance.
Tell them. Yes, next.
Cell number 2, Omesh.
After vacation.
Cell number 3. Cell number
Why
3.
Yeah. My lord, I pray for after vacation, my lord, some throat problem. That's why, my lord.
Yes, after vacation.
Cell number
Yes,
3,
three.
Omesh.
This is also after vacation. 4.
Yes.
Number 4,
Yes, Shivanagoda.
PC Shivanagoda.
What is challenge?
Negligence and
On the ground?
negligence on the part of the other vehicle.
No, after vacation. Next. 5.
5, implication of insured vehicle fraud has been played, my lord.
After vacation.
Cell number
This-
6.
After vacation.
It's the injury case, my lord.
Cell
Which
number
one? 6.
7.
6.
That's what 3778.
Not 3778. We have come till 7 now.
No.
That is MFA 3180.
3180.
After vacation, both for
Please.
yes.
8.
Appear for the appellant, my lord, after vacation.
So yes, 8.
After vacation.
3778, which you are referring
Please,
to.
please.
Give the fine.
It's an injury case, my lord.
Hmm.
Doctor has assessed the disability of 20%.
1 minute.
Puncture wound was of the left aspect of the left
Come to
arm.
the table.
Table, my lord. Pain and suffering 35,000 is granted.
Do you think that joint memo will be filed in this?
Insofar as my opponent is concerned, my lord, it is very difficult to say.
That's right. Why do we waste time? Yes, after vacation. Next. 9 also after vacation. 10 after vacation.
16.
Cell number 11.
Yes, 11, Pradeep.
11.
You are on what ground?
Quantum only.
Quantum only?
Please.
You are prepared?
Synopsis is just
Ah.
prepared.
Take that, court officer. Case of death? No.
No injury, my lord. It is arising out of MEC 537.
Hmm.
537 of 16, my lord.
Hmm.
Table is on but internal page 18, my lord.
Yes. Yes.
Para 20, my lord, the petitioner has sustained head injury and right tibia and fibula fracture.
How many are the injuries?
My lord, he has sustained head injury, right tibia and fibula fracture.
So under the head of pain and suffering, he requires another 60,000, another 30,000, 60. Next. Loss of income during the later period, how much was considered?
Loss of income, loss of amenities granted, my lord. Loss of income.
Loss of income was considered at
7,000 rupees, my lord.
Huh?
7,000 income has taken.
How much it should have been? Which year is the accident?
Accident occurred, my lord.
On it's a MVC of 2016.
Please,
Date of
28,
accident,
28/11/2016.
So we'll take 9,500. So 9,500 into 3. It comes to 28,500. medical expenses as it is. Then coming to loss of future earning, what is the evidence of the doctor with regard to the disability?
And 50% as considered, my lord.
Huh?
50%.
Is considered as a disability.
50%.
What was the doctor's evidence?
Head injury is confirmed 50% only assessed. CW1.
Disability assessed by the doctor 50% to the whole body.
Hmm.
As it is taken. Now we have to take the, along with the income we have to consider. We are considering at 9,500 into 12 into 17 into 50.
Actually, doctor assessment of 27%.
No. I just know I've seen.
It's a
Even as per you also the same.
the transfer brief from HN Keshav Prashant. It's a transfer brief from HF Keshav Prashant. Some mixed file is there. It's a mixed up with other connected matter also. 535. That's the only question, my lord.
It comes to 9,69,000.
But
Court had granted 7 lakhs. It comes to 9,69,000. So your appeal will go. Loss of amenities for 50% disability.
No, sorry, third list. Allah.
Loss of amenities for 50% disability, 30% is on the lower side.
Actually, my lord, the doctor assessed 17%.
Let us look
Internal
at
page 16.
Come to the order. Yes.
Internal page 16, my lord. The tribunal has considered 50%. My lord.
Where do you get that?
Internal page 16, D, my lord.
Para number?
D, para D, my lord. Para 20 onwards, there is a discussion. A, B, C, D, like it has in
Initial implant removal during the course where the denied various and that when compared to whole body, the disability is 50% of the disability certified by PW3 as an outpatient. It is not true to suggest there is no problem.
But 17%, the D, in the D, my lord, there is a discussion. Because of the said disability, he has difficulty to sit cross-legged and squatting and running. He has 17% disability on right lower limb. Locomotor function permanently.
Now, where from this 50% has come?
Actually, in first instance, my lord,
No, it is an injury to the head, isn't it?
head injury is also there, my lord. Actually, but, whether the judgment has reviewed or not, I don't know. In the, it is with my hand, my lord, it is showing that 5,53,000.
We'll have it tomorrow, this month.
Tomorrow. 10,10,000 actually, my lord, as for synopsis. But in the page number shown, so my lord, 5 lakh something is there.
Tomorrow.
Please.
This matter tomorrow. Yes, next. Yes, next. What about this?
Tell number 12.
Enhancement.
My lord, I am for appellant, my lord, only for enhancement, my lord. Since the tribunal below misread the doctor evidence and consider only part of the disability aspect without noticing the other deposition of the doctor. My lord, the disability consider is only 10%, even though there is a more than 36% over body disability. Extent is of the year 2016 is the 25 years old driver. My lord claims to be earning 12,000 per month.
Para number 16, Mr. Shastri.
Yes, my lord.
16.
The petitioner has claimed compensation of the 20 lakhs under the head of disability. Due to accident, he sustained a permanent physical disability. PW stated that he is unable to do work as prior to the accident. In case of petition, in this case, the petitioner got examined Dr. B.V. Vishwanatha, PW2. PW doctor deposed that on so and so. Petitioner came to Victoria Hospital Disability Assessment. PW2 deposed that examination he found that sustained 35.21% to right lower limb and 17.60% to the whole body. 37.9% to the left lower limb, 18.54 to the whole body. Total body disability is 36.14%. PWT or deposed exhibit P say 19 OPD card, inpatient case sheet, X-ray film. In the cross examination by counsel for respondent number PWT stated that petitioner has taken treatment.
1 minute. In this case, doctor has proposed that the claim extend 35 point, take the numbers 35.21% to the right lower limb, 17.60 to the whole body, then 37.09 to the left limb, and 18.54% to the whole body.
Tribunal consider only first part. That is why this mistake happened.
So now what the tribunal did in the first
10%.
part, 10.60, court takes 10%. There should be some basis for that. Generally, the limb disability,
Please, madam.
we are kind of calculating 1/3 of the limb disability. So for both the limbs, if you calculate, for example, this
72%.
35.21 and 37.09. It will be 70.30.
72 point.
72.30. It will come around 24. We'll take 24. So, pain and suffering.
My lord, I have no grievance.
Rightly granted.
Amenities, my lord, required because he is a 25 years old a driver and.
For calculation purpose, I am repeating. Calculation. 33,954. How many days he was in hospital?
My lord, first occasion 24 days. Thereafter 12 days, my lord. After 1 year, my lord, since he is totally bedridden for 1 year, my lord, he again admitted to the hospital on 10/1/2017, my lord. After 1 year, my lord, total 24 days and
Total
12
40.
days.
40,000. Then loss of earning during which year is the accident?
16. 10,000 is considered, my lord.
9,500.
9,500.
My lord, since he is a driver, my lord, the 1,000.
Is it so?
Since he is a driver by profession.
Yes, my lord, driver.
40,000. That's what court has granted.
Yes, I have no grievance.
4 months has granted.
Huh?
4 months, 40,000 has awarded. My lord. The MSCT has considered 10,000 per month as income.
For the permanent disability, we have to take 10,000 then. 10,000 into 12, what is the multiplier?
17, 17.
17 into 24 by 100.
1,68,000.
10,000 into 3. 24%. 24.
It comes to
89,600.
Then what else is remaining?
Loss of amenities has not awarded.
Loss of amenities, how much?
Well, 36% whole body disability. Well, 25 years old boy, my lord. He is unmarried, my lord. Unmarried. The doctor's evidence.
954.
He is unmarried, my lord.
954. 40,000. 40,000. Still
6,63,000.
6,63,554.
No. It comes to 7,35,000. 7,03,554.
33.
Pain and suffering 70,000.
Medical expenses has to be added.
Medical as it is. Nourishment 40,000.
33,594.
Nourishment 40,000.
40,000.
Loss of earning 40,000. Permanent disability 4,89,600. Loss of amenities 30,000.
7,03,000.
7,03,554.
554.
It is submitted that both the councils. by the insurance company is ready to pay an amount of 7,03,554 over and up against 3,57,000, and they'll file a joint memo in that regard. 24. Just wait till end. Next 13.
Number 13.
It is not well.
It is about what? Enhancement, we will see. It's good for your client that he get. No, whatever is the best for him will happen. A senior need not be there. After vacation, yes, 14.
Till number 14.
Yes, Mr. Krishna Swami. 14.
Till number 14. Madhava Reddy VN.
Not your case.
In cause list is not listed. In cause list that is not listed.
No, I am reading from the cause list only.
Till number 14.
Exoneration. Oh, insurance company is exempt. After vacation, next 15.
15.
15 after vacation.
After vacation.
Yes, after vacation.
Till number.
Claimant respondent.
Next
Till
16.
number 16.
Yes, Ms. Shivanagoda.
Well, the ECA case, no deal.
No deal.
ECA case, no deal.
Then it's a driver himself.
Please.
After vacation, yes, 17.
Till number 17.
For applied only for fixing the liability to the insurance company, pay and recovery advocate, permit violation, the vehicle damages case, sir.
Interest 9% is granted, that has to be 6%.
How can it be? Your appeal is not there.
That the appeal is dismissed, the claim petition is dismissed against us.
Claim petition.
No opportunity.
Use that. Use the file.
And my lord, towing
Yeah,
charges
41,000 is
and
there.
towing charges and repair charges, the other damages.
Want all that after vacation. If you want only pay and recover now.
Yes, well, pay and recovery.
The agreed with the orders passed in MBC number 6696 of 2011 dated 30th December 2013. The claimant is before this court. The claimant is particularly agreed with the order of the tribunal, whereby the liability is fixed on the owner of the vehicle, but not on the, and where the insurance company is exonerated. Land counsel appearing for the claimant submits that. Where is that particular finding?
Well, the para number 15 of the judgment.
As the vehicle was flying contrary without a permit and contrary to the terms and conditions of the policy. As such, the insurance company is not liable to pay the compensation. Land counsel and the owner is held liable. Land counsel appearing for the claimant submits that in the light of the law laid down with the Honorable Apex Court in Rani versus
Rani
also,
versus
the,
National Insurance Company.
Rani, what is that?
Amrutpal.
Amrutpal's case, the insurance company is still liable to pay the compensation. Next para, land counsel appearing for the insurance company submits that the compensation, the interest was fixed at 9%.
No,
and
6% only.
6% only. So and so. It is submitted that the tribunal had rightly held the owner to be liable to pay the compensation. Next para. Having heard the counsel's on the side, there is the material on record. The only ground on which the insurance company is absolved from the liability is that there is no permit in the light of the law laid down in so and so. Till the insurance company is liable to pay the compensation and record the same amount of the vehicle. Accordingly, the appeal is partly allowed, applying the principle of pay and recover. Yes, next.
Number 18.
Please.
Pieces.
Insurance company appeal challenging the quantum of compensation on the ground that the major sons are the claimant. And another one, 50% monthly income was taken as this thing. 13,500 rupees income was considered. For the year of accident was 2017.
List this matter as part heard tomorrow. Cordial and counsel for the appellant. No representation for the respondent. Yes, 19.
Till number 19.
Contributory negligence fixed on the claimant.
Yes, after vacation. Yes,
Till number
20.
20.
Damages to the vehicle. No? We are preferring for enhancement. No?
Yes, Pradeep. Please go.
The vehicle IDV, insured declare value itself is,
But as per final bill,
not RW1, where someone the insurer of that,
No. Is there any scope for enhancement?
no, my lord, there is no scope.
List is matter after vacation. Yes.
Till number 21.
After vacation, it may be taken up, my lord. It will not be
Quantum.
settled in the local.
Quantum.
Quantum, we will calculate it, not,
No, percentage of disability is more, my lord.
that's what we will calculate.
65% is.
We'll look at it.
Evidence
The
file
file.
settlement. Doctor evidence.
So first let us see MFA 7115, which is MVC
625 of 2018. 625.
Where is the table?
Para 32 of the.
Para
Injury,
32.
please, injury para 21.
So how many are the injuries?
1, 2, 3,
There are 8
4,
injuries are there, my
5,
lord.
6, 7. 7,
So another 30,000 under the head of pain and suffering.
please.
Then medical
Medical ex-
expenses
3,56,086.
as it is.
Attendance conveyance
How many days he was
Six.
in hospital?
19 days.
Attendant nourishment.
Conveyance, attendance, nourishment, totally 14,000.
Total how much is granted?
14.
8 plus 6 is granted.
14,
8 plus 6 is granted. We'll grant 20,000 round.
please.
Then loss of income during laid up period.
So
Which year is this?
17 accident,
10,000.
no, 11,000.
11,000. Period 11 into 4. 44,000.
Please.
Then
20% disability,
come to this loss of future earning.
please.
Come to the evidence of the doctor.
Para
65% is deposed.
Para
But we'll look at
20,
it.
30 of the judgment.
Para number.
Para 30 of the judgment.
Please read.
Podam.
PWN has sustained so and so. He has stated that there is shortening to the extent of 10%.
10%.
Case sheet so and so.
It is pertinent to note here that PW1 has
Disability, however, she has stated, where did he stated that it is 65%?
doctor evidence, my lord.
You have the evidence?
No, that's an.
Where from you are saying?
Judgment adrille ade paradalli ಇದೆ.
Yeah.
Para 30 only it is the referral.
He was done wound debridement and suturing. Guidelines from the central government. Where do you get? I'm not able to see 60%.
60% was not 20%. Says, doctor has taken opinion, clear opinion of the PWN sustained the partial.
At para 30
disability.
you are reading. Para 30.
Please.
Read.
End para para 30 end.
Para?
Para 30 end.
End,
That is in page 21.
I am of the clear opinion that PW1 has sustained partial physical disability to the extent of 20%, especially keeping in view.
Disability given to the doctor when compared to the whole body and degree.
First of all, what is a whole body disability according to the doctor? The limb disability?
65% he has
Limb
been-
disability.
Limb disabilities, he told us 65%. my
Even
lord.
that.
The nature of injuries are different, my lord. It is not a bone fracture injury. Fracture
Right.
injury is also there. And
Even assuming that 65% of the limb disability,
It comes
another
to
2%.
No, it will not come, my lord. For the bone injuries, bone fractures, it comes 1/3 of the particular limb, my lord. He has other injuries. Court may be go to the injuries, my lord. I'll read the injuries, my lord. Fracture of left condyle, tibia, fibula, and this right clavicular subluxation, right acetabulum.
No,
For
please
that, it is
understand.
1/3, my lord.
Please understand, it is as per the evidence of the doctor we take it. Your
I-
doctor said It is whole, the limb disability is 60%.
Limb means it is only for the bone fracture, my lord. Other injuries I'll read, my lord. Pelvic injury with penis injury with testis injury, that is also is there, my lord.
But
And a
it
cervical
is not
spine injury is there.
injury, for that we are granting 1 lakh. That is, that comes under parent suffering. Your sustained disability by which injury? For that, the doctor said it is 60%. To the limb. Whole body will be 20%. We will take 20%.
This will not be considered as injury, my lord. This, limb, my lord.
Please read the doctor's evidence. According to
I don't
him,
have. That's
it
why.
is there. It is there. Read it.
PWS2, sir.
PW2, PW3.
Huh?
PW3. Doctor.
Give to Mr. Shivanagowda.
PW3.
PW1 doctor.
This is the MFA of 2021.
Please, my
If
lord.
you leave it like this, it will come after 10 years.
After
I should
vacation,
have-
it maybe I'll be ready and I'll argue it, madam.
No.
Injuries are more, that's why I'm arguing.
You can also read. You can go that side and you can also read from the evidence.
Madam, in 626, evidence of doctor say 20% disability only. But the doctor says that the left lower limb, insofar as 625 is concerned, 626 ಅಲ್ಲ
625 only.
ಮಂಜುನಾ fracture of tibia so and so ಇಲ್ಲಿ ನೋಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ disability so and so ಇಲ್ಲಿ ಬಂದು 80% plus 35%. 35% disability is given. ಇಲ್ಲಿ ನೋಡಿ madam, this is your doctor evidence I am saying, not mine.
35% to the whole body, he said.
Here in the
626 ಆದ್ರೆ 20% disability doctor says. 626 doctor has stated 20%.
No, we are looking at 625.
625 means 35% disability.
To the whole body or the limb?
Total disability in respect of left lower limb 35%, hence need important so and so. He has not assessed the.
If it is only 35%, then it comes to 10% to the whole body.
That's the reason court has taken. It is the doctor evidence, it is not our evidence.
So court had rightly taken 10%.
Kindly, it may be a bit after vacation. I'll argue the matter. I'll keep the.
If it is if you don't want disposal for your client, then nobody can help. Yes, list after vacation. Yes, 22.
Cell number 22. What is it?
This also after vacation. 23.
23, my lord, there is another connected matter from my side, 3788/22. Kindly have it after.
After vacation.
Cell number 24.
After vacation.
23 long.
Yes, first, next matter. Yes.
List number 4.
What about this?
Cell number 1. Mr. Shivanagowda.
Please. Examination case. Setup.
Any calculation made?
Claim petition is no liability as pictured against the insurance company.
After vacation. 2.
Extra.
Cell number 2.
That is
Also same.
Please.
Mr. Hegde.
Yes, 3.
Cell number 3.
What about 3?
No permit, madam, they have to take steps.
Uh-huh.
No permit, madam. Liability issues there.
Oh, notice has to go.
Notice has to
In this, for steps, the notice to R2 is yet to be served. The process shall be paid within 1 week from today, or else the appeal shall stand dismissed against R2.
Cell number 4.
What about this?
Permission of PF for the first time to order and to.
Yes. Have any idea on this? We'll see.
It is for enhancement.
Give that.
Cell number 4, sir.
Please. 2019 accident, Mala. 2019 accident.
Pain and suffering, what are the injuries?
That's what we want to discharge somebody. The injuries are total amputation of fourth toe of left foot.
Near total amputation of fourth toe of the left foot.
Please. Exposing
Exposing
of
the
the underlying
underlying
crust
crushed
tissues
and four.
and bone, bleeding, laceration present, so and so. Blood disability was assessed by the doctor. Photo,
So pain and suffering 60,000.
please.
Medical expenses.
13% disability was assessed.
According to the doctor, how much?
Doctor says not 13%. Court has taken 2%. It should be 5%.
Why 5%?
Toe amputation, not as scheduled.
No.
As per the ECA schedule, it is 5%.
No. According to the doctor, the limb disability is
13% to the 13% to the whole body.
So why not we take that?
But it is on the hair side, Milad. With the amputation of tibia fibula itself is at 13%.
It comes around?
For the fracture, it is only a toe amputation. Therefore, Milad, it is then the exaggerated.
2% is on the lower side.
It is 2 on the lower side.
We'll take 8%.
Please.
So this loss of income during the later period, which year is the accident you said?
2019.
Then 14,000. 14 into 3.
What has happened, Milad? They have produced on the exhibit, salary certificate. Exhibit 14 and 15. Stating that he was earning 25,000. No supporting document was placed. He was aged about 25 years at that point of time. Court has taken notional income of 14,000 only.
14 only taken?
Please.
But the court had the loss of income.
2% income was taken, the disability was taken. Therefore, the income was reduced.
Yes.
14,000
Next,
to 8%.
loss of future income. 14,000 into 12 into what is the
15? 18
multiplier 18 into 8 by 100.
8%. And 2,41,920.
2,41,920.
Please.
Loss of future, loss of amenities.
Later period 14,000 is granted, that has to be enhanced.
42,000 is granted.
Please.
Loss of amenities.
15,000 is granted, another
15,000.
Please.
Then attendant conveyance. How many days he was in hospital?
I will have check. Medical expenses.
Inpatient from 6-2 to
20.
19-2. 6-2 to 16-2 to 19-2 is only 3 days.
3 days, another 21 to 27. That means
7 days.
7 days.
Reasonable amount.
So 10.
No future operations.
No future. It is an amputation question of. It's 15 minutes.
It comes to 4,90,487 against 2,41,047. And it is submitted with the insurance company that they are ready to pay an amount of rupees 4,90,487 against the award amount of rupees 2,41,047. And they'll file a joint memo in this regard, 24th, before the Lok Adalat. Next.
Then number 5, R. Gopal,
No,
Sir Appellant, Vishwanath Pujari.
For an enhancement,
enhancement.
give the file.
31,000 ಹೇಳಿತ್ತು ಅವ್ರಿಗೆ 31,500 we had offered.
Where is the table?
Millards, in the pre-conciliation, we had offered 31,000 millards.
31,000. Let's just see, we'll make the calculation.
That's page 23 of the judgment.
What are the injuries?
Open comminuted fracture of distal femur right,
Hmm.
shortening by 1 centimeter. 20% to the limb, 8% has been taken.
Only one fracture.
One fracture.
So the pain and suffering is
50,000.
Medical expenses,
As per bills, millards, 27,600.
loss of income, how much was considered?
3 months, millards, 11,500 has been taken. We had offered 4 months, another 1 month.
So what is, as per the table, how much?
Millards, he had produced his salary certificate. As per that, 11,500 has been taken.
11,500.
11,500.
So 11,500 into 4
Please, millards.
comes to 44,000. Huh?
Please, millards.
$46,000. Then what about the disability?
8% has been taken, millards. Doctor has opined 20% to the limb. 8% has been taken, which is correct.
So it is on that basis only amount is granted.
Correct.
1,98,720. Loss of future amenities.
25,000 has been awarded.
Another 5,000 or 10,000?
10,000.
So 10,000 there and 34 plus 46 means another 13,000 here. Attendant, how many days he was in hospital?
25 days.
Future medical bills. So how much you offered?
We had offered 31,000 millards.
7,000 is in. It is submitted that the insurance company is ready to pay an amount of rupees 35,000 over and above the amount that is granted by the tribunal for filing a joint memo before the Lok Adalat on so and so.
24.
Yes, next.
6. Pradeep B. For
Madam, I will
appellant.
take steps, madam. Liability is under challenge.
For taking steps, a week's time is granted, or else the appeal so and so shall stand disposed against so and so.
Cell number
Next.
7.
Milord, actually 30 rupees DCF with 3 sets of this paper given on 21/6/2024, but it is not tagged, it seems. Office may be directed to verify, Milord.
Post certification. Yes,
Cell number 8. Cell number 8. BC
Shivanagoda.
Please, madam. Negligence and the liability. It may be.
After vacation and 8 in 8 steps, the needful shall be done within a week. Same default order. Next 9.
Number 9.
And the next.
E. Lakshmi Rao.
What about this?
Exoneration. We are not liable.
You're not liable after vacation.
EMTC.
Same in for this also. Process needful shall be done within a week. Default order. 10.
Cell number 10. Memo for dispensation of notice to R5.
Memo for in 9 memo for dispensation of notice to R5. Same in respect of R1 to R4. Yes, next.
Cell number 10. Exonerate. Jagdish.
You are not liable after vacation. 11.
Cell number 11.
11, liability was passed on the owner of the vehicle on the ground that invalid driving license. Pay and recovery can be passed.
And about enhancement is there?
They filed announcement also, but claimant appeal for enhancement also.
After vacation. 12.
Cell number 12.
Is Pradeep?
Yeah, Dudu.
R1 is the claimant, my lord. It has not served to R1. R1 is a claimant, my lord. Notice has to go.
Yes. Same process within 1 week.
Cell number 13.
Yes.
Negligence is challenged, millards. I'll take steps.
Same R4 and R5.
Cell number
For
14.
all this for paying the process for doing the needful a week's time. 14.
14 liability and the talent, my lords. No relationship between the injury and employer and employer, my lords.
R2. R2 process week's time.
Sripadri Shastri.
My lord, 3 sets of copies I have to, I will furnish, my lord. I will
After
furnish.
vacation, next 16.
Cell number 16.
What about this? Liability on MFA 4171.
Please, madam. 4171 of 23. Recently I have received the copies, my lord. Appeal memo only they have served.
Day after tomorrow.
Please.
Yes, 17.
17.
17, I'm for the appellant in this case, filing dispensation memo for respondent number 1, who is the owner of the vehicle.
It's same.
Liability is fastened on the,
Them. So and so. Seeking enhancement.
yes,
Take the file.
Reliance General Insurance Company, take notice may be ordered.
Now you'll be ready. Look at the file, Mr. Pradeep.
May I submit? I am not ready, it may be.
No, there is nothing to be ready. Look at it. We will all look into it and decide.
Please.
Yes, how many are the injuries?
One minute. Appeal memo that the Extina Hospital.
Court had granted 20,000.
Yes. 3,30,000, 6 days he was in hospital.
No.
The case.
What are the injuries I'm asking?
Tibia
Fracture, tibia fracture.
Tibia and fibula fracture.
2 fractures.
Yes, yes.
2 fractures, 60,000. Medical expenses as it is.
Police.
12,682. Future medical expenses, what is the evidence of the doctor?
Doctor.
That is what the doctor said.
Yes,
40,000.
40,000 has been awarded.
40,000 is awarded. Then how many days was in hospital?
6 days he was in.
Huh?
6 days, madam.
Then reasonable amount, 15,000, no enhancement required.
Yes, his injuries are severe in nature.
Then what is the disability according to the doctor? Come to that paragraph.
%. Para 21.
For the doctor?
Para 21 minute.
Para
PW2 according to the petitioner having
in respect of fracture of lower tibia and
10%.
Injuries on use of so and so, petitioners have disability which is in respect of fracture of segmental fracture of fibula in the left leg. Disability has to be taken as whole body disability.
Yes,
As
yes.
per the evidence. So which year is the accident?
2019.
19 million.
We'll take 14,000 then.
Yes.
So 14,000 into 12, what is the multiplier?
17.
17 into 10. It comes to
85,600.
85,600.
Yes.
Then loss of amenities. Quoted granted 15,000.
Yes.
We'll grant another 15,000. 30,000. Next, loss of income
50,000.
during laid up period. Why it is for 6 days it is calculated.
6 days 2,200. That's all.
Income during laid up period. What we'll do is this 14,000 into 3.
42,000.
40.
2,000.
Any future operation?
Not 40,000 awarded. Madam.
Granted. So we'll calculate.
Medical. ಇದು 2,85,000. 60 ಇದೆ 60 ಇದೆ ಇಲ್ಲಿ ನಾನು 20 ಕೊಟ್ಟರು ಏನೇನು ಸರ್
It's coming to 4,85,282 against 3,30,000. Joint memo. Today itself you can file.
Reliance General Insurance.
Huh?
I will ask that Reliance General Insurance
Oh,
Company.
this is not.
Shriram.
Then why they have listed? They said only this Shriram General Insurance.
No, this is Reliance, madam.
Then we will have it day after tomorrow. Mr. So Pradeep is directed to take notice on, your name is already there? No.
No,
Sir,
not
Pradeep is directed to take notice on behalf of the insurance company. Yes, day after tomorrow. R1 dispensed with.
Yeah.
Noted. Take. Yes, next. 18.
Please.
Unknown.
Malad, in this
Yes,
case,
18.
Serial number 18.
injured was an advocate and agriculturist. He was aged about 54 years at that point of time. He was admitted in the hospital for 3 days. Fracture of ulna and radius. Dislocation of ulna and fracture of radius. 39% disability was assessed to the limb. 13% limb disability, whole body disability was assessed. But court has not granted the compensation under the loss of future earning since he was continuing in the profession. And all the 8 Malad did request pain and suffering
So,
20.
Pain and suffering, one fracture,
One fracture, one dislocation fracture. 2.
60. Then medical expenses as
Correct.
it is.
Later period 50.
1 minute. Then which year is the accident?
21.
21 Malad.
21.
14,000.
It is 15,000.
Please.
Loss of income during later period.
Another 2 months.
15 into
3.
15 into 4,
3. Ulnar fracture.
45,000. Then,
Amenity 10,000 is granted.
no, loss of amenities. How much is the disability?
13% of the whole body.
So 30,000.
Please.
Then loss of
Attendant conveyance 3,000 is
loss of
granted,
future earning,
was not granted.
15,000 into 12. What is the multiplier?
54 years Malad 900.
50?
4 years.
54 years means it's 13?
11.
11. Into 11 into 10.
Please. Malad 13%. 39% of the limb.
What are you saying?
Disability 13% is assessed by the doctor.
Oh, not 10%.
That's what.
13.
Our contention is continuing the service.
Then it comes to 2,57,400.
1 lakh rupees.
So loss of amenities, all covered. Any future operation?
No Malad. No,
It is
no
there?
evidence to that effect.
But
Ulna fracture.
so pain and
Paid,
suffering,
yes.
medical expenses, loss of earning, loss of amenities, loss of future earning.
All it covered.
It comes to 4,96,526. How much is awarded?
1,57,126.
The then council appearing with insurance company submits that they're ready to pay an amount of rupees 4,96,526 against the awarded amount of rupees 1,57,126. This is matter on 24th for joint memo.
No permit.
A memo is for seeking dispensation of part 2. Memo is taken on record. Notice to R2 is dispensed with. Mr. B.C. Sivanagowda takes notice, is directed to take notice on behalf of the insurance company. Yes, 19.
Serial number 19.
Please.
This is also enhancement.
No, Malad.
Exonerated
Liability question,
matter.
Malad. Liability question, Malad. At least 1 week time may be granted, Malad. I will take steps.
Yes. A week's time. for taking steps, default order 20.
Cell number 20,
Let,
What about this?
VC Shivan.
invalid DL and permit pay and recovery.
Pay and recover.
Interest.
But oral served,
Please,
owner has to be served. For
R4.
steps, 1 week.
R4.
Yes, next 21.
Cell number 21, Guru Prasad BR.
The claimant's appeal for enhancement case of death, but there is no scope, so my lords, on merit, it may be dismissed.
Dismiss?
On merits, my lords, sir.
Yes, give that.
What has been awarded is on the just,
The, which is MBC,
my lords, 1882.
agreed with the order passed in MBC number 1880, agreed with award passed in MBC number 1882 of 2016, dated 19 July 2022. The claimants are before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation for the death of the deceased in the accident. The tribunal had granted how much?
My lords, 14,21,950.
14 lakhs 21,950. Land counsel appearing for the appellant submits that the tribunal had failed to grant the compensation, the reasonable compensation. It is submitted that the income was taken at
9,500, my lords. Accident is of the year
500
16.
and the accident had taken place
2016.
and the accident has taken place in 2016. Even at the conventional heads also, the amount needs to be enhanced. Land counsel appearing for the respondent insurance company.
Please.
Docket order, Mr. Shivanagowda is directed to take notice and shall file wakalat within 1 week from today. Land counsel appearing for the respondent insurance company submits that the tribunal had rightly considered and granted the compensation. Having heard the counsels on either side, there was a material on record. The tribunal had taken out that 9,500 as an income as accident is of the year 2016 and no enhancement can be granted in that, and even on all the other heads also the compensation that is awarded is just and reasonable, and in the considered opinion of this court no interference is called for. Accordingly, the appeal is dismissed.
Please.
Next.
Cell number 22,
I'm appealing for the appellate.
22, Siddhappa BM.
Yes, Pradeep. Enhancement.
Yes, my lord. The notice has to serve for the owner, my lords.
It's okay, don't have to think about all that. Yes.
My lord, actually, my lord, for the lower court itself, it has been compromised. After that, my lord, they have prepared an appeal.
What is
The
that
execution
for?
petition.
Against to compromise what appeal?
Please, my lord. And 25/1/2023, it has been compromised. It has settled for 10 lakh, my lord. DHR has agreed.
Take instruction from senior.
Tomorrow find out because there can't be, you can't maintain an appeal against the compromise award. Yes, next. Tomorrow. Next.
Cell number 23,
Yes.
cell number 23, Vijay Kumar T.
Yes, Mr. Pradeep.
P. Pradeep.
Appeal for fifth respondent. There is no liability against Acco General Insurance. The Sriram.
ಶ್ರೀರಾಮ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಕ್ಲೋಸ್ ಮ್ಯಾಟರ್
Yes.
ನೋಡ್ಕೊಳ್ಳೋಣ ನೀನು ಹಾಕ್ಬೋದಾ ಕೇಳ್ಬೋದು ಕ್ವಾಂಟಮ್ ಯಾರು ಅಡ್ವೊಕೇಟ್
Come to that table, which is MBC.
1555
MBC, my lord, 1555. 1555 of 2020.
It's a case of
Death, my lord.
injury or death.
ಕೇಸ್ ಆಫ್
ಇದಲ್ಲ 1555 ಈ ಕಡೆ 1555 ಫಸ್ಟ್ ಒನ್ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಇಟ್ಸ್ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಮೇಲೆ
27 ಎಲ್ಲಿದೆ 15 ಪ್ಲೀಸ್ ಯಾರು ಇದ್ದಾರೆ ಮೇಜರ್
Income is taken 14,000. Which year is this?
2019 correct 19
rightly consider
14,000 rightly taken.
rightly taken
40% future perspectives
Also granted. What else they want?
no malad mostly under the convention
Conventional heads.
there are
So,
three
No, 14,000. 40% would come to 5,600. That is 19,600.
The calculation is correct, my lord.
Calculation.
Next table, my lord, para 20 may continue.
Para 20.
Para 20.
Uh,
Para 20.
so
Loss of
input
dependency,
12. What is
19
the
lakhs.
multiplier?
Multiplier 17 rightly
17.
considered, my lord.
Multiplier is 17.
17, that is also
Everything
rightly
is
considered.
19 lakh,
There is no scope in
99,200.
the loss of dependency, my lord. Only
Under the
conventional rates,
conventional.
19 lakh,
19 lakhs, 99,200.
200. How many are the dependents?
Dependents, my lord, 4, my lord.
4.
4.
4 into 40. I think this 44 needs to go to 46, I think. Isn't it?
Please, my lord.
Every at the 10% enhancement, this 44 we were calculating from 2023 or 4.
19.
Huh?
This is 2019.
Actually, my lord,
Not about that.
Earlier.
Correct. So this 44, 36, I was calculating from 2023 earlier when I was in this roster.
But it was, see
Every
what
1
has
year?
happened, Matt.
1 year
There
or
is a
3 years?
delay and all the aspect, my lord, that we have not taken into consideration while considering this aspect. Otherwise, my lord, normally appeal will be filed by the claimant. There will be a delay. So compensating all we are.
No, you didn't get the point. I'm saying under the conventional heads, I'm granting 44 and 36. Now I think it should be 48 and 38.
That has to be
46
increased.
and 38. It is in other calculation, not for
Correct.
the Lok Adalat. So 4 into 40, if it is Lok Adalat,
please.
1,60,000.
As against
36,000.
70,000. As against 70,000.
That's the difference.
90,000 would be. Huh? Dispensation.
Sisters, bachelor.
Look at the grounds or any other things they have raised. 21 lakhs 95,200.
21 lakh 87,861 is granted.
21 lakhs? Then what is the
87,000.
difference? No difference at all.
That's what, my
They
lord,
raised,
40.
they raised only one ground, my lord, conventional rate, para 5.
What is the ground?
But my lord, 44,000 has to be granted.
There is a medical expenses which we have
Medical
not.
expenses 1,18,661 granted, my lord.
That we have to, your lordship has
Next
to
page,
add.
next page it is there.
That has to be added.
Please.
1,18,000. Then now the difference will come.
Another ground, my lord, income has to be taken more.
No evidence. Notice or some other company.
It comes to now 23 lakhs 13,861. The land council appearing for the
Another ground, my lord, sixth ground is their predate is, my lord, 1/3 has to be deducted instead of 50%. Death of a bachelor.
And then how can we deduct 1/3?
Mother, brother and sisters are
Brother,
there.
sister, they are.
The second ground is that, my lord.
No, it is, there are 5 people. You said 4.
4 only, my lord.
No, 5.
No, my lord. Mother,
Oh, there are 2
mother,
LBCs.
brother and sister.
Only 4, my lord.
1,555 of 20.
1,555
of 2020. First case. my lord.
First matter.
First page it is there.
When council appearing for the insurance companies, obviously they're ready to pay an amount of rupees, that's 13,861 against the granted compensation by the tribunal. And in this regard, they'll file a joint memo. Both the councils appearing for the insurance companies.
And fifth respondent.
That's why he's there for filing joint
Second
memo.
respondent.
24.
Second respondent.
Next.
Cell number 24. P.C. Shivanegowda.
7 ಅಲ್ಲ
24.
MFM madam 7742.
Oh.
Please.
7742.
Notice has to go.
Nobody has said it. Is it delayed?
Quantum and negligence.
30
You're
days.
on, but the claimant has to be served
That's
for for taking steps, time, default order. Next 25.
Cell number 25.
The liability is against owner of the vehicle.
Five.
Same for
Steps one.
Serial number 32.
steps 2,
R1.
R1, a week's time. Yes, next.
Cell number 26.
26 liability. Will take steps to.
Yes, for steps,
One.
a week's time. 27.
27.
Applied.
The company of
It can be.
Jagdish.
Complete time. 1 minute. Idea. Complied. Case injury.
What are the injuries?
ಇದೆಯಲ್ಲ ಕೇಸ್ ನಂಬರ್ ಇದು MBC ನಂಬರ್ ಏನು ಮೇಡಮ್ ಅದಕ್ಕೆ
Which is the MBC number?
But that is the problem. We have lost our cause list now.
Card list.
Give them one cause list. 2543.
2543. That is
MBC number.
Ashwini Kripa. Please. Date of accident melad 19.
2543. Where is the table?
Huh?
Global compensation of
2543 so and so. In both the case. 15% only. No matter 2443, there is a disability assessed by the doctor.
what is that? 3 is rounded off and court has written 9. Is it 9 lakhs that is granted?
That I will look. Lengthy journey.
9 lakhs was awarded.
Please.
The claimant has claimed 51 lakhs.
They have claimed more. 15% disability was assessed by the doctor.
1 minute. We'll go to that.
Fracture of right distal femur, right leg, both bones of open fracture of compound fracture and lacerated.
So the pain and suffering, how much is awarded?
Table I
No calculation by the court.
That's a problem.
Huh?
No, there is no 5,96,000 is there.
That calculation which you are seeing is in respect of other matter.
Other case is there. For this case is concerned.
So now
table
we
is
will
not
we will do the calculation. Pain and suffering, how much? How many? What are the? How many injuries?
Blood injuries are global. Oh, earlier 3 lakh, it was altered to 9 lakh. Judgment. Medical records, Astra, so and so. Medical record.
Fracture right distal femur.
Distal.
Fracture right leg with bone open.
Distal femur.
Lacerated. So two injuries. Two
Please.
fractures.
Fracture of the distal.
60,000.
Both bones are open. Please.
Permanent physical disability to the lower limb at 63% and whole body 21%.
Quota second 15%.
Why should they take 15%? We should take 21%. What is the income?
He was working in a private company and earning 50,000.
Any evidence?
No evidence was adduced. It's a loss of income, so and so. What has not granted?
As for that was worked even from the accident has occurred in the month of. So
Well, there is no
there is accident
2019.
2019.
19.
14,000.
Medical bills 50.
14,000 into 12. What is the multiplier?
He was aged above.
What kind of an award this?
Malad, everything
Put us-
is altered. Malad, 6 lakh 50,000 189 is the medical bills. according to this correction judgment. Nothing has been stated in that judgment. Para 17 may kindly be seen.
No, no, before that, what is the multiplier?
Age is per-
8:7.
But the age was not referred in any of the ID officers so and so.
I think for that, the council shall be there.
Please, Mel.
This is matter after vacation.
Cell number 28, MV Maheshwarappa.
This case, number 28 and 30, the connected matter, my lord.
28 and 50.
30, 30.
Hmm.
My lord, the Bajaj Alliance also prepared an appeal. 3057 of 23, 3060 of 23, and 3050 of 23. And claimants, one more appeal is also pending. 440 of 2024.
Give all the list post after vacation with all this.
Please.
Take the numbers from
28.
them.
28 and 30 serial number.
Cell number 29. 29. Yogesha GK.
Which is
Liability aspect. No problem.
after vacation.
Cell number 31.
Excellent.
Cell number 31. BC Shivanegowda.
Unauthorized passenger in a goods vehicle.
After vacation.
Cell number 32. 32.
This is
Shatraj
connected with
K.
serial number 34, my lord. 7742.
32. 32, sir.
Howdu.
24 connected. 751.
32 and 34 after vacation. Yes.
32. 32 may be call along with 7742 of 23.
Give that number.
774.
7742 of
23.
Yes, 33
33.
33 owners appeal. Owners appeal.
after vacation. 30, non-depositing of 50% of the award amount.
I'll verify from the party. My lord.
Yes, 35.
Well, and see number 35, my lord, the insurance company, Pradeep prepared an appeal. So R1, Pradeep may be directed to take notice to R1 and notice to
R1 dispensed with. Mr. Pradeep is directed to take notice on behalf of the insurance company, post along with the insurance company's appeal.
7338 var 23.
That in 35, in the name of Mr. P. Pradeep, yes, 36.
36.
34 has not called.
34?
34 has not called.
34.
34.
You said it is connected with 32.
No, my lord, 30, serial number 30.
Oh.
I said 28 and the 30 is the connected.
You are ready with this?
34, 34 only enhancement.
Yes, 34, call 34.
34 put, yeah. 34.
Yes.
34, my lord. It's a case of injury, my lord. The date of accident is, my lord, 19/10/2018.
What are the injuries?
Injuries, my lord, para 18, my lord. The doctor has assessed 20% physical disability with respect to the vision and 17% to the right lower limb, my lord, 17%. 31% MSCT has considered.
To the whole body.
Whole body, and 12,500 income has rightly taken.
Pain and suffering, another 20.
Pain and suffering, 80,000 awarded.
That's what I'm saying, another 20.
Please. The head period also granted me.
How many months it is granted?
He was 33 days, my lord, inpatient.
No, no, loss of income during laid up period.
76,261 has awarded.
For how many months?
My lord,
Must be for 5 months.
12,500 notional income, my lord.
Yes.
Internal page 10, my lord.
And this attendant charges, how much it is?
33 days, my lord.
84,000 plus 5.
84,600 has granted.
600 plus 5,100 is there. Special diet and nourishment.
Special diet, nourishment, and all, my lord, conveyance charges including attendance charges, 84,600 has been granted.
So conveyance charges is there another 23,100.
That separately made, my lord.
Uh,
The total,
So-
my lord, 84,600. Again, conveyance charges 23,100. Future medical expenses 60,000.
5,100 is the next.
Special diet, nourishment,
Future medical expenses.
60,000.
Then what about loss of future income?
Loss of future or income, my lord, 5,11,500.
Where do you get?
Item number 6, my lord.
Uh-huh. 5,11,500.
500.
Amenities?
Amenities not awarded, my lord.
50,000. So 50,000 towards amenities. Then where the extra amount is coming? Pain and suffering.
20,000.
20,000 is coming. And so what we can find is 70,000.
70,000. Was aged about 55 years.
We'll say that 70 or 1 lakh.
70,000.
70,000. It is submitted that the insurance company is ready to pay an amount of rupees 70,000 to above to the amount that is over and above the amount that is granted by the tribunal. A joint memo thereafter. Yes, next.
35 was insurance company appeal.
Huh?
5 was connected. Serial number 36. 35 idea.
Appellant, my lord.
In that matter.
Number
The
36.
The case of injury, my lord.
Dev Swami P.
The appellant is sustained compound grade 2 fourth one.
In which case?
36, my lord.
Pay and recover order has to be passed.
As passed already, my lord.
Trial court is already passed a pay and recovery.
And 75% liability has been fixed against the
The
company.
contributory negligence fix on the
The notice has to go. Pay and recovery is there. Notice has to go to the owner of the vehicle
Yes, ma'am.
for taking steps a week's time. Next 38.
Serial number 38. 36, 37. Pradeep Ki.
37
Our appeal, my lord.
on quantum.
Maintainability, my lordship. Impedition.
Justification. Same for steps.
38.
Week's time. 38.
It's a case of injury.
38.
Please.
Memo is filed seeking dispensation of notice to R2 dispense where Mrs. Venugoda is directed to take notice on behalf of the respondent insurance company. Yes.
It's injury case, my lord. He has admitted 1 month in the hospital.
Where is the table?
Table, my lord. La. Tara. Issue number.
How many are the injuries?
3, my lord. 2. 30 days.
How many days was in hospital?
1 month, man.
Court has granted 30,000.
Please.
Then income was considered.
15,000 they say them. Not like 15,000.
Which you said. which year?
31, 35 years, my lord. Age
No, which year is the accident?
21, my lord.
So 15,000. So 15,000 into 3, 45,000.
30% of
Medical bills as it is
loss of earning capacity.
49,000. Loss of income 45,000.
40,000 it is granted, 45,000.
Then loss of future earning.
Please.
What according to the doctor, how much is the disability
30% disability.
to the whole body? In that case, we are taking 15,000.
They have taken already.
Court also taken 15,000. Then what's the difference now?
No. Future perspective.
Huh?
Future perspective.
You said disability is
30%.
30%. So what is his age?
Age is my lord 16 multiplied 35 years.
40% future prospect. Huh? It comes to 6,000. That is 21,000. 21,000 into 12 into
16.
multiplied 16
Please.
into 30. It comes to 12 lakhs 9,600.
9,600.
Any
Amenity.
future
That amenity is not granted.
loss of amenities. 50,000. Future operation is not there.
No, they have not granted, my lord. No evidence. But considering this injury, my lord,
Another 40,000.
40,000, please.
It's coming to 14 lakhs 83,98 against the amount granted is 10 lakh 23,898. Then council applying to the insurance company surveys that they are ready to pay an amount of rupees 14 lakh 83,698 against granted against a compensation of an amount of rupees 10 lakh 23,898. 24th.
30. Please. Namdala.
It is not, it is delete, it's not. Pradeep, 34, what happened? 1 minute. $34 we have calculated. Huh? IN number 1024 is filed to condone the delay of 68 days. Delay condoned. Memo is filed seeking dispensation of notice to R1. Dispense with at the risk of appellant. Yes, next.
Sir, number 39. 39, Shankar Prasad, PMP.
What about this?
Tata AG.
Tata General Insurance.
Tata AG General Insurance. Who appears? You appear for that too? Let's see. You don't have the file? We'll have it day after tomorrow. Day after tomorrow, Mr. B. Pradeep is directed to take notice on behalf of the insurance company.
Sir, number 40.
40, 42 and 40.
Directed to print the name. Yes, 40?
40, 42 and 43, my lord.
40?
All three connected matters.
40?
42 and 43.
Uh,
Take steps to Asavan and
First steps a week's time. Next 41.
41. Sir, number 41.
Huh? Yes, you will pay the process. Which is the insurance company?
41.
1 minute.
Company.
Look at it.
Company. Which is the company? Appeal.
It's Shriram General Insurance.
Please.
Look at it.
41. R2.
Give the file.
Complied, man.
Hmm?
Complied.
Enhancement.
Please. Injury.
Come to the table.
Previous injury, treatment, so and so. Table malad, injury, what is the nature of injury? It is not mentioned.
It is there at page 17.
No, table is there, Mala, but injury is not mentioned.
Let's see from the.
Please, 16.4% to lower limb. Doctor evidence is there, Mala.
Has
Pain and
sustained
suffering
one
is granted.
grievous injury.
Please.
Court had granted 50,000, that is
Correct.
fine.
Conveyance attendant charges is
Yes, he was in
concerned.
hospital.
13.5 to 23.5. That means 10 days. Para 12 of the judgment.
30,000 is granted reasonable. Then
Correct.
income is considered.
Suffered so and so. Income malada removal of implant. No amount. No.
This accident.
It
which
is not
was-
granted, Malad.
What is not granted?
He was working as a not producer. So no,
No, court has granted 29,500.
during later period.
This accident is of 2022.
22.
15,500.
15.
So
40.
15,500 into 3.
Please.
It comes to 46,500.
Please.
Then what about future loss of income?
That's what, Malad.
You said disability is there.
There is a disability,
Let's
but
read that,
avocation is not mentioned.
No, no,
Loader.
please come to the.
No, para 50.
Read.
No. Loader. 36 years, loader, earning 35,000, not produced for.
We have taken the notional income 14,750.
So
We are taking
15,000 has to be taken.
15,500.
Correct. Low 16.4% to the whole body limb disability means it is para 18 of the judgment.
Permanent disability of 16.4%.
Lower limb.
Lower limb has not examined the who issued the disability certificate.
Even assume 16, but
It would be 5%.
5%.
So 15,500 into 12, what's the multiplier? What is his age?
Disability, Malad, what has happened? Disability certificate was produced.
Doctor was not examined.
Doctor was not examined. So instead of granting compensation on that
loss
type,
of amenities.
amenities we can grant some. 50,000, that is the reason 50,000 is granted.
Medical
75.
expenses, 1,20,000, 1,20,860. Loss of amenities, 50,000 is granted. We'll grant another 30,000.
Please.
Or another 50,000. Because we are not
50,000
granting future loss of income.
on 50,000 is already granted, therefore another 30,000.
Loss of income 80,000. So now where is the difference coming?
Malad,
Okay, it's only instead of 29,500, we are granted 46,500.
please. And this is 30,000. That is.
Difference is 17,000 there. Plus here another 30,000. So 47,000 is going to be the difference. Find out. We'll list this matter day after tomorrow. If it is, if your client is okay with it, you can file a joint memo. Insurance company, the counsel appearing with the insurance company submits that over and above the amount that is granted, they are ready to pay another 50,000.
Interest is there, but 60,000 lump sum. 60,000 lump sum.
Can't say interest. How can you? Will say 50,000 over and above the.
With interest.
With interest.
Please.
Mr. Soyans, Mr. Shivanagoda takes notice. Registry is directed to print his name, and there is a delay of 330 days in filing. Is condoned on condition. Yes, 42.
42, day after tomorrow. 42, 42, 43 urgent. Cell number 44. Cell number 44. B.C. Shivanagoda.
Non-involvement of vehicle minute.
After vacation.
Cell
for
number
steps-
45.
No, 1 minute. In 44, notice to R2 returned as refused amounts to deemed service of notice. And what about non-depositing of 50%?
Deposit will produce the account.
Yes, list after vacation. 45.
liability and owner, my lord, notice is necessary.
Notice to R2 for steps, a week's time default order.
Till number
46.
46.
Memo is filed seeking dispensation of notice to
Equal,
R1.
Equatokia general insurance, my lord.
Dispensed with Pradeep appears.
My lord, another connected matter is there, my lord. Kindly post the matter.
So
Along with
Pradeep takes notice
From
on behalf of the insurance company.
486.
List along with so and so day after tomorrow.
Macho.
Give him the papers.
Shoot him.
Give him the papers. Yes, next.
till number 47.
Yes, 47.
Please,
Chandra 47.
case for announcement. my lord.
Hmm. Yes,
Please.
there are two MBCs. Which MBC?
Chandra, Monica and
MBC 2737
2737.
of 2023.
27. Please. ma'am. First case.
Hmm. Yes. Come to the table at para 31.
Little bit confusion. 1 minute. The different case was opened.
Hmm?
MFA.
I think no. Your court officer has given a wrong bundle.
Ah,
It's a long.
MBC 3999.
Please, please. That is the case we have opened.
Ah. It's a case of death.
Please.
How much is the income
38
taken?
years.
Ages?
38 years. my
No,
lord.
income is taken as.
Income taken. my lord.
That's where they can have enhancement.
Deceased 16,601.
Which year is the accident?
This is my lord,
20 accident.
20 accident.
14,500.
He was drawing. my lord, he was drawing his salary. Exhibit P14 is the salary certificate for the month of May.
Please
20.
come to the discussion. We will see.
Please.
Para number 20.
Please, so for avocation of income, income of the deceased concern, as per the case of petitioner, deceased was working as a NCDS counselor at Samudaya Health Center, Government Hospital, Health and Wealth Department, Pancharalli, Kadur, Talak, so and so, earning salary of 26,500 per month. Additional to rupees 10,000, he was experienced technician. Totally, he was earning 36. Petitioner was produced salary certificate exhibit P14 and also examined 1 witness period, got marked the bank statement of deceased, so and so. Respondent has disputed the avocation income. Petition of morally ID card was produced. He was working as a student of the government on a contract basis. If their salary certificate of exhibit P month of so and so, drawing salary of 16,601.
Why 1,800 should be deducted? That is what they are, on that ground they must be here.
Please.
PF is deducted.
Correct, madam. No, every PF that has been
Added.
professional
So-
tax has to be deducted.
No, 16,601
601.
plus 1,800.
Please.
That is 16,000.
No. 17,000. 18,400. Plus 16,600.
18,401.
Please. Less 200 rupees, madam.
So 18,200.
18,200 less professional tax.
No, it is 18,400 less 200 is 18,200.
18,200 professional tax has to be deducted out of that. So 200 rupees has to be deducted.
That's what I'm saying.
Please.
18,200
Please.
after deduction only. Then future prospect set.
Which a prospect 40% has to be added, madam, because he is not a permanent employee.
No, he isn't a permanent employment.
No, he is a temporary employment, not
As per the
permanent.
petitioner, deceased is working as NCD counselor.
On contract basis. 1/4. This is 1/4 is deducted. So 10%. ಎಷ್ಟು ವರ್ಷ ಅವ್ರಿಗೆ? ತಗೊಂಡಿದ್ದಾರಲ್ಲ.
It
What has
comes
taken
to
40% future only.
25,480. It comes to 25,480.
Please.
Into 12 into
15.
no, how much has to be deducted? That deduction is not done.
1/4, madam.
How many are the
That's what your lordship kindly appreciate in para. Wife, 2 minor children and mother. Para 27 of the judgment is.
It comes to 19,110 into 12 into, you said 17.
15.
15. It comes to 34 lakhs, 39,800.
38.
Huh?
34 lakh, 38,000.
39,800. No?
Please, we will check it
Do
out.
it again. 19,110 into 12 into 15. 3 lakh
Please,
40
please.
3 lakh 43,000. I mean 34 lakhs 39,800.
Please. Conventional aid minute.
Then the conventional heads 4 into 4.
Only 44,000 is awarded. In another 3 persons.
1,60,000 will come. And 36,000.
No, they have given 44,000. So
44,000. How much is given?
44,000 for one person it is granted. So
No.
another 3% we need to give 44,000.
No. Now if it is going to file a joint memo,
Please,
it has to be, then we'll grant 40,000 only per 4 also.
please.
30,000. Comes to 36 lakhs 29,800. How much was awarded?
32 lakh 14,400.
32 lakhs 14,400. And council appearing for the insurance company service, they are ready to pay an amount of rupees 36 lakhs 29,800 against granted compensation of 32 lakh 14,400. Joint memo for filing joint memo list for the local Adalat day after tomorrow.
Cell number 48.
Anu.
Yes.
Oh my.
Liability. Yes. List after for steps. A week's time.
49.
Appear for the second respondent, Lord. There is no compliance of conditional order passed on 6/11/24. It's an appeal by the insurance company. Lord, kindly look into order sheet dated, my Lord, 6/11/24.
48.
After vacation 49. Next 50.
Cell number 50.
51 madam.
What about this?
Vijay Kumar T.
You have to take steps, my lord.
For steps a week's
Complaint.
time.
Cell number
Default
51.
order.
Complaint, madam.
51.
Complaint.
Yes. Come to the table.
Please.
Take this. Yes.
1 minute. Injury. 8,000 income is taken. La.
How many are the injuries sustained by the claimant?
Of pain and suffering, 40,000 is granted.
That's why we look at the injuries.
Injury is concerned.
Abrasion of the knee joint.
Abrasion.
Restricted movement of the right ankle. Fracture of tibia and fibula.
Tibia, fibula bones. Simple. One after.
Quoted granted 40. Will grant for another 10,000.
Please.
Then food. How many days he was in hospital?
2, 3, 5 days. Man.
Nourishment.
7 days. Man. 7 days.
10,000. Next. No, court has already granted 8 plus 4, 12. Yes, we'll confirm that only. Medical expenses, 81,574. Now coming to the loss of income during later period, how much is taken? What is his income?
This was, he has agreed to settle the matter for 90,000. He seeks for time to consult with their counterpart. Maybe refer to Lokadar.
Then counsel for the insurance company submits, so they are ready to pay an amount of rupees 90,000 over and above the compensation that is granted to the tribunal for filing joint memo. We'll say day after tomorrow.
Please.
Day after tomorrow.
They start for some time. 52.
Yes, Ms. Sivanagoda takes notice on behalf of the respondent insurance company. Next 52.
52 complied, my lord.
Yes. Pain and suffering 1 lakh is granted. The loss of amenities 50. Transportation 35. Treatment hospitalization 80.
Multiple bone fracture, my lord. Got exam in the doctor.
Then there is no future loss of income.
That's the reason court has granted total amount. But loss of earning during treatment period 30,000 is granted, my lord. Damage,
This
pain and
matter,
suffering.
day after tomorrow.
Please.
Mr. Sivanagoda takes notice on behalf of the second respondent insurance company. Next 53.
Serial number 2053.
Best time to
Check
test.
area.
Best time to text mail. Best time to text mail.
Take steps of the
No, liabilities on the insurance company.
Both KSRTC and insurance company.
Then we'll hear this matter. We'll
KSRT is not served mail. KSRTC.
counsel will be there. We'll ask him to take notice. KSRTC counsel was here.
This is grievously injured mail. Only 91,000 is awarded.
Compensation that we will calculate.
Okay. Because he is a driver.
And if
Please,
you don't
please.
want, we can't help it. This is matter after vacation.
Serial number
Steps for the
54.
first respondent. Yes.
Serial number 54.
Liability under
Avoid
challenge.
service of notice, post after service. Yes.
Serial number 55.
Also,
Serial number 56.
memo is filed in 55. Memo is filed second dispensation of notice to R2 and R4 dispense with. Yes, 56.
56. Ananda KS.
No liability. Liability was against.
Post after service of notice. Office objection shall be complied with within a week, or else appeal shall stand dismissed.
Serial number
57.
57. Kamala DK.
After vacation.
It's after vacation. 58.
Serial number 58.
Complied, man.
Sushmita G.
It's a case of amputation, my lord.
We'll calculate.
Yes, my lord.
We can open.
Yes.
The tribunal ought to have assessed permanent physical disability at loss of earning capacity of the appellant at higher than 38%, having accepted appellant's lower limb above knee was amputated due to the crush injury sustained in the accident in question. The tribunal failed to appreciate that the loss of earning capacity to the appellant due to amputation.
Calculation.
Where are the injuries?
Yes, please, my lord.
Calculation.
Where are the injuries mentioned?
Testified. Para 15 of the judgment, my lord.
15 of the judgment, my lord.
The knee amputation has been done with skin
Please.
grafting due to vascular injury.
Doctor has assessed the disability of 85% to the limb and 30% to the lower limb, whole body disability at 38%.
Court had taken how much?
38%, my lord.
Court. Whole body disability according to the doctor 38%. Court had taken how much?
2014.
38%, my lord.
Salary was taken how much?
15 accident. 38%.
Salary was taken
8,500 is
8,500.
taken.
Which year is the accident?
2014 accident.
2014
accident.
It should have been 8,500.
Correctly taken.
My, photos also have been produced, my lord. Exhibit P13 and P15, photos of the amputation that's been produced. Yes.
You examined the doctor. Doctor said 38% disability.
No, my lord. According to this one, my lord, the tribunal failed to appreciate that the loss of earning capacity to the appellant due to the amputation of left leg knee would be 100% as he was an agriculturist. It is further submitted that even in Employees Compensation Act,
If he's an agriculturist and then amputation
50%.
till the knee, then we have to take it 100%.
Yes,
No,
please,
my
my
lord,
lord.
50%.
And may I
Sir, the
submit, my
W-
lord?
What she said, my lord, it is under 50% only.
Then first schedule part 2, serial number 18 indicates 70% permanent loss of earning capacity. Hence, the tribunal ought to have assessed loss of earning capacity at much higher rate and ought to have awarded more compensation towards future loss of earnings, my lord. It's amputation case, my lord.
But
He can't be working as an
when their
agriculturist.
doctor have been examined, is there the 38%, my lord? Under the WC Act, if the below knee, it is 50% only. Considering that, my lord, your lordship can consider that 50% disability. Pain and suffering and other conventional
No,
compensation
salary
was read.
taken at what? 8,500.
Please,
So
correct
8,000,
me.
what is his age?
66 years.
Huh?
66 years.
No, my lord. He was 53 years old, my lord.
Then future
5
prospects.
multiplier ಹಾಕಿದ್ದಾರೆ
10% future prospects.
60 para 33 may kindly be seen, my lord. He was aged about 66 years. 5 multiplier was applied.
This madam.
Yes, my
65 years.
Pain and suffering, my lord, amount is
No future loss of income. I mean, no future prospects. So 8,500 into 12 into 5 is a
Please.
multiplier. 5 into 50.
But also other heads, my lord. 20%.
Wait, ma.
First, you want the court to
Yes,
calculate
please, my lord.
this
Sorry,
or
my
not?
2,55,000.
2,55,000.
Pain and suffering,
1 lakh you will
20,000.
grant pain
Please.
and suffering.
Amenity, medical expenses as it is.
1 lakh. Loss of future earning, it's there. Then reimburse medical expenses. 42,490.
Correct.
Food nourishment, how many days he was in hospital?
71 days, minister.
Huh?
71 days.
Attendant, 71,000. Loss
Amenity.
of amenities has to be increased. How much?
Another 50,000 maybe.
This also one we will grant.
Can.
Huh? It's a case
Can.
of amputation.
Yes, my lord.
It can.
Then future medical expenses 1 lakh.
When the amputation, where is the question of future?
Huh?
Future medical, but there is no appeal by us.
Medical expenses in the sense he needs to buy some
Artificial limb, my lord.
No evidence.
But court is granted. Your appeal is not there.
That's what.
The amputation case, it understood that he needs an artificial limb for his future life, my lord.
Please. Artificial
It's coming to
Yes, ma'am.
6,68,490. How much is grant?
447,290 was.
Hmm.
Interest enhanced amount 6.
6%.
My lord, disability, my lord, disability.
50%.
50%.
50% is taken.
Yes, okay.
8,500 into 12 into 5
Yes,
into 50 by 100 is 2,55,000.
100%.
1,93,090.
Because of he is a age person, my lord, compensation will not be in the.
Is agriculturalist for 100% disability would have taken, my lord.
It is submitted by the insurance company that they're ready to pay an amount of rupees 6,68,490 against the awarded amount of rupees 4,47,290. The enhanced amount shall carry 6%. For filing joint memo day after tomorrow.
Much obliged, my lord.
How much delay?
Please delay.
There is a delay of
250 days.
There's a delay of 250 days. Higher number 1/25 is condoned the delay of 250 days. Condoned on condition that they are not entitled for interest for the set period. Memo, anyway, for all this, it's not required. Anyway,
Wait up, sir. Same vehicle.
Is there?
Dispensation memo, Akama.
Not required. Mr. Sivanagowda takes notice on behalf of the
Dispensation.
respondent insurance company and he'll, yes. Yes,
Cell
next
number
59.
Much obliged, ma'am.
59 at 1,10,000 it is agreed. It is agreed.
Day after tomorrow.
Please.
This is matter day after tomorrow for filing joint memo before the Lok Adalat. It is stated that the insurance company is ready to pay
1,10,000 in addition to what has been.
1,10,000 in addition to what has been awarded by the tribe.
Cell number
60.
60.
60 my lord, it is not our company. Yeah, company.
For taking steps.
Which is that company?
Respondent, a week's time, default, after default order.
Right.
Is 61.
61.
Please, complain.
In this case, my lord, kindly trial court record are necessary, my lord.
Yes, memo is for seeking dispensation of notice to R1, dispense with. For respondent number 2, Mr. B.C. Sivanagowda is directed to take notice, admit post of final hearing. Registry is directed to call for the DCR. Next.
Cell number
62.
62.
Yes, Mr. Pradeep.
Pradeep B.
133 days delay is there, my lord. TCR is required in this case.
Delay IN number 1/23 is filed to condone the delay of 133 days. Condone, admit, call for the TCR. You want just
Medical bills is disputed, my lord, and the disability taken is on
day
higher
after
side.
tomorrow. Let's just matter day after tomorrow. Before
Otherwise,
the
when we
Lok Adalat.
discuss, my lord, day after tomorrow, I will submit.
If you discuss, if it is today,
Day after
keep this a day after tomorrow. 62.
Cell number
Day 63.
63.
What about 63?
63 is, my lord, 1 day delay in filing appeal, my lord. Claimants also prepared an appeal, 5366.
2 of 23 is filed to condone the delay of 1 day in filing. Condone. List along with, you have the number?
Please, my lord, 5366 of
Along
23.
with so admit post of final hearing, TCR. Yes, next.
Number
64.
64, my lord, liability.
This also all insurance companies appeal.
Please, my lord. Check
I
one's
number
case and
1 of 23 is filed for dispensation for the production of the certified copy of the judgment. The
Production
dispense with for the present IA3 1 day delay condoned. Next 64.1
.1, my lord, I will take steps, my lord.
steps a week's time.
Claimants
Next,
also prepared
65.
appeal, my lord. My lord, these two appeals, the claimants also prepared an appeal.
Preferred appeal, you have the numbers?
I have, my lord.
That it is submitted that the claimants have also preferred the appeal. List along with them. Yes, 65.
65 and 67, my lord. Challenging the liability, my lord. And 2 more appeals are pending, my lord.
IA number 65, IA number 1 of 23 is filed to condone the delay of 18 days, condone. Then 67,
67
11
also.
days, condone, admit post of final hearing this year. What about 66?
Serial number 66. Bala Kumar.
56 pertains to if court of
For enhancement, who appears?
served unrepresented.
Tokyo.
Served unrepresented.
Day after tomorrow. For respondent insurance company, Mr. Pradeep is directed to take notice.
First respondent, I'll seeking dispensation.
Already served.
Served.
The Mr. Pradeep is directed to take notice. List is smarter day after tomorrow.
Records are required, madam.
Huh?
Records are required because they will, injury to a private part.
Admit post for final.
Much.
TCR, IN number 1 of 23 is filed to condone the delay of 290 days on condition.
Till number 68.
68.
Yeah,
What
number
about this,
68.
Mr. Yonagoda?
Please.
My lord.
Liability against the KSRTC as well as the our insurance company.
50%. Negligence on both the vehicles, madam.
Only quantum.
Only quantum is there.
We can decide then.
Please.
Take that, 68.
The date of accident is 33/2018, my lord.
Where is the table?
He has sustained fracture of mandible
Table.
and tenderness over right
It's
side.
not here, madam.
Court representative.
Para number 16.
All these matters repeated tomorrow from 69 to the end of the list. Any other matters? Any list prepared?
No, madam.
Why it is passed over?
Side concept took a passover. He has appeared online. He has taken passover.
These list may be called on next on the Friday, madam.
Yes.
Because all these tomorrow there is some rumors.
No, not tomorrow. Friday you want.
Please.
All these remaining matters
There
on
is
Friday.
there is some rumors regarding Backett and all. That's the
Tomorrow.
reason.
So all these matters on Friday.
That's it.
Then any other list you
My
have
lords,
prepared?
here.
1 minute. Court is not raising, please wait. And no mentionings now. Yes.
Apart from this, madam, nobody has come forward to settle the matter.
No. Your list, is there any?
We have given the list to.
You also gave. What about Mr. Ravi Sampati? He has given it.
Ravi Sampati, sir.
You have given your list.
Your
We have
list
given
you
the
have
list.
given? No, that's what. You have to give it to Mr. Raghu so that they will list it. Yes. All these matters, they have to on Friday. Remaining matters. They also after vacation.
My lord, serial number 1 in list 2, my lord, it is the appeal of 2014.
ಇಲ್ಲಿಂದ ಆ ಕಡೆ ಉಳ್ಕೊಂಡು.
We'll see after vacation.
68 ಇಂದ. 68 ಇಂದ attachment 69 ಇಂದ ಕರೀತಾರೆ.
Not able to understand what
69
you're
to
saying.
80. 69 to 80. Number 69 to 80. My lords, one submission.
No submissions in the evening for any post.
In 3 o'clock, there was attachment to my property.
So that we can't help it. Whenever the attachment, you cannot come to the court.
It's movable, so.
No, nothing. Okay, I'll come back. 10 minutes.
Three three nine eight.
Okay. ಆಮೇಲೆ 3204 ಆಮೇಲೆ
ನಾನೇ ಮಾಡ್ತೇವೆ.
ಮೇಡಮ್ ಅಕೌಂಟ್ಸ್ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡ್ಬೇಕು ಎದ್ದ ತಕ್ಷಣ ಫೋನ್ ಮಾಡಿ
20% ತಗೊಂಡು.
ESಗೆ ರಿಜಿಸ್ಟ್ರಿ ಆಯ್ತು.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ.
ಈ ಸ್ಟೆಪ್ ತಗೋಬೇಕು. One after vacation.
Oh, you are here.
ಅಷ್ಟೇನಾ?
ಲೋಕದಲ್ಲ.
ಅಲ್ಲಿಗೆ 70ರಲ್ಲಿ ಇವೆಲ್ಲ ಓದಲ್ವಾ? ಇಲ್ಲಿಂದ ಅಷ್ಟೇ ತಾನೇ? ಇಷ್ಟೇ ಇವೆಲ್ಲ
ಪ್ರದೀಪ್ ಸರ್ along with number ಕೊಟ್ಟಿಲ್ಲ. serial number.
ಇದೆ ಕೊಡ್ತೀನಿ.
ಎಷ್ಟೊಂದೆಲ್ಲ ಕೊಟ್ಟರು. ಒಂದು ಕೊಟ್ಟಿಲ್ಲ. ಒಂದು ಕೊಟ್ಟಿಲ್ಲ. ಎಲ್ಲ ಪಿನ್ ಮಾಡಿ. serial number 64.
ಎಲ್ಲಿಗೆ?
ನಾಳೆ ನಾವು ಇಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ಕಡೆ ಈ ಕಡೆ ಬರೋ ಹಾಗೆ
ಇಲ್ಲಿ ಇಟ್ಬಿಡೋಣ. BN ನಾಗರಾಜ್ ಕೊಡು. ಯಾವ್ದು ಯಾವ ಕಂಪ್ನಿ ಇದು?
ಇದು
ಫೈಲ್ ತಂಬ ನೋಡೋಣ ಇಲ್ಲೇ. ಓ ಇಲ್ಲಪ್ಪ ನಾವು ಬರ್ತಿಲ್ಲ. ಇದು ಯಾವ ಕಂಪ್ನಿ ಅಂತ ಗೊತ್ತಾದ್ರೆ ಹೇಳ್ತೀನಿ ನಾನು. ಮೂರ್ತಿ ಡಿ ಎಲ್ಲೋ ಮೇಡಮ್? ಹೌದು ನಮ್ದೇ. ಅಲ್ಲಿದೆ
ಮಾಡಿರಾ?
ಮೇಡಮ್ ಅದು
ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಸರ್ ನಿಮ್ದು authorization
ಲಿಸ್ಟ್ 3 ನಾ? ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲ ತಗೊಂಡು 11 ನಾಳೆ ಬರುತ್ತೆ. ನಾಳೆ ನಾಳೆ ಬರುತ್ತೆ. ಏನೇನಾಗಿದೆ ನಮ್ಗೆ 120 ಮಾಡ್ರು 150 ಮಾಡ್ರು ಎಲ್ಲ ನೆನ್ಪಿಟ್ಕೊಳಕ್ ಆಗಲ್ಲ. ಅದನ್ನ ಅವ್ರು ಕೊಟ್ಟು ಕಳ್ಸ್ಬಿಡೋದು. ಡೇಟ್ ಎಲ್ಲ ನಾನು ರಿಪೀಟೆಡ್ ಕೊಡಕ್ಕೆ
ಕೊಟ್ಬಿಡ್ತಾ ಬರೀತಾವ್ ಸದಾನೇ ಬರೀತಾವ್. ನಾವು ವಾಶ್ರೂಮ್ಗೆ ಎಲ್ಲ ಹೋಗ್ತಾರೆ 5:15 ತಾನೆ.
ಅಷ್ಟೇ ಹೋಗಿ ನಂಗೆ ಅವರು